The top law enforcement officer in the state of Texas impeached.
Republicans and Democrats in the Texas House of Representatives overwhelmingly adopting 20 articles for misconduct.
It's 10 times worse than it's been public.
Ken Paxton maintaining his innocence, calling it all politics.
And they are showcasing their absolute contempt for the electoral process.
Now all eyes are on the Texas Senate for the first impeachment trial of a Texas Attorney General.
Everyone will do their job to the utmost in fairness.
KVUE special coverage of the impeachment trial of Texas Attorney General Ken Paxton starts now.
And good afternoon. Hope you enjoyed your lunch break. I am Tony Plohetski.
And I'm Ashley Goudeau. We are back for this second session of day 6 of the impeachment trial of Texas suspended Texas Attorney General Ken Paxton. And before the lunch break, we've heard from only one witness so far from the prosecution. So a real departure from yesterday, where the pace was moving much more quickly, where we had 4 witnesses in one day. Today, solely focused on the testimony of Brandon Kamek.
And Brandon Kamek, he is the person who was hired by the Texas Attorney General's office to investigate claims made by Nate Paul, hired, according to his own testimony, at the behest of Ken Paxton himself. Ashley, he talked about regular and ongoing communication that he was having with Ken Paxton, who he says was directing and affirming his work every step of the way.
Hired not only at the behest of Ken Paxton, but at the request and suggestion of Michael Wynn, he testified, which is Nate Paul's personal attorney.
That's right. All of this, the foundation for all of these allegations is that Ken Paxton was allegedly taking multiple steps to aid Nate Paul in an ongoing federal investigation into Paul that, as we know, over the summer resulted in a federal indictment against him. We've been talking all morning about the irregularities of the complainant, the attorney for a complainant, meaning Michael Wynn, working so closely with a special prosecutor, going so far as to actually travel with him to deliver subpoenas.
And after submitting a list of names of who those subpoenas should be issued to, and we had a local Austin attorney joining us during the morning session who talked about just how unusual this is. You're now taking a live look at the Senate floor, where you can see there are some senators who are back on the floor. Directly at the bottom of your screen, you've seen State Senator Roland Gutierrez talking to State Senator Royce West, and then standing up a little further behind them, you see Senator Cesar Blanco, Senator Charles Schwartner. They're all standing around talking as we're waiting for things to get started. And I would think that part of the reason for this delay, though Rusty Hardin does look like he's ready to go.
Yeah, he does, standing at the podium, yes.
There was question about what evidence would and would not be submitted, or what evidence the prosecution wanted to submit that the defense objected to regarding text messages and correspondence between Brandon Kamek and Ken Paxton.
And that tied up a lot of time this morning.
So much time that Rusty Hardin asked for some of his time back.
Exactly, yes. And so we are just waiting for Lieutenant Governor Dan Patrick, of course, the presiding officer, to return and gavel in for the afternoon session. Just again, by way of scheduling, the Lieutenant Governor has said that they may go and as late as 7 this evening, but in addition to that, will likely progress through the rest of the week, and he said work nonstop until this case goes to a quote-unquote jury, meaning 30 senators who will decide whether or not Ken Paxton will remain in office, and whether or not, if convicted, he could potentially be barred from ever serving in an elected position in the state of Texas again.
When we talk about time certainly of the essence, especially considering we've slowed the pace down and we're spending so much time hearing from one witness, This morning, when court resumed, the prosecution had just 9 hours and 20 minutes left out of their 24 hours that they are given to present their case against Paxton. Dan Patrick is now preparing to enter. Him and his legal counsel entering into the Senate chamber now. You'll see him walking onto the dais in just a moment there. That was the bailiff, the sergeant of arms at the Senate, Austin Osborne, who's serving as the bailiff in this case, announcing his arrival. And the senators all seemingly in place now.
And then, of course, once the lieutenant governor takes his position, we will then see Brandon Kamek, who is clearly not being kept on the Senate floor, not allowed on the Senate floor at this time. The way it has been working is that Austin Osborne then opens the door to the chamber and the witness files through the chamber to take his or her position on the witness stand.
And, you know, I would say really some interesting testimony we're hearing from Kamek in terms of how he was carrying out this investigation. There is a lot has been said about him in terms of his experience. He'd only been an attorney for 5 years when he was hired by Paxton to carry out this investigation. He had no experience serving as a prosecutor, and himself said he had never even, issued subpoenas to anyone. He didn't know how it worked.
Or worked on any sort of alleged white-collar crime case, which was part of what he was being asked to investigate through the so-called second referral from the Travis County District Attorney's Office to the Attorney General's office. Actually, he said he got that referral, he looked at it, and in his words, he thought this was going to be an opportunity to rise to the occasion, given his lack of experience.
But then he also mentioned that he felt at times that he was drinking water from a fire hose, that's how much was coming at him at this time. And so he also admittedly said that when he was hired by Ken Paxton, he was hired to investigate a claim that Paxton himself said his attorneys, that's his top aides, his staff, did not want to investigate. And I think it's interesting that then rather than kicking it down to perhaps a line attorney within the Attorney General's office, instead the decision was made to bring in someone from the outside to look into this.
Kamek also testified that he had some relationship with Michael Wynn, and I thought that was an interesting point too. They know each other through the Rotary Club of Houston or something.
That they both served on the board, and that he, outside of the meetings that they had, those board meetings, he didn't have communication with him, but certainly that is how he knew him, and he was a little surprised that when surprised him in recommending him for the job. He also mentioned getting a call from an anonymous number about that job opening. So Dan Patrick there, you can see he's talking, he's sort of joking that the attorneys gave them a bit of homework to do over the lunch break in terms of this decision about whether or not certain evidence should be allowed to be heard in this trial. That is Judge Elena Myers sitting next to Dan Patrick, an experienced judge who is advising him because Patrick has no experience, no legal experience serving in this role. He's not an attorney. He's never been a judge. And now he's sitting as the presiding officer over this trial.
So they're going to spend a few minutes just resolving this issue, and then hopefully we will get back to that testimony. Correct me if I'm wrong, Ashley. Rusty Hardin had completed direct examination of Kamek. Is that true?
No, he had not completed. They wanted to submit this evidence. They wanted to talk about these conversations, and this was happening around 11:58, and so it was a good time for a break and to take a lunch break. And they started this morning about an hour, a little more than
67 minutes. I think you counted.
67 minutes. Of course I did. I did, Tony. 67 minutes behind schedule. They started because they were trying to resolve other issues between the prosecution and the defense. So I think as we're getting to such a key witness, certainly in the prosecution's trial, we're getting, sort of down to the nitty-gritty of as to whether or not certain pieces of evidence are going to be admissible in this court.
And as the clock runs down, who else could be called or will be called to testify. We were talking to James Wood, Austin attorney, earlier today about who might call Kim Paxton's mistress to the stand, the possible benefits of doing that, but also actually the possible drawbacks of doing that as well.
Right. It certainly would seem as though, given the amount of time that they have left, you would want to also remember that of those, and granted this morning it was 9 hours, so it's now less, I would say significantly less than 9 hours that the prosecution has left. They would want to save some time to cross-examine any witness that the defense may call. However, the defense isn't necessarily saving a lot of time.
They don't have a ton of time.
Yeah, as of this morning, they had 12 hours and 14 minutes left, and so at one point, the defense and the prosecution were running neck and neck. They had the exact same amount of time, just about maybe a few minutes difference between them. But we're seeing the defense pull back to have 3 extra hours that the prosecution doesn't have, which would make you think perhaps they do intend to call some witnesses. And you have to be thinking on rusty heart, and you have to be strategizing how much time you feel you need to cross-examine the witnesses.
Yeah, exactly, which will be a major thing that they presumably would want to do.
Beyond that 24-hour limit, right, that each side has to call witnesses, they will also get an hour each to present rebuttal evidence, and that's followed by an hour each for closing arguments.
So as we project that out, the lieutenant governor had said yesterday that he thought this case may be wrapped up Thursday into Friday. It seems to be consistent today with that timeline, which means, not to get too far ahead of ourselves, Ashley, but possibly a verdict Saturday, Sunday, or early next week.
Yeah, it's certainly the lieutenant governor saying that once this case goes to the senators, there will be no off days. It was his words. There will be no off days until we have a verdict, which means they're not going to get to take a day off to go home or, to their respective districts. They're going to have to stay in deliberations in the Senate chamber, just the back room of the Senate chamber, deliberating and talking until they reach their decision. And I say reach their decision rather than reach a verdict because we have to remember this is not a criminal trial. The jurors do not have to reach a unanimous decision on conviction or acquittal, but rather they each individually get to submit their finding, their ruling.
A majority is required to convict Kim Paxton, and so if you project that out, if we assume that all 12 Democrats do in fact vote for conviction, 9 additional Republican senators, 9 of 19, would be needed to convict him, to convict him.
9 of 18.
9 of 18 because of Angela Paxton. Thank you.
So Angela Paxton is present. She is there, and in the rules, it was kind of written in a way that frankly gave Kim Paxton a point. While she cannot vote and while she cannot be present during deliberations, her very presence on the floor, her very attendance, which she is required by law and by the rules to be in attendance, counts toward the total number of votes needed. So rather than a 2/3 majority out of 30 senators, the voting senators, it's a 2/3 majority out of the 31 senators, because though she can't vote, she still counts. And so some see that as a vote to acquit for Paxton.
A vote for Paxton. And so again, as we have seen, the politics around all of this have continued ramping up. That was the case through the weekend with Paxton supporters continuing to apply pressure on this process and on particularly Republican senators who they see as at risk for voting in favor of conviction.
Yeah, and when we're talking about the politics outside of the Capitol building, how they have been painting this as a slam dunk win. They have been painting this as these whistleblowers went to the FBI with no evidence, with no, physical proof, physical evidence to turn over, to show wrongdoing on the part of Paxton.
That they were attempting to stage a coup of the Attorney General.
That Paxton has not, the FBI investigation has not resulted in any indictments of him, and therefore they see this as a clear indication that the whistleblowers were wrong and therefore he should be acquitted.
Let's listen. Let's see what the lieutenant governor is saying regarding that evidence. Still looks like a little bit of business going on. Rusty Hardin, the man you see there in the blue suit, talking to Dan Patrick. He is the, Texas famous attorney, if you don't know that by now, who was last questioning Brandon Kamek in direct examination. We can presume that Kamek will soon be summoned back to the stand.
We'll go ahead and listen in now.
Goudeau, we're sustaining the objection on 686 and 691. And then the other ones we'll bring up one by one as we walk through.
Yes.
So 686 and 691 will not be admitted. Bailiff, call the witness.
If you're just joining us, we are watching as Brandon Kamek enters the Senate chamber. He is the special prosecutor who was hired by Ken Paxton himself, he has testified, to investigate the claims that Nate Paul had against federal attorneys, federal judges, federal agents, that they falsified a document and changed the search warrant on his properties there on the spot in an effort to find him guilty of some sort of crime. That is the claim that
Hardin,
Paxton's aides called insane, but the claim that Paxton wanted investigated. Let's listen in as we continue
Mr. Hardin,
with his
saved you some
testimony.
time on the clock by resolving some of those issues, so you got your extra 5 minutes. Okay.
Thank you, Your Honor. Something just came up at the well, how do we pronounce your name by your preference? We've said Kamek, we've said Kamek. Kamek. All right. Thank you. Mr. Kamek, I have several documents I want to go over with you. I first want to show you and ask you to look on that hard copy you have there. Do you have a hard copy of 649 with you up there?
Let me take a look. Yes, sir.
All right. And I want you to look at that 649 and without testifying as to the contents yet, tell me if that is a document that was prepared by you.
No, sir.
All right. Who was it prepared by?
This document was prepared by Michael Wynn.
By Michael Wynn?
Yes, sir.
And would you tell us the circumstances real quickly as to how you got that document from Michael Wynn?
This was emailed to me.
Emailed to you? Did you ask for it?
No, sir. This was unprompted.
All right. And then in this particular document, it's still not in evidence. I have a couple more questions for you.
Yes, sir.
When you received that from Michael Wynn.
Mr. Hardin, excuse me. So there was an objection on 649?
Yes, sir. I haven't asked him questions about the content yet for that reason.
Because I'm going to sustain the objection on 649.
But I understood at the bench you wanted us to extend a predicate if we were going to try to overcome it. That's all I'm trying to do. But it's not in, you understand as a lawyer, it's not in evidence. Objection's been made, preliminary sustained. I'm being allowed to ask you a few more questions about it without describing the contents.
Yes, sir.
Okay? Now, when this particular document, and notice here, you forwarded that document to whom?
I sent this document to Mr. Paxton.
All right. And in the case of Mr. Paxton, when you sent it to him, is this an example of how you kept him informed of things that were being done?
Yes, sir. This was one of the ways.
All right. And this particular document, then, did you, as you that you got from Mr. Wynn, did you use it as a basis to prepare any documents yourself?
No, sir.
All right. Did you do anything with this document?
No, sir.
So, is it your testimony you received this document from Mr. Wynn, you passed it on to the Attorney General. Did you and the Attorney General ever discuss this document?
No, sir.
Did you ever have any personal or over-the-phone contact with the Attorney General about this document?
Yes, sir.
All right, when was that?
It would have been around the time that I received this on this 9/16 date, but I don't recall the exact date that I spoke with him.
Can you discuss that conversation without referring to the contents internally of this document?
Yes, just like in other things that I forwarded to Mr. Paxton, if I had a conversation about it, I would have said, yes, sir, I sent you over something that I got from Michael Wynn or Nate Paul, or Michael Wynn, actually.
Did you represent Mr. Paxton personally, individually?
I'm sorry, could you?
Did you ever consider yourself Mr. Ken Paxton's personal lawyer?
No, sir.
All right. And at that time, had you been retained by, I believe you testified, the Attorney General's office, is that correct? Or whom did you think you had been hired by?
The Office of the Attorney General.
Okay, all right. So now, was anything with this document done in your preparation for any of the things you did?
No, I believe I skim read this document and just sent it on to Mr. Paxton.
Without ever discussing it with him or anything?
Just discussing that I'd sent him over what this document is, but not going into any detail about what was in this document.
And is this a fairly typical process you had through this whole representation during the investigation?
The process of forwarding him emails and maybe discussing things with him?
Yeah.
Yes, sir.
All right. And were you regularly getting emails from Mr. Wynn that you would just pass on to the Attorney General?
I don't know about regularly. I would just have to look at the emails that...
Let me change the word regularly. Then would you frequently pass on to the Attorney General documents or emails you were getting from Mr. Wynn?
I had sent him some things. I just don't recall what those specific documents were. So I don't know if I can say that I frequently did it, but I did send him things and this is one example of it.
All right. And then let me ask it another way finally. That's all I have on this. Did you attempt throughout your representation or throughout your retention as investigator, try to keep the Attorney General updated on all of your activities?
Yes, sir.
All right. Your Honor, I'll ask the court to reconsider the exclusion of 649. There's a basis here. There's no privilege from anyone. There is on this document. Their business record had been filed with this. It's covered by a business record. There is no statement here by anyone other than Michael Wynn. It is not hearsay, though, because he's not making a statement. They're being forwarded somebody else's statement. And so for all kinds of reasons, I respectfully request that this be admitted.
May I speak with Mr. Kamek, sorry, Brandon, Kamek, on the predicate question, Your Honor?
Yes, you may.
Mr. Kamek, if you could look at the top of House Manager's Exhibit 649, and I think the fourth line down regarding the subject, it says, does it not, discovery plan dash work product?
Yes, sir.
I'm assuming based upon your designating the document with that description that you considered this to be part of the work product that you were performing in your role as an outside lawyer for the Attorney General's office. Correct?
Yes, sir.
You acted like that was a trick question. It wasn't meant to be.
Okay.
So would you agree with me, Mr. Kamek, that the act of reviewing it and then forwarding it was consistent with your description at the top of being work product? Agreed?
Yes, sir.
So it would be covered by the work product privilege, Mr. President.
So your objection is work product?
Yes, sir.
Your Honor, the work product privilege on this document belongs to this witness and witness alone. And the question would become, if he considers it his work product, he's produced it to us, which waives his work product. And I suspect he would concur again that he's not claiming the work product, and he's the only one in this equation that has the right to. and he's provided it to us voluntarily through this production. So it's waived, even if he did. But I've
With respect, I don't agree with the last.
never heard of a third party waiving somebody else's work party privilege.
I'm simply directing the witness to answer the question, which is, it was sent pursuant to. I'm sorry. Brandon, are you okay on water? You good?
Yes, sir.
We will sustain the objection on hearsay.
Yes, sir.
Mr. Kamek, did Michael win? What is your testimony as to whether or not he regularly or frequently throughout this kept providing you information to assist you in your investigation? Did he?
He did send me information throughout the course of this investigation.
Many times was it unsolicited?
Towards the end, it was.
All right.
Yes, sir.
And would he send you things that were to be, that gave you names that he was trying to get you to issue grand jury subpoenas for?
Objection leading.
That's not leading. That question was, would he do so-and-so? He can answer yes or no. It doesn't tell him which answer to give.
Overruled.
Thank you.
I'm sorry, could you?
Yeah. Would he? Did he send you things did he give you names that he was trying to get you to issue grand jury subpoenas for?
No, sir. He gave me names in an Excel spreadsheet that I think we discussed, but it was never, these are the people that you need to.
But, Mr. Kamek, did he also...
Excuse me, may the witness be allowed to finish answering the question?
Certainly. I thought you were through. Were you through?
Are you through, Mr. Kamek?
Pardon me?
Yes, Judge. Yes, sir.
Thank you. Now, what all kind of information was Mr. Wynn regularly providing you, if he was?
I'm so sorry.
Was he regularly providing you information?
Yes.
And what type of information was he providing you?
There were a couple Excel spreadsheets that he had forwarded to me that had the names and demographic information of individuals as they related to the referral that I got. There was a timeline that I was given early on. There was a memo that was provided to me, like a prosecution memo. There was... And as I sit here right now, I can't think of anything else.
Would you look at 650 up there, please?
Yes, sir.
All right. You've got 649 already. We talked about that, correct? The contents are not in evidence. We talked about that, did we not?
Exhibit 649? Yes, sir. We talked about it.
And now you've got 650 in front of you?
Yes, sir.
You just mentioned a prosecution memo that he provided you?
Yes, sir.
And what was the purpose of him giving you a prosecution memo?
Objection, conjecture, and speculation.
Sustained. Just rephrase it.
Excuse me, I'm sorry. What was the stated purpose of him giving you a prosecution memo?
That was also an unprompted email to me with this prosecution memo.
Were all of these things he were provided designed to help your investigation of the allegations of Mr. Paul?
The information that he gave me was helpful to my understanding of what the investigation was about and what was to be done.
Yes. And of course, you were conducting an investigation. Your view, you've mentioned before, was that Mr. Paul was your sort of complaining witness as a prosecutor in your mind, correct?
Yes, sir.
Okay. And were these different things that Mr. Wynn was providing you, were they intended to help you in your investigation of the complaint that was filed by Mr. Paul?
They were helpful to the investigation. Yes,
All
sir.
right.
I don't know what, I'm sorry, I don't want to speak for Mr. Wynn about what the intention was, but they were helpful.
Well, Mr. Wynn was representing Mr. Paul, wasn't he?
Yes, sir.
We can kind of agree, can't we, that he's not going to be providing things to you that are harmful to Mr. Paul? Can't we agree on that?
Yes, sir.
Okay. So would you agree with me as you think about it, that Mr. Wynn was frequently providing you with information that was potentially helpful to Mr. Paul's complaint that you were investigating?
Objection. Leading.
Sustained.
Were you getting information regularly from Mr. Wynn? Number one, were you?
Yes, sir.
And was that information designed to help you in investigating Mr. Paul's complaint?
It was helpful.
All right. You know it was helpful then, right?
Yes, sir.
All right. Did Mr. Wynn provide you a prosecution memo for you to adapt into one of your own?
He provided the prosecution memo to me unprompted, but that was kind of my jump off point for the investigative report that I was going to ultimately put together and turn back into the Attorney General's office.
Yes, sir. He actually, did he not, provided you a prosecution memo that is 650 that was designed for you to help write your report at the end of the investigation. Is that a fair statement?
Objection. Leading.
Sustained.
What was the purpose of this prosecution memo?
I viewed it as giving me information about everything that had happened. More detailed information than just the timeline that I got initially at the first meeting.
Yes, sir. It was all information from the perspective of Mr. Paul, was it not?
Objection. Leading.
I'll ask you another way. Was this information, excuse me, was this information offered to you for help, Mr. Paul?
Conjecture and speculation. He can't know what the purpose of it was.
I'll overrule.
I'm sorry, could you repeat it?
You can answer the question. Was this information provided to you to help Mr. Paul or to harm Mr. Paul?
It was helpful. It was helpful from my perspective to be able to wrap my mind around all of the different moving parts within that investigation.
All right, sir. I'm going to refer you to Exhibit 650 in front of you.
650.
You have it?
Yes, sir.
It's not in evidence yet. But is this a email sent that you got from Mr. Wynn, or is this an email you created yourself?
This is an email that I created myself, and an email that I sent to Mr. Paxton.
All right, was this email, is this the prosecution memo we've been talking about?
Yes, sir.
And was the prosecution memo prepared by you?
This document was, yes.
All right. And did you use as a basis for this a prosecution memo proposed by Mr. Wynn that he sent you?
Yes, sir.
And then did you forward it on to the Attorney General?
I didn't forward Mr. Wynn's memo. I created my own.
All right.
And then forwarded it on.
So did you forward 650 to the Attorney General?
Yes, sir.
As far back as the date of 9/13, is that correct?
Yes, sir, 9/13.
Now, you're not here today claiming any type of privilege on this document, are you? Did you produce it to us?
Excuse me, those are two different questions.
Down at the bottom, I'll ask you to look and see if you see your name.
Could you repeat
Third
the
question.
Yes, did you produce this document to us?
I believe my counsel did.
Yes, your counsel did. I know. In total openness, you provided us about 2,000 documents, didn't you?
Yes, sir.
It was a bunch, right? And 650 is one of those documents you provided us, correct?
Yes, sir.
And you weren't claiming work product privilege at that time or anything, were you?
My lawyers are the ones who produced all of it. I didn't make any claim one way or the other with respect to privilege.
Right, to both sides, correct?
Correct.
All right. So my question to you is this a document you prepared and just forwarded to the Attorney General for his information?
Yes.
Did you ever discuss this document with him?
I did.
When?
I believe it was around the time either just before or just after I had prepared this. I spoke with him about it to let him know that I had sent it.
That you intended what? To prepare a prosecution memo?
Yes, that I had sent this.
To him?
To him.
Did you discuss the contents with him at that time?
I did briefly, just to let him know that I had sent this over here and then it had some ideas about the case.
All right. And so was this designed to let him know that you were working on the case and this is where you were in the middle of September?
Yes, sir.
Okay. Now, again, Your Honor, I move to introduce Exhibit 650.
Objection, hearsay.
Your Honor, there are about 3 different reasons it's not.
Overruled.
All right. Now,
The exhibit is admitted to
Thank
evidence,
you, Your Honor.
650.
I'm sorry, Mr. President, I couldn't hear you.
I'm sorry, I said overruled, 650 has been admitted to
Thank you.
evidence.
now, if we go over to the Bait Stamp 1986 of Kamek, Stacy. All right. Up at the top, number 6 says establishing a predicate to issue legal process. Do you see that?
Yes, sir.
And it has a list of names there. Where did you get those names?
I got these names from Michael Wynn.
All right. And if we go over to the first page of it, Stacy, can you tell us where you got this heading and the date, what it is, the factual summary, where it says a more detailed chronology is attached to this memorandum. Did you get the information that you used as a basis of that from Mr. Wynn?
Yes, sir, from that original prosecution memo.
All right. So would it be a fair statement that everything you prepared in this document, that the research and writing of it was information provided by Mr. Paul or Mr. Wynn?
So, yes.
All right, I'll let you explain. You said so I want to give you an opportunity if you wanted to explain that.
Sure. Well, the prosecution memo that I got initially from Mr. Wynn, I'd reached out to him about it after I'd spoken with Mr. Paxton about sending it to him, and as lawyers, I checked with him. I said, I'm going to prepare this and send it over. Would it be okay if I use some of the things that you put in here, statutes, and reviewed some of the case law that was in there? So, he said, no problem, have at it. So I used that as the basis of what was going to ultimately be an investigative report to turn in at the end.
All right, I'm going to show you what is a new exhibit marked 696.
696.
I don't think you have it up there. I want to ask you just to look at this document, first of all, and see if you recognize it. Don't testify about the contents or anything. Okay?
Mr. Hardin, I don't have 696.
No, sir, it's a proposed new exhibit.
Okay.
I don't either.
And my question is simply, do you recognize it?
Yes, sir.
Can you identify what it is without talking about the internal contents?
This is an email from Michael Wynn, dated 9/25/2020, with what appears to be like a Word document attached to it.
Thank you.
Thank you.
And what did you do with that document? If anything.
With this, I read it and I kind of just one ear out the other with it.
All right. Now, is that additional information Mr. Wynn prepared for you?
Yes, sir.
And without going into the contents of the documents, what was the purpose of that particular document?
This document appears to be a list of individuals to approach about an interview.
All right. So let me ask you this. May I have it back?
Sure.
I move to introduce 696.
Objection, hearsay.
Hearsay, we already have a record, a business records affidavit, which addresses whether the reliability of it. It is not a statement. It is a suggestion to this man by a co-conspirator in this case, not a co-conspirator with him, but a co-conspirator with the Attorney General and Mr. Paul, as they keep feeding this information in pursuit of their conspiracy. That's the reason we offer it.
And therein lies the problem. Mr. Hardin suggests as they keep feeding the information. There is zero evidence that Ken Paxton saw this document, participated in this document, created this document before it was sent by Mr. Wynn to Mr. Kamek. And for Mr. Hardin to suggest there's not a statement is belied on the face of the document. Look at the very first page.
The objection is sustained.
All right, may I just for the record have one thing. Mr. Paxton doesn't have to have seen this if there's an actual conspiracy going on. It only needs to be somebody that is a member of that conspiracy. Any overt act or making any statement like that. I just want that in the record, Your Honor. I certainly don't want to quarrel with you.
Yeah. We sustained it to hearsay.
All right, thank you, Judge. Now, let's move forward. You are going to issue grand jury subpoenas, were you not? I
Yes,
said
sir.
are, but you were. Is that correct?
Yes, sir.
And in preparing those grand jury subpoenas, I think we've testified you used the assistance of the AG's office or the district attorney's office to get the forms prepared, correct?
That's correct.
Did anybody in the district attorney's office work with you or anything as to the content or the people they would be sent to or the wording or anything like that?
I believe I received a form from them in an email, like a sample form. That's the only thing that I received back from them as far as assistance goes.
So is what you said, what you received from them, what I'm really asking is, did any lawyer or anyone working on behalf of the content, did anybody try to talk to you about the content or the people to subpoenaed or anything like that?
No, sir.
All right. Was their duty simply aiding you to get the grand jury subpoena before a judge to sign?
Yes, sir. They facilitated that.
Did you discuss with anybody in the district attorney's office anything about who you wanted to subpoena or anything like that? Or did you simply provide them the information, they helped you with format, and presented it to a judge for you?
Yes, sir. So I just emailed the application for the subpoenas. They did not offer any assistance or make any comments or anything about the contents.
Was there anyone in the Attorney General's office aiding you at all in terms of investigating this complaint of Mr. Fall?
Objection, conjecture, and speculation.
Sustained.
All right. Now, at the end of the time, when you issue these subpoenas, let's go to the dates and times you did it.
Yes, sir.
Did you issue some subpoenas originally by email? You got your billing record up there?
Yes, sir. I'm looking at the...
And your records or your memories show you when you did it? When did you first start serving these subpoenas?
Would have been September 25th. 2020.
Pardon me?
It would have been September 25th, 2020.
All right. And then after you sent, do you remember how many of those you sent out by email?
It was roughly 35 to 40, somewhere in there.
All right. And then after you sent out some by email, then did you reserve some that you were going to serve and serve personally?
I think there were a few that I was going to serve personally for the second referral.
For the second one?
Yes, sir.
So why did you decide to send email for the emails on Mr. Paul's complaint, but decide to serve personally those in the second referral?
Because can I explain myself?
Sure.
So I have this list that I'm given of individuals that are subject to either the first or second referral. I get that from Michael Wynn. And the grand jury subpoenas were going to go out for email address, like to and from, the email log, to, from, what time, around the time that this search had taken place. And then there were also phone numbers to see if any contacts had been made around that time between cell phone numbers. So I say all that to say this: most of the people who were on this list either had a Gmail account or a Hotmail or a Microsoft account. So rather than piecemeal, let me get a couple subpoenas here, there was no intention of it to be this big shock value of sending out so many subpoenas. It was like, let me get all this information together. I will go through it and then go from there. And with respect to those that I emailed out, that's the way I looked it up. I went and looked that up. Like, okay, how does Microsoft receive a subpoena? Well, you can fax or email it. With respect to the banks that I've served those subpoenas on, I just did it in person.
Well, and then you notice you sent out, did you not, on the emails you did, so that you were subpoenaing personal cell phones records? Did you send that out by email?
Those were by email,
Yeah.
the cell phone records.
So were you sending out subpoenas for personal phone records of law enforcement officers, state and federal?
I'd have to look back, but I believe some of them were.
And were you did you even send out a subpoena for the cell phone records of somebody who worked as a deputy for a federal magistrate? A courtroom deputy?
I would have to look, I believe so.
Okay. And then you don't happen to recall on the top of your mind right now who all you did, correct?
I do not, sir.
Okay, that's all right. So then, when you send out these different subpoenas, did you have any knowledge one way or the other that some of the people that you were sending subpoenas to were opposing counsel to Mr. Paul in civil litigation? Did you know that?
No, sir.
All right. If you had known that, would you have done it?
No.
All right. Who did you get the list from as to who subpoenaed?
I got the list from Michael Wynn and Nate Paul.
So is it an accurate statement to say that you issued grand jury subpoenas on behalf of the person that was under a state charges? You issued subpoenas to his agency, the Securities Board.
Objection, assuming facts not on evidence.
Did you realize that? That's really my question. Let me rephrase. Thank you, Judge. Let me put it this way. First person out of the box in that prosecution memo we went over is Mr. Ronnie Saban, right? Did you know that?
Yes, sir.
All right. And you knew him as one of the agents involved in the search, correct?
That's correct.
Were you aware that he was an employee of the Securities Board and was involved in the criminal case where charges were filed and pending at this moment still against the Attorney General?
Objection, assume facts not on evidence.
Did you know that? That's all I'm asking.
Sustained.
Were you aware of what his role was?
Of the gentleman, I think you said Ronnie Saban?
Yes.
No, sir.
All right.
I just only knew him as one of the individuals who had searched Mr. Paul's residence.
Fine. All right. And then different other people. Did you know that Mr. Ray Chester, who was on your list, was opposing counsel in a lawsuit with the Midi Foundation? Just did you know?
No.
All right. So did Mr. Wynn provide you these names without informing you that part of what they were seeking was information with people that were either in litigation against the Attorney General, namely the criminal charge pending, or in litigation against Mr. Paul,
Okay,
namely the Midi Foundation?
I'm
Were
sorry.
you aware of any of that?
Multifarious, assuming facts not on evidence.
It's all in evidence.
No, it's not. And it's multifarious.
We have heard, well, excuse me, let me let the court rule.
Overruled.
Thank you very much. Were you aware of that?
I'm sorry, could you please rephrase that
Sure.
question?
So did Mr. Wynn provide you these names without informing you that part of whatever they were seeking was information with people who were either in litigation against the Attorney General, namely the criminal charge pending, or in litigation against Mr. Paul in the Midi Foundation litigation? Did he inform you of that?
No, sir.
Okay. Now, then you move on to the subpoenas that you were going to serve personally. And is it your testifying that those subpoenas were based on the second referral that Mr. Paul had filed originally with the DA's office on September the 23rd?
Those were for the second referral.
All
Yes,
right.
sir. Yes, sir.
And that's the referral that you had said you got on the 24th, right?
Yes, sir.
Okay. Now, at the time you sent out these subpoenas the previous week, after you sent them out and the judge signed them and they were ready to be sent out and you sent them out into the world of the internet, did you inform the Attorney General?
I did.
How did you inform him?
I believe I sent him an email.
All right. Did you send him an email at any time letting him know which people you were subpoenaing?
No.
right.
I don't think I individually named.
You need to stay with the microphone, please.
I don't believe I individually named each person, but
All right.
I just don't recall that.
Now, when you went out to serve the subpoenas in person, what dates did you do it and how did you do it?
That would have been on September the 29th of 2020.
September the 29th?
Yes, sir.
All right. And had you made arrangements with Mr. Wynn for him to go on these services of subpoenas with you?
So he was insistent on going.
What did he, I mean, how long had he been insistent talking to you about wanting to go with you?
Just maybe a day or so. I told them, I was informing them of what I was going to do to serve. I was going to go drop off the subpoenas, and he was insistent on going, and I was like, no, you don't really need to do that. I didn't really think it was appropriate. But he said, I'm Nate Paul's lawyer, and it's important for me to be there in case they ask you any questions about his case or anything that's going on. And so, I felt a little pressure to say, okay, and he rode along with me.
Share with us why you felt pressure to accede to that.
I think just kind of pressure to perform. I wanted to do a good job, and I frankly trusted Michael.
Right. Did he inform you there was a statute prohibiting an interested party from serving subpoenas?
I was not aware of that.
Okay. And then, so when you made arrangements to go with him, where did you first meet up?
I forgot the hotel I was staying at down here, and he was at a hotel, and I just picked him up and we went.
What day of the week was it? 28th was a Monday, was it not?
I don't know. It was September 29th.
September 29th. I don't think anybody's going to argue if I can say it was a Tuesday.
Okay.
By the way, by this time, Tuesday the 29th, how much contact did you had with the Attorney General about this investigation? How many times? Just first of all, how many times did you talk to him by phone?
Between phone calls and text messages, it had to be somewhere 15 to 20 times range over that 3.5-4 week period.
Yeah. So that'd be 15 or 20 times that you were in contact with the Attorney General about the case, correct? And leading up to the 29th. And would you agree that you really actively get involved on the 3rd of September?
Oh, I'm sorry, one more time?
Roughly the 3rd.
The 3rd?
Yes. Remember the billing records, the first thing you billed is September 3rd.
Yes, sir, that was a typo. The date that I actually went out there was on 9/4.
All right. So can we say that those 15 to 20 times that you're in personal contact about this case with the Attorney General was 15 to 20 times in the days between the 3rd and the 29th of September?
I think that's accurate.
All right. And how many of those do you think they were personal phone calls?
I'm sorry, what?
How many of those 15 to 20 times were phone calls?
I would have to...
Roughly, just approximately.
Say maybe 7 to 10 times.
All right. How many of them were personal visits?
I didn't have any personal visits during that time.
During that time, you had the first meeting that you described when you were hired. Is that correct?
Yes, sir. I had the 8/26, the 9/4 day, and then throughout the month of September, I didn't meet any more in person.
Okay. And by the middle of it, he is communicating with you by a particular type of encrypted app. Is that right?
Mostly through cell phone text, and then I was asked to download the Signal app, and I don't think we had I don't even think we had a conversation on the Signal app, maybe. I mean, I had that and then my cell phone.
Now, did the Attorney General, you did give the Attorney General advance notice that you were going to going out on the 29th and serving subpoenas?
Yes, sir.
Had you sent him any preliminary list of who you were serving them on?
No, sir.
Had you told him approximately how many you were going to serve?
No, sir.
How many were you planning to serve?
I believe there were 4 in person. There were the banks who were kind of the ones that were being accused in that second referral of this bank fraud deal.
All right. And so the email subpoenas that you sent out had to do with Nate Paul's referral number 1? Is that correct?
The emails that I sent out?
Yes.
Yes, sir.
Those subpoenas.
Yes, sir.
And then the subpoenas you served in person had to do with referral number 2. Is that what you're saying?
Yes, sir. That's correct.
All right. And when you took, would you just tell us in your own words, recite to us how you served those subpoenas?
We went to 2 banks.
Yeah, let me stop you there just a second. In each of these banks that you went to, did you identify yourself as a special prosecutor for the Attorney General's office?
Yes, sir, I did.
All right. And Mr. Wynn was with you at each one, correct?
Yes, sir.
Did you attempt at each of these banks to do some interviews of the people you served them on?
Just talking to them, yes, sir.
Yeah.
And giving the subpoena.
And did you talk to each of these people during it, in some cases, a little bit about why you were there in terms of the case?
Yes, sir.
All right. And you were there about a case Mr. Paul contended was a mortgage fraud case, correct?
Yes, sir.
And that was a case in which he wanted you to subpoena also or investigate a federal bankruptcy judge, correct?
Yes, sir.
Okay. And then did you conduct an interview of the husband of a court deputy during one of these services of subpoena?
There was I wasn't serving a subpoena. I don't believe it was that was trying to talk to him.
All right, that was an interview without serving a subpoena. Without giving the person's name, unless counsel asked for it, and I think it's in the records, without giving the person's name, who did you go interview? Was it the husband of a deceased deputy?
Yes, I think she was a clerk of the court.
And where had the deceased clerk of the court been a clerk?
She was I forget which court it was. It was the court basically where this first initial referral came out of, the search warrant that came out of that made the basis of the first complaint.
So she was a previous clerk for the federal magistrate?
Yes.
And who were you talking to, her husband?
Her husband.
And did you have some suspicions or so that made you inquire as to how she died or anything?
I think there was I can't think of the right word, but there was like an indication that maybe there was some kind of foul play or something there with this clerk.
Now Mr. Kamek, that had been a suggestion to you by Mr. Wynn, had it not?
And Mr. Paul.
And Mr. Paul.
Yes.
So Mr. Paul tells you a deputy at the court that issued the warrant that I'm complaining about died under suspicious circumstances. That's what Mr. Paul tells you, right?
I don't remember those exact words, but it was something like that.
And maybe not that tone of voice, right?
Yes, sir.
But my point is, he actually led you to somebody that you in good faith interviewed, making you think that this husband might tell you suspicious circumstances of his deceased wife's death, correct?
Objection, leading and argumentative.
Is that correct?
Sustained.
Thank you. Now, my only point was you issued those 2. You served those 2, were they on the 29th to these 2 financial institutions?
Yes, sir.
And do you remember what the names of the 2 financial institutions were?
I don't recall. I don't recall.
All right. After you issued those subpoenas on the 29th, what happened?
I get back to Houston the following day, and I've received an email from, I think, Microsoft at that point, and then also an email from counsel for one of the banks saying, we need some credentials to.
And of course, you had been saying all along to the Attorney General you wanted credentials, right?
Yes, sir.
In order to take care of this particular problem. Is that right?
Excuse me. Third time. Objection leading. Both questions.
Sustained.
Well, when you how many conversations did you say you'd had with the Attorney General trying to get credentials for this kind of work?
I think 4 or 5.
All right. And then once you got those emails, were those emails, if you served them on the 29th, were you receiving those the day after you served them, or would you receive them all the same day that you served them? If you remember.
It would have been after, and you can't quote me on that exact day if it was the 30th, but I do remember receiving emails to the effect of units.
And then what was the next thing that happened in your relationship, in your conduct with this?
I got a cease and desist letter.
From whom?
From a gentleman named Mark Penley.
What did you do?
I responded to his cease and desist and said, okay.
And then did you do anything else besides respond to it? You reach out to anyone?
I reached out to Mr. Paxton once I got the cease and desist.
Were you successful in reaching him? How did you reach out?
I believe I called him.
All right. Were you able to talk to him?
I don't remember if it was that, if I spoke with him that day.
Did you also get a visit from federal law enforcement?
I did get, the U.S. Marshals showed up at my office down in Houston.
Yeah. Do you remember what day that was?
Maybe October 1st.
Who was the federal marshals were at your office?
They came by my office.
Who was the first person you contacted?
I called Mr. Paxton, blowing his phone up. Like, why are there U.S. Marshals at my office?
How many times you called him?
Probably 5, 6 times, text messaging, and he answered his phone.
On the 5th time?
One of the times.
All right. And how often were you calling him until you got him?
Well, my secretary comes back and says, there's U.S. Marshals here at the office, and I'm like, what? What's going on? And then I just start blowing his phone up until he answers it.
In your mind, certainly, had you done anything wrong that would merit anybody in law enforcement coming to see you, in your mind?
No, sir.
All right. So the first person you called was the Attorney General?
Yes, sir.
And when you got him, what did he say?
He told me don't talk to him without counsel.
So he told you to get a lawyer before you talk to them?
That's correct.
Okay. Did you talk about the merits or anything of why they were there? Do this. What did you say to him, and what did he say to you?
Yeah, I said there's U.S. Marshals at my office. What is this all about? And he told me, well, don't talk to him without a lawyer. I don't know what it's about either.
Okay.
And then hung up the phone.
He hung up the phone, or you hung up?
I don't remember. We both hung up the phone and went out there and greeted those gentlemen and went to my conference room, and I said, hey, with all due respect, I can't talk to you without having a lawyer present, but can I have a business card? And I got the business card from those 2 gentlemen, took a picture of it, and I sent it to Mr. Paxton. Said, these are the guys who showed up at my office, and that was that.
All right. What's the next thing that happened to you in connection with this?
I had sent my invoice back to Mr. I got a cease and desist letter, and I send my invoice back over, and then I get an email the following day from Jeff Mateer.
And what did Mr. Mateer tell you?
They sent me another cease and desist letter, accusing me of crimes and all this other stuff. I'm like, whoa, what is going on here?
All right. And then at some time, did you go back to Mr. Vassar with the request to be paid, and that he responded to you?
They said there was no valid contract, and so I sent him the contract that I had for Mr. Paxton.
And all along, had you believed you had a valid contract?
Yes, sir.
And when you sent him the valid contract, was it signed? Who was it signed by?
It was signed by Mr. Paxton.
The one you sent back to him?
The one that they said that I didn't have a valid contract. I sent him the contract that I had for Mr. Paxton, with Mr. Paxton's signature on it.
Was Mr. Paxton's signature on the one you sent them?
The one that I sent them. I'm sorry.
When did you get a contract that had Mr. Paxton's signature?
I believe I got that on September 28th.
How had that happened?
So this was about the time that I'm getting ready to go with the subpoenas, and I still don't have my badge or credentials, and I was talking with Michael Wynn about it, and I was kind of frustrated at the time because I'm like, well, I'm supposed to go serve subpoenas and do this work. I don't even have my credentials, which my contract, don't have a badge. I don't have a governmental email address. And Mr. Wynn asked me, I guess, well, send me over your agreement. And I had planned on coming out to Austin the following day to come do these subpoenas. So I get out to Austin to go over to...
Now, let's put a day on it. What day do you get to Austin?
That was on the 28th.
All right, the 28th would be a Monday.
September 28th.
All right. And you arrive in Austin on the 28th. And what happened when you got, who do you go to see?
I'm meeting over at Nate Paul's office, and Michael Wynn is there.
All right. And what do you find when you get there?
My contract was there on the table.
And was it signed by whom?
Myself and Mr. Paxton.
Had you ever seen a contract signed by Mr. Paxton before September the 28th?
No, sir.
And in fact, all this time that you thought you had a valid contract, did you have a contract that was only signed by you?
I sent Mr. Vassar my signed copy back on the 4th and said, please send me back an executed contract. And I never got one. I didn't know.
I just want to make sure real quickly here. You got back from you sent Mr. Vassar your contract, which had only your signature on the 4th. Is that right?
That's correct.
And then, from then until the 28th in Mr. Paul's office, did you ever see a contract that had the Attorney General's signature on it?
No, sir.
And when was it that you complained to the Attorney General, if you did, that you did not have a contract signed by him? When was the last time you did that before you saw it on the 28th?
I don't recall the exact date, but I had told him about a badge, credentials, and email address, and so I just never received it.
On the morning of the 28th before you left, did you have a conversation to go up there? Early in the morning, did you have a conversation with Mr. Wynn?
I did.
And what did you tell Mr. Wynn?
I believe he had texted me the night before and said, because I was frustrated, so I was telling him I don't have my credentials, like meaning my contract or my badge or any of that. So he texted me. I think I was already sleeping, and he said, "Send me your contract." So I wake up at like 5 a.m. and I send it to him.
The contract you sent to Mr. Wynn early that morning,
about 5 a.m.
5 a.m. had only your contract, your signature?
Yes, sir.
All right. And then how soon after that was it that you arrived in Mr. Wynn's office where they had a contract signed by the Attorney General?
We went to Nate Paul's office, not Mr. Wynn's office, and we had to be around lunchtime maybe.
And you walked in and saw what?
My contract was there on the deal signed.
Signed by the Attorney General?
Yes, sir.
And that was the first time you'd ever seen one?
Yes, sir.
Signed by him. All right. Now, finally, when things got a little hectic for you after that, did they not, after the 29th and 30th of September?
Yes, sir.
When was the next time that you saw the Attorney General?
I don't remember the exact date. I'm sorry.
On the 29th or the 30th, did you see him? Or the 1st of October or the 2nd October or any of those dates? Did you have occasion to have contact with the Attorney General again?
I did. I just don't remember the exact date. It was after I had received the second cease and desist letter from Mr. Mateer. And what were the circumstances of you seeing him? I got a phone call from Michael Wynn, and he had said, hey, I need you to come out to Austin. It was like last minute, and it was in the evening. And I'm like, he's like, you need to come out to Austin and come over to Nate Paul's house.
What time of day were you supposed to get there?
I don't remember what time I got there. Maybe it was in the evening. My sun was going down.
All right. And so when you drove up there to Austin, to Mr. Paul's house, did you have any idea why you were there?
I mean, I figured because at this point, I've gotten a cease and desist letter. I've gotten basically the rug pulled out from under me. Like, I'm going and working, everything is okay. I'm getting affirmation that everything is good. And then all of a sudden, I've got cease and desist letters, U.S. Marshal showing up at my office. And I'm trying to figure out, how did we go from that to this? And I'm just trying to get answers about what's going on, because I still don't know. And so that's what I figured this was all about. So, yeah, I get out to the house. I drive to Nate Paul's house, tell my fiance at the time, like, hey, I'm going out here. I'll be back later. And then, yeah, I get out.
So what happens when you walk in? Can you basically describe the meeting?
Yeah, I go in, and Michael Wynn is there, Nate Paul is there, and Mr. Paxton's there.
Where's Mr. Paxton, and what's he doing?
Shook his hand, and he was like on the phone, and then just spent most of the time just out on the balcony on the phone.
Was there anything surprising about him being there to you? Did you know he was going to be there?
I didn't know he would be there.
Pardon me?
I didn't know he was going to be there.
And then, what was the circumstance, the scene? How was everybody dressed? What was everybody doing? All that jazz.
I mean, I was dressed in a suit because I thought it was, for business, and, they were dressed casually. I think Michael had a suit on. Mr. Paxton had like running shoes and running shorts on or something, just casual.
Did they talk to you? Why were you there?
So while Mr. Paxton was out on the balcony, Michael Wynn and Nate Paul, they were just kind of commiserating about all this stuff that had happened in that last few days. And when Mr. Paxton came in, as I was going to leave, I think I was there maybe an hour, he had mentioned, that Mr. Penley didn't have any authority to tell me to stop working. He told him to stand down and just to continue to work on this report.
At that time, when you say he came in, was he outside the room but there when you arrived?
He was in the house and then went outside on the balcony or in the back and was on the phone the entire time.
All right, after Mr. Paxton told you that, how long were you there?
Oh, I left.
So, what did you think? What was the meeting about?
Just a lot of talking about, how I can't believe that this happened. I can't believe what these guys are doing. The fact that Mr. Penley had reached out to Michael Wynn asking for documents, even though Mr. Paxton had told him not to work on the case, and this type of stuff. But I still left there very. In my mind, I'm like, hey, I got 2 cease and desist letters. I'm not doing any more work. And I haven't been paid for anything. And so I'm just kind of listening, trying to get answers on what I should be doing.
So did you wonder on the way home why the hell you had been there?
Yeah, yes, sir. That was annoying to have to drive out a 3-hour drive for an hour meeting and then come back.
When is the next time you saw the Attorney General about this matter?
I think within the next couple of days, I got a call to come out to his office and meet with him and some of his staff.
And what did they want?
Mr. Paxton wanted me to meet Brent Webster.
Brent Webster did you know who he was by that time?
No, sir.
Did you know what position he now had?
I knew when I got out there that he was, I guess, the first assistant.
And when and where did y'all meet? What did you do? Just walk us through it.
So we met in the conference room over at the Attorney General's office with 2 other individuals, and Mr. Paxton wanted me to just debrief what I had learned, what the first referral was about.
What did you tell him?
What I had done. I spent the first few minutes kind of just venting my frustration about how I felt like I had been treated to that point, still not having any clear answers, and the fact that I had a whole entire life before of all of this, a docket. I had clients. I mean, I didn't ask for any of this. You guys reached out to me to come do a job, and then now you're pulling the rug out from under me, and I'm getting cease and desist letters, and now my name's being thrown through the mud in the media, and it's a totally new world to me. So, I let that out and just told them, what we kind of talked about here today, right now, that I'd issued subpoenas. I had this PowerPoint presentation where they showed me this, and
What did they say? What did he say? What did the Attorney General say?
I believe he asked me, or Brent Webster asked me, to send him any documents that I had sent the Attorney General, to email it to him.
Did the Attorney General apologize to you?
I don't think he apologized to me, no.
And then did y'all stay there, or did you go somewhere else?
No, I left there. Went back to Houston.
And then when was the next time that you saw the Attorney General?
Yeah, the next time, and I'm sorry, but I just don't recall the exact date, but it was within that week. I get a call from, that last meeting, it was like, hey, you need to, just continue to work on the report. Everything is fine. And in the back of my mind, I'm like, yeah, right, I'm not doing anything else. And then a few days go by, and I get a call to come back out and meet with him, just like a very short notice, maybe even the same day, to come out to Austin again.
You drove up again?
Drove up again.
You recall what that date is?
No, sir. It had to be the first week of October sometime, though.
All right. And then where did you go when you drove up?
I went to the AG's office again.
And then who was there?
Brent Webster and Mr. Paxton.
And what happened there?
I thought we were going to meet to talk about the contract and what is going on, and but instead, they were like, well, let's not meet here in the office, and they walked me over to a Starbucks outside of the office to have a meeting.
Did you ask why?
No, but it was uncomfortable. It was not professional to me at all.
So when you go to the Starbucks, who all is there?
Mr. Paxton, Brent Webster, and then a couple other gentlemen who I don't know.
And what happened at that meeting?
At that meeting, Mr. Webster did all the talking and told me, well, in fact, your contract is not any good anymore. Stop working, don't do anything at all. I asked him, okay, well, what about, paying me?
Do you recall exactly how you put it about whether you were going to get paid? Did you put the amount in there?
I think I ballparked it, and I said, what about my $14,000 invoice? And he's like, well, you're going to have to eat that invoice. I've had to eat $40,000 invoices.
Webster said he had eaten a $40,000.
That sticks out in my mind, sir.
Yeah.
Yes, sir.
Why does that stick out in your mind?
Just because it was offensive.
Yeah. What was the Attorney General doing during this whole conversation?
He was just listening in.
Did one of them tell you your contract was now terminated?
What Mr. Webster said.
How long did you at the Starbucks?
15 minutes, 20 minutes tops.
Did you feel better knowing that Mr. Webster says he had eaten a $40,000 debt before? Did that make you feel any better?
I'm sorry, what do you mean?
How did it make you feel?
I don't know if I believed him or not, but I know it was offensive to me.
And then what happens? Anything you remember? What happened then?
Yeah, they left the Starbucks and tried to get in the car and drive off. I said, excuse me, can I get a ride back to my car?
So these guys take you to, are you saying that these guys took you over to a Starbucks outside the office, terminated your contract, told you weren't going to get paid, and then drove off, and if you hadn't said, wait, I got my car, they'd have left you in the street?
That's what it looked like.
Pass it with.
Mr. Goudeau.
Good afternoon, Mr. Kamek.
Hey, Mr. Cocktail.
We know each other distantly, I guess is the best way to put it.
Yes, sir.
You also know my associate, Mr. Oso.
Yes, sir.
Once upon a time, there was a lot of discussion in the court about young lawyers and 5-year lawyers and whatever. At the time you got involved in the Paxton matter, Mr. Kamek, you were a 5-year lawyer, right?
Yes, sir.
Mr. Oso, younger than you or older than you?
He's younger than me.
Let me begin sort of near the back and the marshals coming to your office. You learned eventually, did you not, that the purpose or the reason the marshals came to your office was because of the visit that you'd made to the I guess the widow or the widower at the clerk's office, right?
I learned that from my lawyer, Andy Drumheller.
Okay.
Yes.
And Mr. Paxton hadn't sent you to that clerk's office or anything of the sort, right? That
No,
was
sir.
That was Nate Paul. You met with Mr. Hardin how many times before you testified?
I've spoken with him 3 times.
When was the first time?
I believe it was in the last 2 weeks. I'm sorry, I don't remember the specific date.
About how long was that meeting, Brandon?
That was approximately 4 to 5 hours, I believe.
And the next time you met with him?
I met with him last week when I came out here. I thought I was going to be testifying on Friday.
And about how long was that?
Hour and a half to 2 hours.
And did you meet with him again last night?
Met with him last night for maybe an hour.
So that's a total of how many hours that you met with Mr. Hardin?
Roughly 7.
Could we see article of impeachment, article number 5? Have you studied, I assume you have not, Mr. Kamek, the articles of impeachment in this case?
No, sir. Not studied them.
But if I suggested to you, this is, quote, why you're here, close quote, could you agree with me?
Yes, sir. I've read this. I've seen this.
All right. Did Mr. Hardin ask you or show you this article in any of those 8 or so hours?
I don't recall seeing this.
So in the 8 hours that you met with Hardin, he never showed you the relevant article that brings you here. So let's take it apart. It says, while holding office as Attorney General, Warren Kenneth Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro tem. Will you agree with me, Mr. Kamek, that you were not a prosecuting attorney pro tem? Agree with me on that?
Yes, sir.
Okay. It goes on to say that Paxton engaged Kamek, a licensed attorney, to conduct an investigation into a baseless complaint. Mr. Hardin never asked you about that? That language?
I'm sorry, could you
Sure.
rephrase that? I'm sorry.
Yes, sir, sure. Mr. Hardin never went over this language in the article of impeachment with you, right?
No, sir.
And you will agree with me, Mr. Kamek, that you certainly never believed that you were a part of an investigation into a baseless complaint, right?
No, sir, I did not.
Okay. 8 hours and you've never asked that question by Mr. Hardin, right?
We didn't talk about a baseless complaint.
Okay. Let's go for strike 3, although you just need 1. It says, during which Kamek issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul or Paul's business entities. You would agree with me, Mr. Kamek, that was not your purpose. You were not there trying to benefit Nate Paul or his business entities. That's not why you agreed to get involved in this. Agreed?
Absolutely not. I didn't even know Nate Paul or his entities or anything like that.
Mr. Hardin has a reputation as not a good lawyer, a great lawyer, right?
Yes, sir.
Could you give us a reason why a lawyer as good as Mr. Hardin would have never asked you those critical questions?
In the words of a great American, Your Honor, it's calling for speculation.
Sustained.
Well, if that's a suggestion that I'm a great American, I'll take it. Let's go back. I think what may be lost in some of this, Mr. Kamek, is this is in the late summer or fall of 2020, right?
Yes, sir.
And this is when, I don't want to say COVID is raging, but COVID is ever-present, omniscient. It's taken over the world, right?
It's peak COVID. Yes, sir.
Peak COVID. So here you are, a younger lawyer. If I understand it correctly, you had just left, not too long before this, practice with your father, right?
That's correct.
He is also a criminal defense lawyer.
Yes, sir.
So you have your own practice, right?
Yes, sir.
You had tried a number of cases with your dad, I assume, a number of cases with others, right?
And myself, yes, sir.
And yourself. And you had tried, I guess, I'm assuming, anything from misdemeanor cases to felony cases,
yes,
right?
Sir.
You weren't some kid straight out of law school that couldn't find a courtroom door with a CNI dog and a search warrant. I mean, generally speaking, you knew what you were doing at the Harris County Courthouse, right?
Absolutely.
So along comes COVID, and like a lot of Americans, what you took for granted suddenly was an issue, right? Meaning your business, our business stopped. It didn't slow down. It came to a screeching halt, right?
Yes, sir.
Arrests went way down. Courthouses literally closed, right?
They did.
So you're rolling along, I assume, and you get a call from Mr. Wynn that the Attorney General might be calling you, right?
That's right.
Now, I assume you never aspired to be a prosecutor or you would apply to the DA's office, but still, when the Attorney General calls, that's a big moment, right?
It was a big moment.
Okay.
Yes, sir.
You trusted Mr. Wynn, right?
I did.
He's a Harvard-educated lawyer. You were aware of that?
He's a serious lawyer.
He's a serious lawyer. And I assume that up to this point in time, Mr. Kamek, you didn't have any real personal connection in terms of going out and having drinks or having dinner or whatever with Mr. Kamek, but you knew him professionally slash socially, and you respected him, right?
With Michael Wynn?
Yes, sir.
Just an acquaintance who was part of a couple clubs I was, and we had worked on that COVID-19 panel with some of the district court and federal judges, and he seemed like a nice person.
Okay.
So,
he had a significant practice, at least from your perspective?
serious practice, yes.
So it's good news, and if I'm remembering your direct correctly, the call from Mr. Paxton or from General Paxton came on your birthday.
Yes, it was on my birthday.
You're thinking, what a great birthday present, right?
Something at the time I was like, oh, well, what a coincidence.
And look at you now, Mr. Kamek. Didn't turn out to be that perfect, did it?
I never would have imagined in a million years getting that call to sitting in an impeachment hearing, sir.
Got it. So let's go completely sideways for a second. If there has been a suggestion, Mr. Kamek, that it is wrong or illegal to challenge or investigate the legality of a search, that is not your worldview, right?
I'm sorry, one more time.
Sure. If there has been a suggestion made in this courtroom before these 31 senators that it is somehow wrong or illegal to investigate the legality of a search or a search warrant, that is not your worldview. Agree with me?
I agree with that.
I mean, it's sort of born and bred in a criminal defense lawyer. That's part of what we do. You would agree with me?
That is what we do.
And any criminal defense lawyer, I think, that's been practicing longer than 6 weeks has probably challenged the legality of a search warrant. You would agree with me?
Yes, sir.
And has probably looked into the conduct of law enforcement agents in either the creation of a search warrant, right?
That's right.
The execution of a search warrant, right?
That's right.
Again, that's called Wednesday in our business. That's what we do.
That's a Wednesday on our business. Yep.
Now, would you also agree with me that not only do we have, I guess, the choice of challenging or investigating the legality of searches, but we have the obligation to do it on behalf of our clients, right?
Right, we're just on the other side of it.
Yes, sir.
That's right.
And if we don't do that on occasion, we can get sued by the client, right?
That's right.
We can have a grievance filed against us by the client, by the state bar or someone else for failure to investigate that sort of claim, right?
That's right.
And I guess my long-winded point there is when you were asked by Ken Paxton, and we will get to that conversation, but when you were asked by Ken Paxton or told by Ken Paxton he wanted you to investigate the possibility of an illegal search or the creation of an illegal search warrant by agents, that was like, great. That's in my wheelhouse. That's what I do, right?
Well, it was an investigation into potential violations of the Texas Penal Code, which is what I'm familiar with doing. So it would be in my wheelhouse.
Right. So it's in your wheelhouse, in your strike zone, whatever, right?
Right.
And the fact that, and oh my God, it's a federal agent, or oh my God, it's a federal magistrate. I mean, again, they deserve and are owed their deference, but there's nothing sacrosanct about an AUSA in our worldview, right?
I have complete respect for government officials, but, you know, Mr. Paxton also believed that, hey, this is a serious accusation. It requires a serious focus. And, you know, if someone's doing something like that, they should be held accountable for it.
And I assume, Mr. Kamek, you felt the same way.
I did feel that way.
Now, jumping ahead a little bit, but I think in one of the conversations, Mr. Kamek, you had, or one of the answers to one of Mr. Hardin's questions, that somewhere along the line you heard either Mr. Wynn, I believe, or Mr. Nate Paul say something, quote, and this is a statement attributable to Mark Penley, there's no amount of information that could be presented to him that would ever convince him that a federal official could commit a crime, right?
That's right.
And which person said that? Was it Mr. Paul that said that about Mr. Penley, or Mr. Wynn that said that about Mr. Penley, or do you know?
It was Mr. Paul said that.
Okay.
Mr. Wynn was there when he said that.
Okay. And that's just not the house that you live in.
I don't live in that house.
You don't feel that same way, right?
I don't feel that same way, no.
I'm assuming.
Excuse me, can the witness be a little closer to the mic and speak up a little bit?
All right, Judge.
I'm assuming, Mr. Kamek, that you view federal prosecutors and magistrates and judges just like defense lawyers, bankers, bakers, trash truck drivers, whatever. There are good ones out there, and there are bad ones out there.
Base people off of their character. I mean,
That's right.
That's it.
And you do not automatically foreclose from your mind or from your obligations an inquiry into the legality of a search warrant simply because it was signed off by a federal magistrate, right? That's a mouthful. There's nothing improper in your worldview about investigating a search warrant or the validity of a search warrant simply because it is signed off by a federal magistrate, right?
No, I mean, that's, as a defense lawyer, that's what we do, is challenge the validity of a search warrant. I mean, this was just on the other side of it, where that person could be held accountable for it.
Now, let's get to your first meeting with Ken Paxton. On your birthday, I think the 22nd, he calls, right?
Yes, sir.
And I'm sure you have been asked this question 287 times, but the best of your recollection, he says what to you when he calls you, Mr. Kamek?
I didn't speak with him that day. It wasn't until the 23rd that I spoke with him, and he said that he got my name from Michael Wynn. I think the words were, my name was dropped in a hat, and he got my name from Michael Wynn and wanted to see if I'd be interested in coming to talk to him about working on a criminal investigation.
And that would have been, if it's the day after your birthday, that would have been August 23rd?
Yes, sir.
And did he give you any detail about what he wanted to, what was the job description specifically that he wanted you to do?
Not at that time. It wasn't until I went out there and met with him in person that I found that out.
Okay, and if I'm recalling it correctly, there was some request by someone to bring a resume, right?
Yes, sir.
And it had been a while since you had a resume, right?
Yes, sir.
But you figured, well, if I've got to audition for the beauty contest, I'll find a swimsuit, I'll get a resume together, right?
Just trying to remain humble and do what he asked me to do.
Okay. And you met with him, right?
Yes, sir, on the 26th.
On the 26th, Mr. Paxton, General Paxton you knew him by sight, right?
Yes, sir.
He's gracious, professional, nice enough to you.
He was nice, yes.
And on that day, on the 26th, Mr. Kamek, can you share with us the description of what he wanted you to do?
At that time, he told me that he was looking to hire a special prosecutor to investigate whether, I guess, these federal agents had tampered with or altered a search warrant. Basically, violations of state law.
Okay. And again, we've talked about that's kind of in your wheelhouse.
Correct.
You spend 20, 30 minutes with General Paxton?
Probably 20, 25, something like that.
And he uses the phrase special prosecutor, right?
Yes, sir.
So we've heard that sort of go through the evolution of your story, but it is true that he was the person that first put those words into your mindset, right?
Yes, sir.
If I heard your testimony directly, then, Mr. Kamek, you go down the hall and you meet with Jeff Mateer, right?
Yes, sir.
And did he act like he knew why you were there?
He did.
And just collapse the conversation succinctly that you had with Mr. Mateer.
Yeah, so I had another copy of my resume. I handed it to him, and I said, well, it was kind of awkward for a second, just communicating with him. But he said, I said, I'm here to interview about the special prosecutor position for this investigation with respect to the search warrant. And he acknowledged that,
okay,
and said, oh yeah, I know a little bit about that, and just kind of act disengaged.
Gotcha. And I think that was the phrase that you used with Mr. Hardin, disengaged, right?
Yes, sir.
But I guess my point, at least right here, Mr. Kamek, is the phrase special prosecutor was discussed with Jeff Mateer, right?
That's correct.
And at no time did Jeff Mateer say, oh, no, you're not going to be a special prosecutor. We can't hire special prosecutors. That never happened, right?
No, sir.
Did Mr. Mateer, disengaged as he was, did he ever indicate to you, Mr. Kamek, that there was no need for a special prosecutor being hired?
He did not.
Did he ever indicate to you that he felt like this investigation was a baseless complaint?
His attitude was kind of like that. Like he didn't feel like it was important or worth pursuing.
It didn't rise to his level of importance.
That's fair to say.
Okay. But he certainly never said or suggested to you that this was a crime or illegal for you to be interviewing for this job.
And he did not. He did not.
Okay. Now, you don't get the thumbs up that day, but you leave. You're optimistic, hopeful about it, right?
That's right.
And to put us back in your worldview at the time, again, we're in the middle of COVID. Let me stop back. I over theatrically demonstrated or referred to how long you'd spent with Mr. Hardin. You and I did meet last night, right?
Yes, sir.
Spoke for 45 minutes or so.
About 45 minutes.
It was late, right?
It was late.
And it was after Mr. Hardin had
met with Mr. Hardin, and then me and my lawyers came and talked to you for about 45 minutes.
Gotcha. So we have discussed this before. I'm not just getting lucky with every single answer.
We have talked about this, yes, sir.
Okay. So you're hopeful. Again, we got COVID. You're thinking the Attorney General. This is great. I believe that on your drive home, you call your grandmother, right?
I think I told you that. It's like, hey, I met the Attorney General.
Right.
Yeah.
And your grandma says, I guess, would act like any other grandma and said, good for you. That's awesome.
That was her attitude.
So you then go through a series of exchanges about whether or not you might have a conflict, right? Potential conflict with any other cases at the Attorney General's office.
Yes, sir. Mr. Vassar at some point reached out to me about a contract.
Okay.
And told me that I needed to do a conflicts check.
Did Mr. Vassar ever suggest to you, Mr. Kamek, that you were unqualified?
No, sir.
Did Mr. Vassar ever express to you that hiring, whether we call you an outside counsel or special prosecutor, whatever, did he ever express to you that the hiring of you was unnecessary?
No, sir. He reached out to me to set up a phone call. And then on that phone call with him, I said, yeah, I'm interviewing, or he's calling me, I guess you're calling me about the special prosecutor position. And then he's acknowledged that, asked for my email address. And I think we talked a little bit briefly about where he had gone to school and that type of thing. So he's, I told him the same thing that I told Mr. Mateer as well.
But he never gave you any pushback on the idea of you getting hired for this job, right?
I never got any pushback from anyone at the Attorney General's office until I got a cease and desist letter.
Say that again.
I never got any pushback from anyone at the Attorney General's office or the Travis County District Attorney's office or anything until I got a cease and desist letter.
In fact, Mr. Kamek, it's true, is it not, that in your, effort to be compliant, appropriate, righteous, that's probably overstating it, but in your effort to do the right thing, you called the State Bar of Texas Ethics hotline and described what you were going through, right?
I did, sir.
And without getting into what they told you, you walked away from that conversation after explaining to the ethics hotline at the State Bar of Texas what you wanted to do. You felt like you had a blessing from the State Bar of Texas to do exactly what you do, right?
Told me congratulations on the job.
So in the middle of this alleged conspiratorial dark worldview effort, you're calling the State Bar just to make sure you are literally dotting your I and crossing your T.
That's
right?
correct.
Now, I think Mr. Hardin had you talk about your expectations about your sort of bell curve or what have you of ability. In other words, when you first met with Mr. Paxton, I think you thought, I can investigate, I can issue grand jury subpoenas, I can appear in front of a grand jury, I can make recommendations to the grand jury. Heck, I might even get to go try this case. That was kind of your worldview when you went into this, right?
I thought I didn't think there would be any limitation all the way up into potentially presenting the case for a charging instrument, whether it be an indictment, a complaint, an information, or trying the case in front of a jury panel. So once I got my contract, then I realized how limited of a scope it was.
Yes, sir. You anticipated my next area question. Once you got the contract back, it was sort of the real world of, no, I'm not going to be presenting this case to a grand jury. No, I'm not going to be making recommendations. No, I'm not going to be trying the case, but I'm going to be investigating the case, right?
I was just still happy to be working for the Attorney General.
Got it. Now, and I don't know when you want to break, Mr. President.
I was going to go to about 3:10, about 15 more minutes.
That's fine. At some point along the way, you and General Paxton had a discussion about your hourly rate. You said $300 an hour, right?
Yes, sir.
And you would agree with me that all things being equal, that's a pretty reasonable, moderate rate, right?
Yes, sir.
I guess, Mr. Kamek, the more important than the money was sort of the prestige or the opportunity or the resume, if you will, of getting to work for the AG's office on this particular matter.
I thought it was a fair rate, and it was not about the money. And I have a whole business before all of this that I still have today. So it was not about the money. It was about trying to help out.
All right. So refresh my memory of when you get a contract from, and refresh my memory. I should know, but I don't. You got a contract from whom and on what date? The first contract you received?
I received a contract. This was my mistake, but the contract came in on September 3rd in my email, and Mr. Paxton asked me, did I receive it?
Okay.
But I didn't see it. It got lost in the shuffle of all the other emails. So I responded back and said, no, I didn't get it. And then Mr. Vassar resent it to me on September the 4th of 2020.
So you have a recollection of Vassar specifically sending you this contract, right?
I do, sir.
And when you received this contract from Mr. Vassar, you think that is an offer. I mean, neither one of us are contract lawyers, but you think that's an offer, and by signing it and sending it back, you think that's an acceptance.
Yes, sir. I spoke with him, Mr. Vassar, about the contract.
Right.
I spoke with Mr. Paxton about the contract. He followed up to see if I got the contract.
Right.
He said he could get me the hourly rate. I told him I was coming back out there. I mean, to me, it was very clear that I was being hired for this position. And so I signed it and returned it to Mr. Vassar that day when I got home.
Gotcha. And no one suggested to you during that month of September that they had their fingers crossed and you really didn't have an agreement. In other words, you went through that month believing you had a valid contract with the state of Texas to be an outside lawyer, right?
Yes, sir.
Now, I think you told us that you, Mr. Kamek, attended a meeting with Nate Paul on September 4th, right?
Yes, sir, I did.
And that's here in Austin, right?
Yes, sir.
Let me back up. So, Michael Wynn tells you, hey, the AG might be calling, the AG calls, right? And then you learn at some point that Michael Wynn not only had recommended you, but was Nate Paul's lawyer, who was the complainant, for lack of a better description, in this illegal search warrant claim, right?
Yes, sir.
Do you know when it was, Mr. Kamek, that you learned that Wynn was representing Nate Paul?
Yes, sir. It was once I got confirmation about the job, I guess, and okay. I sent, Michael reached out to me and said to come meet with him and the complainant, Michael or Nate Paul, on September 4th.
Now, Mr. Hardin asked you if you did any research about Nate Paul, or you Googled Nate Paul, or words to that effect, right?
He asked me that, yes, sir.
And when is the first time you have a recollection of doing that? Before you met with Paul or after you met with Paul?
Before I met with him. I just Googled him.
And you knew, obviously, at some point that he had a search warrant run on his home and his properties and his business and all of that, right?
Yes, sir.
You didn't come across news articles about that in your search, however long that was or wasn't, right?
No, sir.
But what you came across were articles where, for lack of a better description, he's the new golden child of commercial real estate in Austin. He's the new king or whatever, right?
It was just headlines about his career as a real estate developer.
From your perception, Mr. Kamek, you thought you were sitting in front of or meeting with a valid gentleman or person of substantial economic means, I guess.
I thought, okay, serious guy, businessman, serious lawyer, serious case. Took it very seriously.
Okay, so nothing about this, I guess I'm stumbling into. Nothing about this was off-putting to you. You didn't think that there was. In fact, you thought this case just keeps getting better and better for me, right?
I was just trying to focus on the facts of what I was being presented with. I didn't know any of these people.
Okay. So you meet with him in Austin. I believe you said you met with him for an hour and a half, 2 hours, right?
Yes, sir.
And I say him. Nate Paul is there. Michael Wynn is there, right?
Yes, sir.
Ken Paxton is not at this first meeting, if I understand it, correct?
No, sir. He was not there.
And they are explaining to you, that is Mr. Wynn and Mr. Paul are explaining to you their theory about why the search warrants may be invalid and why they might have been altered, right?
Yes, sir.
And I wasn't there, but as I understand it, Mr. Paul showed you, made a pretty convincing presentation utilizing a computer, diving into the metadata, which at least convinced you that this probably happened or this might have happened, right?
I was convinced.
You were convinced?
Something there.
Okay.
I didn't make a judgment either way, but it was a persuasive presentation.
How computer literate are you, Mr. Kamek? And that's a vague question. You know much about metadata?
No, I've never really worked with metadata in that way.
Okay, but it at least appeared to you at that time that Mr. Paul was literate in that area, made this explanation, made this explanation, and you accepted it, right?
Yes, sir. I was told that this presentation was also given to Mr. Penley and Mr. Maxwell as well. So it was just me, my set of eyes looking at it, and I thought it was persuasive.
And you leave there, I think, and go meet with Ken Paxton at his office here in Austin the same day.
Yes, sir, that's correct.
Do you recall how you described your worldview of the explanation that, I don't know why I can't talk. I'm paid to talk. You told Ken Paxton, I think, Mr. Kamek, words to the effect of, I think there may be something there, General.
I told him I was convinced, it was convincing what I was shown, and he agreed with that.
Okay. Now, let's go there. When you say it's convincing, exactly what words did you say?
I said it was convincing, it was persuasive, and he agreed with that. He said, yeah, I agree.
Paxton agreed with you.
Yes,
right?
sir.
Now, at no time, you would agree with me, I think, that did Paxton ever suggest to you that this investigation was a baseless investigation, right?
No, he never indicated that it was a baseless.
You believed, recognizing that you don't know what's in his head, but you believe that he believed the same thing that you believed, right?
Yes, sir.
At some point during this meeting with Ken Paxton, after you had met with Nate Paul, I think it is then that General Paxton says to you, get me a wedding copy of the search warrant, right?
He said that after we got back from the press conference and I was getting ready to go.
That the same day?
Same day.
Okay, so...
He did say that.
And they probably understood it after Mr. Harden explained it, but just so that I'll be on the same page with it, a wedding copy is a copy that is actually signed with ink by a judge, right?
It would just be the original document.
And your understanding of why a wedding copy was important is it could, if not definitively, then go a long way in establishing whether that warrant had been improperly altered or not, right?
Yes, sir, that was my understanding.
And the words of General Paxton to you, I think, were along the lines of, if you can find me a wet ink copy of this search warrant, that's all I need, game's over, right?
It was, if the wet ink copy is the same as the PDF document that was provided to Nate Paul and his lawyers, if they're the same, then it's over.
It's
If
over,
there's-
meaning he would be satisfied.
Would be satisfied with that, and if they were different, then obviously this thing's going to take a little longer
Okay.
to figure out.
Now, did General Paxton ever pressure you to find a given or a specific result?
With respect to the my ultimate conclusions about what I thought happened?
Yes, sir.
No, he never pressured me one way or the other.
He didn't say, you got to do this, dude. I need one. I mean, if you get this done for me, you got a big job. I mean, there was never any suggestion of you engaging in any sort of impropriety or a request for any sort of impropriety on the part of General Paxton. Agree with me?
I agree with that.
Did he use verbiage like, look, I just want to know the truth. Just tell me find the truth in this thing. You remember that?
I do.
And when was it, Mr. Kamek, that General Paxton first told you, I just want to know the truth, or find the truth?
That would have been in our first meeting on August 26th when I first went out for the job interview.
So to be clear, before you were ever hired, that was his directive to you. I just want to know the truth. Find me the truth.
It was, yeah, I just want to know the truth, and if something happened, that would be an injustice.
Okay. Now, there has been a lot of discussion, Mr. Kamek, about evidence and what's not evidence and that sort of thing. At the time that you first met with Mr. Paul and Mr. Wynn, do you believe they gave you at least some type of evidence for you to begin an investigation in good faith based upon?
They gave me, they told me the story about what happened, and I took some handwritten notes, and then when I left there, I was given like this timeline of events to kind of, I guess, help me digest everything.
Okay. And so you set about doing what a lawyer should do, that is investigating, right?
That's right.
And you could have done a number of things in this investigation. I assume one of the things you could have done is knocked on doors and started interviewing people, right?
Yes, sir.
But you didn't do that, if I understand it correctly. Instead of knocking on doors, if I'm understanding what you did, you issued subpoenas or chose to have grand jury subpoenas issued, right?
Yes, sir.
Would you agree with me, Mr. Kamek, that the very intent and purpose of having the grand jury subpoenas issued was for you to be able to obtain that information without causing any alarm or concern on the part of the people of whom you were seeking the information?
That is correct.
All right. So for a week and a half, we have heard, oh my God, the grand jury subpoenas would intimidate these people and frighten these people and scare these people. It was exactly 180 degrees opposite from that. Your intention was to do the exactly opposite of that, right?
Can I explain that?
Yes, sir.
But yes, sir, to answer your question, when I spoke with Mr. Paxton about the idea of grand jury subpoenas, he said it was a smart idea because some of these individuals were people in positions of power, and this would be the most discreet way to get that information.
So if I'm understanding that conversation, then not only did you believe that was the most discreet way to obtain the information without alarming or frightening somebody, so did General Paxton, right?
Yes, sir.
Can we break now? Is that okay?
Members, we will stand at ease until 3:30, so a 25-minute break.
Well, we have been listening to the testimony of Brandon Kamek, who was hired by Attorney General Ken Paxton to be a special prosecutor for the AG's office to look into Nate Paul's claims, and certainly some interesting testimony he is giving us today.
Where to start? I mean, I have to tell you, Ashley, one of the things that was so striking to me is the degree to which Kamek describes acting at the direction of Michael Wynn, who is the attorney for Nate Paul. And perhaps one of the most striking things, well, there are actually several. Number one, this notion that Kamek drafted 30 to 40 subpoenas that he emailed to federal employees, federal agents, others as well, based on a list that had been drafted and provided by Michael Wynn, Nate Paul's attorney. And then as part of this quote-unquote grand conspiracy that Nate Paul apparently came up with, there's this idea that a former federal clerk, an assistant federal clerk who worked at U.S. District Court, possibly died under suspicious circumstances, and Brandon Kamek went to her home and talked to her husband, the widower. Yeah, I mean, like, what's going on?
I mean, it's really, and we want to take a step back, and we had Austin Attorney James Wood here with us earlier, and so just to talk about how unusual it was that Wynn was sort of feeding this information, feeding these lists, feeding these documents to who was supposed to be a special prosecutor. So Michael Wynn in and of himself is a former federal prosecutor who is now in private practice, and he solely focuses on white collar crime. And so he's Nate Paul's attorney and helping, in the construction of these claims that have been characterized by other attorneys, whistleblowers, these claims that they say are insane,
ludicrous, crazy,
that there was just no way that there was a conspiracy with magistrates and federal agents, clerks, and U.S. attorneys, and now a clerk who suspiciously died,
according to them,
to conspire against Nate Paul. And what we haven't heard is for what reason.
Yeah, exactly. I mean, I think that's definitely one of the kind of jaw-dropping moments of the day. Rusty Hardin didn't spend a lot of time on that or really develop that whole string, which I think, judging by his questioning, Hardin also believed that it was kind of a crazy notion. Actually, I also just want to point out, several other sort of headlines that came out of Kamek's testimony, and that was just, again, sort of talking about the degree to which he was in touch with Ken Paxton and the degree to which Ken Paxton was either overtly approving or tacitly approving everything he was doing as part of his investigation.
In fact, just before we went to this break, he says that he told General Paxton that he thought about, because in carrying out this investigation, he could have gone and talked to people and interviewed them, but Kamek himself has said he's never done one of these types of investigations before. In fact, he's never prosecuted anyone in his legal career. He'd been 5 years into his legal career at this time. He's a defense attorney. So has never worked as a prosecutor. He didn't really know how this worked. And so he told Paxton that he was thinking about issuing grand jury subpoenas because some of the people that they wanted to talk to are federal officials. They're high-ranking federal officials. And in order to not cause them alarm, he thought he would issue a subpoena, and that would be a better way to go about it. And he said that Paxton told him that that was a smart idea, that yes, you should move forward with that. That's a smart idea. Now, we know that those grand jury subpoenas were what triggered aides in Paxton's office to send Kamek a cease and desist.
Not one, but two.
Not one, but two cease and desist letters, because again, he's submitting these grand jury subpoenas as a member of the Texas Attorney General's office. And they're like, whoa, 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 we've got to tell him that, in fact, when they were on the stand, because his age and his experience has come into question, they said they were calling him the kid. And, oh no, the kid is serving subpoenas. We've got to tell him to stop.
And then as part of that, Kamek describes going to the boss, Ken Paxton, and saying, what's up? And Ken Paxton saying that Jeff Mateer, who issued one of the cease and desist letters, Jeff Mateer, former first assistant, one of the whistleblowers, that essentially Paxton said Jeff Mateer doesn't have any authority over this. You should continue your investigation.
Yeah, and he's saying that this conversation, there was a conversation where he was actually called from Houston. The Attorney General Paxton called him while Kamek lives in Houston. While he was in Houston, told him to drive to Austin to come to Nate Paul's house. And while they were at Nate Paul's house, it was Paul's house. They were all there. Paxton was on the balcony talking on the phone, but
running shorts or athletic shorts and tennis shoes. Yeah.
So a casual, sort of meeting at Nate Paul's house. Michael Wynn, he said, was in a suit along as he was in a suit because he assumed this was a business where you with your engagement, don't ignore those cease and desist letters. But this is all happening also. We have U.S. Marshals showing up
to Kamek's office.
In Houston to question him, and him calling the Attorney General and saying, what is that about? We learned in cross-examination that those U.S. Marshals were there because Kamek had gone to talk to the widower.
To the lady's house, the clerk's house.
To the clerk's house. And again, you said, well, why are you going to the clerk's house? What is this all about? Well, this all goes back to the conspiracy that Nate Paul believed was happening against him, that, they were federal agents. Nate Paul believes, so we have been told by multiple people, because obviously we have not heard from Nate Paul, that when they were issuing those search warrants on his properties, they were initially looking for drugs and guns. And after about 2 hours, when they didn't find that, they changed the search warrant on the fly to look for white collar
financial records.
Right. And so you would imagine that in order for that sort of thing to happen, there would have had to be a lot of people involved. And so you had Kamek, trying to prove this out. And at one point he talks about Microsoft and trying to look at if there were phone messages and text messages and emails sent between all the people around this time to see if that document had been changed. And certainly the clerk of the court would know something, but she's now dead. And now you have Michael Wynn and Nate Paul saying, yeah, she's dead, but there's foul play. She didn't just die of natural causes.
It was honestly, so much of what we have heard as part of this testimony. Yes, there have been sort of new twists and turns, but the underpinnings, I think, have largely been out there and, reported on and dissected in the public. But that was definitely a strange twist.
I don't think anyone saw that coming.
Yeah, exactly. And then, Ashley, Kamek takes us to this kind of other weird meeting. He describes it as weird. When he is summoned to a meeting with Brent Webster, who by that point, this is in October of 2020, who by that point is Paxton's new first assistant. Mm-hmm. And he talks about how he walked into the AG's office, but instead of meeting in a more professional environment, they wanted to have a meeting at Starbucks. And that's where...
And they drove him.
They drove him
to Starbucks, and it was Brent Webster and Ken Paxton and several other men who Kamek said he didn't know. And then...
It's like the breakup meeting.
I think we've got a new name for it.
Exactly. It was the breakup meeting.
At Starbucks, where they said, okay, your work is done.
Yeah. Actually, you don't have a real contract.
Well, yeah, and so that, I mean, this has really been a point throughout this whole thing, because Ken Paxton in Article 5 is alleged of violating the law, misusing his power to violate the law to even hire Kamek. And Kamek also talked about, before we even get into that, Tony, he talked about the contract and that he had gotten a contract from Ken Paxton's office. And there was a point in his investigating where he felt like he needed credentials. He needed the ability to say who he was with. And he mentioned to him, well, my contract isn't even signed. And he said he made that comment to Michael Wynn. And Michael Wynn called him over to his office. And then Michael Wynn had his employment contract just sitting on the table.
Bada boom, bada bing. All of a sudden there's a
signature from Ken Paxton on the employment contract, which we've heard the other top aides in the office explain. Ken Paxton does not sign the employment contracts for attorneys within the Attorney General's office. That's just not the procedure.
So then you see and hear Michael Wynn talk about during the breakup meeting, where they essentially say, never mind, you don't have a real contract with our agency. And Michael Wynn says, oh, okay, well, what about my $14,000 fee? And they basically say you're going to have to eat it.
So not basically.
You're going to have to eat it.
Brent Webster told him, you're going to have to eat that $14,000.
It's the cost of doing business.
Yeah, hey, I've had to eat $40,000 before. And you listen to what Kamek describes as just the disrespect that he felt, because before during this hiring process, he said they agreed to his fee schedule and what he was going to do. And he noted, earlier that he had what he said, quote, I had a life before this, that he had clients, that he had a business and a practice that he himself was running. And he said, I didn't I didn't reach out to you. Y'all reached out to me for this. And that goes, again, that harpens back to the testimony about his hiring. I mean, so he's saying that he received a phone call from an anonymous number to even tell him about this position that was open at the Attorney General's office, and that he needed to get a resume together. He said he hadn't gotten a resume together in some time, but that he got a resume together and then submitted it. And then the other thing that I think brings us all pause and makes us all wonder is that during that hiring meeting that he had with Ken Paxton, he says that Attorney General Paxton told him Michael Wynn, Nate Paul's attorney, is who recommended him to Paxton
for this position,
and that they did not truly know each other. They served together on a board, but outside of that work, never had conversation, never really talked and worked together.
Though I think Kamek does establish that while he did not know Michael Wynn, he did have a reputational respect for him.
Because he's a former federal prosecutor, and so he knew who he was, and he knew of him, and certainly sitting on a board together, you hear someone speak, you see the work that they're doing, so understandable that you could have respect
and you
for
can
a
tell
person.
that there was something, because of that, something of a deference to Michael Wynn. So for example, Kamek talks about when he did the email subpoenas, about 30 to 40 of them, but then in addition to that, he decided to personally serve some of the subpoenas as well. On banks and other financial institutions. And so he's in Austin, Wynn's in Austin. He gets a call from Wynn the night before who says he wants to tag along with him as he goes and serves these subpoenas. And I think it's an important moment kind of showing Kamek's deference to Wynn, because Wynn is like, I want to go, let me go with you, and he
initially said, no, I don't think that's a good idea.
Yeah, he did.
That's strange. But then, Wynn told him, but they may ask you something about Paul's finances, and I need to be there.
I need to be there. Yeah.
And so he just said,
his exact quotes. Yeah.
He said, okay, at that point.
According to Kamek, he said, you don't really need to do that, meaning go with me. I don't think it's appropriate. And he said, I am Nate Paul's lawyer, and it's important for me to be there. Kamek said, I felt a little pressure to say okay, and he went along with me. Kamek went on to say, I wanted to do a good job, and I trusted Michael.
Yeah. powerful there, because his desire to do a good job, I think, has been made really evident. Him saying statements like that, because he respected Ken Paxton and he wanted to do well and he wanted to do.
It's going to be a big break.
This was going to be huge for him, as you would imagine for any young attorney, to be called on and then have
directly by the Attorney General.
And then to have this access to the Attorney General of Texas, the state's top law enforcement officer. You now are having phone calls. In fact, before our lunch break, he talked about getting a separate phone that he gave the number to Ken Paxton, so that anytime that phone rang, he knew that it was Ken Paxton calling, and he knew he needed to answer that
And
phone.
the reason he said he did that is because every time Ken Paxton called, it was like from a strange number that came up as scam. Spam. Thank you.
Yeah, that he was calling him on 2 different phone numbers, and he was also receiving a lot of spam calls at the time, and so he wanted to make sure he always
never missed a call from Ken Paxton.
But when we talk about that and the way that he was communicating and the access that he was granted to the Attorney General of Texas, he talked about that he had never received an official an email from Ken Paxton from his official email, which, as I'm saying this now, makes me think back to the employment contract and the fact that employment contract that they then said doesn't exist didn't come from Paxton's original email. That the only email he got, he didn't even know there was an
OAG.state.gov
email, that he didn't know about that email until he received the cease and desist letters from Paxton's staff, and so that they had been emailing with the Proton mail, which we know is a more secure email server, that they were texting using the Signal app, which is a fully encrypted text message, and that was at Paxton's request. Kamek, and I have to say Kamek, I want to say it intentionally because they finally asked him how to pronounce his name, and he says it as Kamek, that Paxton asked him to use that text messaging app to communicate with him.
And I got to tell you, Ashley, I've been around, any number of investigators just through years of covering them. They do not communicate in these, obscure, off the record kind of ways. In fact, to protect the integrity of the investigation, they often communicate in very practiced and straightforward ways. For example, logging information into an offense report, into case notes, and things like that. Certainly.
And so then even this idea that he was just working, Tony, at this point to make a report for General Paxton, that's sort of, what it came down to, what he was being asked to do, which is different from what he initially thought he was being asked to do. I also thought it was interesting, and this is something that we saw happen with Ryan Vassar, a young attorney who was in the AG's office. So they did this with Vassar, and then Dan Cogdell did this again with Brandon Kamek, where he actually pulled up the article of impeachment as it is directly related to Brandon Kamek, read it line by line, and asked him, well, did the Attorney General do this? Well, did the Attorney General do that? And I bring that up because it's an interesting strategy, I think, to present to a witness what is ultimately supposed to be the decision of the senators.
Yes.
It is up to the senators to decide whether or not that's a question for the jury. But he's presenting it to these, I would say, younger witnesses, because that's just factual. They have testified. Everyone who has testified about their ages, and the 2 witnesses who are in their 30s compared to people in their 60s. And 70s, David Maxwell,
exactly.
Asking them that, and so their answers have also been interesting, because their answers are, well, no, in the way that it's framed, and the way the questions are framed to them, it's, well, no, that's not what it was. Well, no, and so you think about proving this case beyond a reasonable doubt. And if you're poking holes, so for instance, one of the first line of Article 5 is that Ken Paxton, while holding office as Attorney General, Warren Kenneth Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro tem. And so,
but that pro tem, circle that.
That is the big thing, because again, he's saying he was being hired to be a special prosecutor. And so you heard Dan Cogdell say, well, you weren't hired to be an attorney pro tem, were you?
So then this article is an acquittal. Yeah.
Yes, and then he said, he went another line. Specifically, Paxton engaged Brandon Kamek, a licensed attorney, to conduct an investigation into a baseless complaint.
So
and
then
there.
like, Mr. Kamek, did you believe you were investigating a baseless complaint? And Brandon Kamek said, no, I thought I was investigating a legitimate complaint.
And he said that when he listened to Michael Wynn and Nate Paul sort of present this case, he thought it was compelling and convincing are the words that he's used, and that he told that to Ken Paxton and that Paxton agreed with him that this was convincing.
As he listened to their story, that he thought that there could be some legitimacy here that needed to be sorted out.
And I think that raises the point of, and this makes it hard, that to conduct an investigation into a baseless complaint without Ken Paxton taking the stand, we don't know. And certainly the testimony that we've heard would show that Attorney General Paxton believed this was
100%.
This was a genuine complaint. He believed that he had been wronged by the FBI. He has made those statements, not the FBI, but by federal law enforcement and DPS.
And state law enforcement.
Right, and state law enforcement. And so he believed and said to his top aides, and those aides have repeated here in sworn testimony that he said, I don't want what happened to me to happen to another Texan. And so this idea that this was a baseless
complaint, it was absolutely legitimate, according to
in their mind, this was real.
Yes.
And so I think that if I'm a senator going back and looking at this and having to say beyond a reasonable doubt, as you say, if you are inclined to acquit Paxton, I think Dan Cogdell is certainly giving you.
And again, when we talk to Paxton supporters, members of the Republican Party, particularly the faction of the Republican Party, the ultra-conservatives, they are delighting in these kinds of question, this line of questioning from Dan Cogdell, and they believe that Paxton's defense team, one by one, is dismantling the testimony of each and every one of these witnesses who has come to testify.
Yes, certainly they believe that it is open and shut to them. That it is very clear that he is not guilty of the things that are specifically alleged in the articles of impeachment. However, that brings into question the final 4 articles, which are not as specific, which are
those catch-all.
Those are the catch-all
I think
articles.
the article about the discredit into the Attorney General's office is a compelling one.
Absolutely. You're talking about Article 20, which is the abuse of public trust, which alleges that Paxton brought the office of Attorney General into scandal, and that he obstructed fair and impartial administration of justice, and that he misused his power to subvert the lawful operation of the government. And so I think when you start to look at those overarching themes, I mean, even article, let me see what number this is, article number 18, which is that he violated his oath by engaging in acts described in one or more articles. So even if you believe he just did one thing that's in the article.
Yeah, I mean, then that's a conviction. And as we have pointed out a couple of things numerous times, but a conviction on one single article is a conviction. Ken Paxton does not have to be convicted on every single article to be convicted and removed from office.
And we want to note those two things go together. Convicted and removed from office go together. You are not convicted and then get to remain in office. It's just you're convicted.
And there's no little bit convicted.
Right.
You either are or
you are or you are not, and it's a vote of a 2/3 majority, so 21 of the 30 senators who are voting in this, and so that's notable because when we go into deliberations, it's not as though the jury has to all agree on whether or not.
Unlike a criminal trial where there has to be a unanimous verdict.
Right. It's and we know it's not. We know going into this, it is not going to be unanimous.
Though it might, and this is a big might, we will see, it might be along party lines.
I think it could certainly be along party lines. I think that there is a lot of political pressure from PACs and from other powers that be outside of this room. And, generally, the Republican Party, the Republican senators like to stand together, like to send, a message, if you will. However, that's during legislation.
And it was not the case
during the motions.
They did not stand together during the motions. And if you want to go back even further, they did not stand together in sending forth the House. This would be the House. Did not stand together, Republicans and Democrats. The Republican Party did not stand together with regard to votes on sending those motions out of the House.
No, you saw your ultra-conservative Republicans vote against impeachment. The vote was 121-23, and I say your ultra-conservatives, it's worth noting, some of the ultra-conservatives did, in fact, vote to impeach.
Yes, that
Briscoe
is, well,
Cain
yes, exactly.
and Jeff Leach.
Yes.
And, even the chair, Andrew Murr, these are not...
But really, Briscoe Cain, like a major
right.
conservative.
When you talk about the Liberty PAC as it first started, he was one of the founding members of the Liberty PAC in the Texas House of Representatives, and one of the remaining members that they have started to, I would say, distance themselves a bit, him and Jeff Leach, from that when you had other ultra-conservative members joining. I'm trying to not name names.
Yeah, fair enough.
When we're saying this, to sort of start to, in this past session, we saw them really start to distance themselves from that group. Particularly, we had a representative who was removed from office and barred from ever serving again for his action.
But politically, within that deliberation room, when those senators, particularly the Republicans, gathered together to decide how individually they are going to vote, I think part of the calculation they will make, Ashley, though, is the degree to which, if they want to vote to convict, they are on an island themselves. Is there enough cover for them is there enough political cover to say that, well, other Republican colleagues did this voted to convict as well? Or are they, potentially on an island themselves, in which case that would not be a position they likely would want to be in?
Well, and Tony, when you think about political ramifications of this potentially for the senators, they have some time before they themselves are up for re-election. So when you think about that aspect, if we're talking about, they don't want to upset voters or they don't want to feel the effects of this at the ballot box, the Republicans in the House, that is coming up for them as to whether or not their terms are for 2 years. The senators' terms are for longer than that. So it's different. And you certainly aren't going to take out all of the Republicans in the House who voted to impeach. And so,
and typically speaking, it's hard to oust an incumbent.
Sure it is. We do not typically see that happen.
Can Paxton votes or not? Yeah.
Right. And so I think that, in terms of if you have Republican senators who do wish to vote to convict, and if all of the Democrats vote to convict, you just need 9 of them. Do they have enough distance between now and a future election that voters would have forgotten about this? Because by that point, we will have a new attorney general and presumably a new Republican attorney general, just if we're looking at how long it's been since a Democrat has won a statewide office in Texas. And so if you have a new sitting Republican Attorney General who is, by all of their accounts, doing a good job, and then
all may be forgiven, or at least some may be forgiven.
And even if they can say, well, we got rid of someone who was corrupt, and we know that there is a, basically after this impeachment is over, we expect to see some movement on Paxton's securities fraud charges that have been hanging in the balance
since
for what,
8 years, 2015.
And as well as the impeachment articles related to those 4 charges, because we still have 4 articles of impeachment that also have to be right. And so depending, whether or not they vote to dismiss those articles based on the outcome of this particular case is something else to be settled.
Exactly. And as we take a live look now on the Senate floor, you can see those senators are making their way back to their seats. We've probably got another 3.5 hours of testimony, maybe as long as 4 tonight. We will likely conclude with Brandon Kamek in the next little while, and then giving time for the state to the House impeachment managers to possibly call another witness. But Ashley, as we've been talking about, just looking at the clock, it's also conceivable that they would rest their case after Kamek.
Well, I don't agree with you on that.
Okay, all right, fair enough.
I love when we can agree to disagree, because they still have to prove the bribery charges.
But they are going to start having a timing issue at some point.
They are going to have a timing issue in that. This morning when they started, they had 9 hours left. 9 hours and I believe 19 minutes of time left. And this is compared to the defense, which had 12 hours. And this is where you have to think about the strategy of this, because up until this point, we've talked about all of the articles except the constitutional bribery
which is, by the way, a huge one, and the one that, at least in the public court of public opinion, the bribery charges have helped tell this story.
Sure, because it gave a why. It answered the question, well, why is Paxton doing all of these things for Nate Paul? And the answer is, as is alleged by the House, well, because Nate Paul hired Paxton's mistress so that she could move from San Antonio to Austin to be closer to him, and Paul paid for renovations to the Paxton's home in Austin. And so we have not heard testimony speaking to those
we truly have not.
Articles. And so I think we at least are going to get one more witness, but I think we could end the day, honestly, on Kamek. I think between the cross and then the redirect and then the direct and then the redirect and direct, I think that could happen. You're seeing now Lieutenant Governor Dan Patrick coming back onto the floor.
And there is Kamek taking the stand. So let's go back to the Senate floor.
You may resume, Mr. Goudeau.
Mr. Kamek, by my notes, I'm about halfway done, but let me see if I can speed this up and get you.
Mr. Goudeau, would you raise your mic up? There you go.
Yes, sir.
We had you talk a little bit, Mr. Kamek, about the grand jury subpoenas and the reason for that. At some point, I think I heard you discuss with my colleague, Mr. Hardin, that Paxton made a statement to the effect that he was being critical of Mr. Penley and Mr. Maxwell because they won't do any work. Do I recall that correctly?
I don't remember the exact question that was asked by Mr. Hardin.
Do you remember back during this time, that is back in September of 2020, that happening, that is Mr. Paxton being critical of Mr. Penley and Mr. Maxwell, believing that or stating that they didn't do any work?
Wasn't critical in the sense that like he gave me any detail about what they were or weren't doing. He just said that he couldn't get the people at his office to do what he was asking them to do.
Fair enough. Now, there are different ways of conducting an investigation. You'd agree with me?
Yes, sir.
There are all kinds of different tools that law enforcement can use, TCIC, NCIC, every initial in the book sort of stuff, right?
Yes, sir.
And even lay people can do computer searches, Google searches, Intellius, Truth Finder, LexisNexis, all that sort of stuff, right?
Yes, sir.
Are you literate on LexisNexis, or were you at the time?
Yes, but more proficient in Westlaw.
Okay. And Pacer, do you do much work on Pacer?
No, sir, but I'm familiar with it.
And Pacer is public access to computer electronic records, something like that?
I believe so.
Okay. May I approach, Your Honor?
Yes, you may. And the witness, if you can speak up, Mr. Kamek,
Yes, Judge.
make sure all of our senators can hear you.
Yes, sir.
Acoustics, not your fault. Acoustics aren't the best. And some of our hearing collectively is not the best either. So. Hold on, get back to your microphone. There you go.
Yes. I'm showing you what's marked as AG Exhibit 1047. And I don't know that you've ever seen this, but I'm going to see if I can walk you through it. I would offer AG 1047, which is a docket sheet on the Contigo matter.
Any objection, Mr. Harden? Sure.
If I may, please.
Take your time.
No objection. No objection.
No objection. Admit to evidence. AG Exhibit 1047.
All right, Eric, if you could kind of blow up the top, and again, I'm just using you as my ventriloquist right now because I don't think you've ever seen this, or tell me if you have. Have you ever seen this before?
No, sir.
Eric, blow up the top of it, which says, obviously, the style of the case, which is Contigo Information Management. Are you familiar with that name, Contigo Information Management?
Yes, sir.
And that is one of the entities, is it not, Mr. Kamek, that Mr. Nate Paul was complaining that an illegal search may have potentially occurred at that place right there, Contigo, right?
Yes, sir.
Now, if you will go to the second page, Eric, of 1047. Well, let me go back to the first page, my bad. And on the first page, it shows, does it not, that Judge Mark Lane is the judge in this case, right? Upper left-hand corner, Mr. Kamek?
Yes, sir.
That's obviously public information. And that Mr. Gupta with the U.S. Attorney's Office is representing the government, right?
Yes, sir.
So the whole world can see that based on anybody that has a Pacer account has access to that sort of information, right? Now, if you could go to the second page, Eric, and what that shows, give us the top half of that page. And what we see, do we not, Mr. Kamek, is there's a motion for leave to disclose sealed search warrant that was filed on September 5th, right?
Yes, sir.
And an order granting that motion for leave to disclose a sealed search warrant, right?
Yes, sir.
So that would allow, and that was granted on the 5th, and then it is closed again on the 17th, where someone files a motion to extend the sealing, right?
Yes, sir.
But for those, whatever that is, 12 days, that search warrant would have been the warrant, not the probable cause affidavit. And they probably understand by now, but I know you do. There's a difference between the search warrant and the search warrant affidavit, right?
That's right.
But the search warrant would have been visible via Pacer for those 12 days back in September. Again, anybody with a Pacer account could have logged in and looked at that at least during those 12 days. Agree with me?
It was not sealed during those 12 days.
Fair enough. Now, when you were working on this matter, did you ever see, Mr. Kamek, any evidence that Mr. Penley or Mr. Maxwell had done anything in terms of investigating the same complaints that you were investigating? Meaning, did you see any reports, any memoranda, any conclusion, anything?
No, sir.
It is possible, is it not? Let's say that I want to investigate whether or not a given prosecutor might have at least been accused in a pleading of doing something improper. You or I can get on Pacer and enter that person's name and pull up every case that lawyer's ever been assigned to, right?
Yes, sir.
And they can do the same to us as well, right?
That's correct.
But if we wanted to investigate whether or not a given prosecutor was doing something, we could look at their history, or at least their history that's visible on Pacer, right?
That's right.
Same with the judge, correct?
It should be public record.
Now, let me be Captain Obvious because it's a cape I wear a lot. Every single search warrant that is a bad search warrant was signed by a judge somewhere, wasn't it?
Theoretically speaking, it.
Okay.
Yes.
Well, I guess my point is, if someone is arguing, well, a judge signed it, therefore it must be good. Well, if it's a search warrant that was executed, chances are a judge signed it. That doesn't necessarily make it a good search warrant. It's just one more search warrant that one more judge signed. Agree with me?
I agree with that.
I think we heard you testify that Mr. Wynn, during, I guess, the latter part of September, stated that Penley had reached out to him out of the clear blue and asked for documents. You recall that?
Yes, sir. That's what I was told.
Do you know when Mr. Kamek ballpark that was?
It would have been, I believe, sometime in the fourth week of September 2020.
Okay, so if you were hired on September 4th, you had been working on this case for several weeks, or this investigation for several weeks by the time you heard that. Agree with me?
Sir, approximately 3 weeks.
Okay. Now, let's get into the time. Mr. Harden had you walk through sort of the frequency of contact that you had with Mr. Paxton during this, and it was about a month. That's probably the easiest way to describe it, is about 30 days, right?
Yes, sir.
And Mr. Harden had you describe your contacts with Agent Paxton, and I think you said, 15 to 20 times, something like that, right?
Yes, I did say that.
And during that month or so period, you saw him a grand total of how many times face to face? 2 or 3?
Well, I can tell you the days. So the 26th was
Okay.
one time. September 4th was the second time.
Right.
Then there was the time at the end of September at Nate Paul's house.
That's 3.
And then there was another time when I drove out to meet with him and Brent Webster.
That's 4.
And then there was another time when we met at the Starbucks.
That's 5, right?
That's 5 times.
So let's use as a demarcation, artificial or not, I'm going to call it when the stuff hit the fan, and that is September 30th or October 1st, okay?
Oh, yes, sir.
So before the stuff hit the fan, and we're going to get to there, you had seen him a grand total of 3 times. That is Mr. Paxton, right?
2 times.
2 times, okay. Now, you said, I think in reference to a question by Mr. Harden, that you had talked to him 7 to 10 times on the phone, something like that?
Yes, sir.
and there were some occasional texts as well, right?
Yes, sir.
Would you agree with me, generally speaking, Mr. Kamek, that those phone calls are generally short, to the point calls?
Yes, sir.
Do any of them stand out in your memory for one reason or another? That's not meant to be a trick question. That's just an open-ended question.
I'm just thinking about what stands out in my mind about the conversations.
Okay. Let me keep going, and if it comes to you, we'll come back to it.
Okay.
Fair? Would you agree with me, Mr. Kamek, that Mr. Paxton has, General Paxton, whatever we want to call him, has a, let's say, unique style of communication? I'm sure it's not exclusive to him, but what I mean by that is when he wants you, he reaches out to you and you're generally accessible, right?
Yes, sir.
But the reverse isn't always true. When you need him, it ain't always, he doesn't pick up the phone as quickly as you pick up the phone.
I would agree with that.
Okay. And you had 3 or 4 of these occasions where you were saying, look, Mr. Paxton, or look, General Paxton, I need an email address and I need some identification, or I need a badge or something, right?
Yes, sir.
And the response that you get is more or less, yeah, I'm working on it, yeah, right?
Yeah, I mean, every time that was kind of the
Fair
response
enough.
that I got.
And you would also agree with me that just about every time you're in the presence of General Paxton, he's either on the phone some of the time or on the phone all of the time. Is that fair?
The first 2 times that I met with him, it was not on the phone.
And those were the interview, right?
Interview, and then the second time that I went there.
Yes, sir.
And then after that, he was on the phone quite a bit.
In your mind, I think, not unlike perhaps others, he's kind of notorious for being on the phone when you need the man's attention. That's just how he rolls. Agree with me?
I didn't know him before all this.
I'm just talking about your experience with him.
Just figure he was busy.
And he is, as far as you know, right? Now, let's get to, speaking of busy, let's get to that point in time, Mr. Kamek, when you were asking for a signed contract and you told Michael Wynn you hadn't gotten the signed contract, and I think that was the night before, and then you roll into Mr. Paul's office the next morning, leaving at 5 or thereabouts, and lo and behold, there is a signed contract on the desk or at Nate Paul's office, right?
Yes, sir.
Do you know whether or not, Mr. Kamek, that on that date that Mr. Paxton was out of town? You know one way or the other if he was?
No, sir.
Okay. Would you agree with me that based upon your observations of the man, he traveled frequently? Agreed?
There was at least one other time, yes, sir, that he said he was traveling.
Okay, so let's jump to the second, and again, I'm going to be quick running through these, but we've talked, generally speaking, about the first referral that you received from the Travis County DA's office, right? And that is the complaint about the search warrant.
Yes, sir.
Not too long after you're involved, you get this second complaint, right?
Yes, sir.
And that complaint is referred to you directly. It is mailed to your office, right? Somebody find that for me, a copy of it, the second complaint.
I believe it was emailed to me from Mr. Klimmer.
Okay, whether it was emailed or mailed, my mistake.
Yes, sir.
It was sent to you directly. Agree with me?
Yes, sir.
And if someone were to come in here and state that Travis County DA's office had no idea who you were or what you were doing, and you were just some sort of ghost out there in space, you would disagree with that, would you not?
That would be a falsehood.
And in fact, Mr. Klimmer knew exactly who you were and where to find you, right?
Yes, sir.
And can you estimate for us, Mr. Kamek, how many touches, for lack of a better description, how many touches you had with employees of the Travis County DA's office? And when I say touches, I mean interfaces, emails, phone calls, personal visits. How many touches are we talking about?
Well, and it's no disrespect to the folks over there, I just don't remember everyone's name.
Of course not. I'm not giving you that pop quiz. I'm just asking to estimate it.
Yeah, so I spoke with one individual who referred me to Don Clemmer, and then I think there was another woman named Amy Meredith, maybe.
Okay.
And then I got referred to a woman named Bailey.
So that now we're up to 4, right?
I think we're at 4, and then from there were multiple
repeat visits.
Well, just back and forth on an email exchange about the subpoenas, and then 5 or 6 times there, like with Mrs. Molnar, and then I got that other referral from Mr. Clemmer directly.
So if we are counting each subpoena as a touch, we've got 35, 40 subpoenas?
Well, I sent them on the application, just multiple per, just sent them out. There were several emails to their office.
I'm interrupting you. I'm sorry. I apologize. But there were several tranches of subpoenas sent to the Travis County DA's office.
Yes, sir. I agree with that.
And there were several people you communicated with, right?
Yes, sir.
Some were staff and some were lawyers, right?
Yes, sir.
And at least in your mind, Mr. Kamek, they were well aware of who you were and what you were doing, right?
Yes, sir.
And you certainly never tried to hide that fact from anybody. When you were working with the Travis County DA's office, you told them who you were, you told them your job description, you told them what you need. It's not like you were hiding, right?
I was not hiding.
The second complaint is different, Mr. Kamek, in kind, is it not, from the first complaint? Meaning, the first complaint is, may I approach, Your Honor? And just to satisfy, of the second complaint, correct?
Yes, sir. That's the second referral.
So again,
I'm sorry, Mr. Kamek, I really need for you to speak louder when you're answering, because I know.
Yes, Judge, that's the second referral.
and again, like the point I made before you saw the document, although I don't think there was a dispute about it, that was sent to you directly with your name on it, with your address on it. Clearly they know who you are, right?
Yes, sir.
Okay. Now, the first complaint, again, focused on the potential illegality of the search warrants. The second complaint focused on a alleged fraud concerning people trying to steal my words, not the complaint word, Nate Paul's property too cheaply, right?
Yes, sir.
And I believe, correct me if I'm wrong, but you utilized the resources of the Travis County DA's office to issue search warrants, or I'm sorry, grand jury subpoenas for the first complaint, correct?
Yes, sir.
And you did the same thing with the second complaint, meaning part of the thing that you did to investigate it was send out grand jury subpoenas to try to obtain information, correct?
Yes, sir.
Now, I think I heard you say, Mr. Kamek, correct me if I'm wrong, that you were not keeping General Paxton apprised of the names of the individuals that you had issued the grand jury subpoenas before, right?
I never spoke with him about like who specifically I was issuing subpoenas for, but that's not to say that I don't remember if I had forwarded an email list or something like that.
Fair enough. It's possible that you sent him on one or more occasions a list of folks that, or some sort of detail on names, right?
That's possible.
Not certain one way or the other if it happened, but it's certainly possible.
As I'm sitting here right now, I don't recall that.
Fair enough. But you didn't, in any conversation, as far as you can recall, Mr. Kamek, get so granular with General Paxton about the names of the people that were being subpoenaed that you said, well, Joe Smith on this day, Bob Hunt on that day, Travis Smith on the other. That didn't happen, right?
No, sir.
And I assume it is a safe bet to say that if you sent General Paxton an email containing a list with names on it, you don't know one way or the other whether or not he opened that email and read through it and assimilated or understood what was in it or not. Agree with me?
I'm sorry. Could you just rephrase that one for me?
That's a $500 question. I don't know why I ask it that way. You don't know if he ever opened up any email you sent to him and read it or not, right?
That's right. I don't know.
Okay. Now, in the in the investigation of the second complaint, did you think your marching orders from General Paxton had changed? Meaning, if I recall your testimony correctly, Mr. Kamek, in the first referral, he told you to go get the truth or find out the truth or whatever, right? I assume you were operating under the same belief system that General Paxton wanted you to do the same thing in the second complaint, correct?
That was my belief and my understanding.
And at any point, Mr. Kamek, that you were dealing with Ken Paxton, did he ever ask you to misrepresent anything?
No.
Did he ever ask you to, for lack of a better description, lie, cheat, or steal?
To lie, cheat, or steal?
Yes, sir.
No, sir.
And I'm including that in a broad sense, not in the literal sense. But also in the broad sense, not the literal sense. Mr. Kamek, never ask you to hide, secrete, destroy. Never ask you to hide any record, conceal anything you did, dispose of anything that you obtained. There was never any suggestion of that, I don't think. Was there?
No, sir.
Now, there was the time when the stuff hit the fan, right?
Yes, sir.
And that was October 1st?
I believe it was October 1st, whatever day that I got a cease and desist letter from Mr. Penley.
Okay. And again, whether it's the 1st or the 2nd, 30th, whatever, you get the cease and desist letter, and what was your reaction when you got that? What was your thought?
I mean, I was shocked. I was confused and felt like a rug been pulled out from under me. And
I heard shocked and confused, and then I didn't hear the last thing that you said.
I just felt like the rug had been pulled out from under me.
Okay.
It just seemed like it came out of nowhere.
And it really did come out of nowhere, if I'm understanding your story, right?
It did come out of nowhere. I had never spoken with Mr. Penley over the course of those 3.5, 4 weeks.
And after Mr. Penley sent you that letter, Mr. Mateer sent you another letter, right?
That's correct.
And this is and he's basically saying, this is unauthorized, you're performing illegal activity, you're whatever. This is the very same Jeff Mateer whose office you sat in interviewing for the job that you took, right?
That's correct.
If I'm recalling it correctly, Mr. Kamek, when you got the first letter from the Penley letter, you responded very professionally, very appropriately, very succinctly. He sends you this cease and desist letter, and what do you reply back?
I think I told him that I would just stand down and something along those lines.
Unlike some other people that you might have heard of, you didn't get volcanic on him. You didn't pick up the phone and slur a bunch of invectives or worse at him, right?
No, that would have been unprofessional.
And to be fair to you, Mr. Kamek, all you were trying to do was do a job, do it well, do it professionally, right?
Yes, sir.
Then it gets even worse because the press starts blowing up, right?
Yes, sir.
And speaking for you, you are a 5-year lawyer, and you have authors, writers, people in the press that you've never spoken to, that you've never communicated with, that you've never heard of, just saying horrible things about you, right?
There were a lot of articles written, and I read a couple of them and then chose just to put that out of my scope of view, just move on with my life.
That was probably a wise decision, but it went into really needless detail about disagreements that you had with your family, and it just blowing everything out of proportion, and it was a nightmare for you, simply put, was it not?
It had nothing to do with anything involved in this. It was just a bunch of trash. I'm sorry.
That's all right. And it was, if you understand the timeline, or I guess if I understand the timeline, I'm asking you if you understand it the same way, Mr. Kamek, that by this point, the so-called whistleblowers had gone to the FBI, and that's when all this volcanic eruption occurred, right?
I'm sorry, could you?
Sure. When the negative press started coming out, it was after the time, at least insofar as what the articles were claiming, that several individuals that used to be with the Attorney General's office had gone and made a complaint with the FBI, or made the so-called whistleblower complaint. Is that consistent with your memory?
I remember reading, I think, about that.
And after this eruption, that is when you drive to Nate Paul's house, right?
Yes, sir.
And I mean, it's just a surreal time, fairly put, for you and for everybody else, right?
Yes, sir.
You go to his house, you had never been to his house before, you're hoping to resolve whatever issues are outstanding. Oh, by the way, you would like to get paid for your work, right?
Right.
And everybody's kind of standing around shell-shocked. When I say everybody, I mean you, Mr. Wynn, your friend or whatever, Mr. Paul, and Mr. Paxton, right?
Yeah, that's who was at that meeting.
And I mean, again, without engaging in hyperbole, it's kind of like everybody's sitting around with PTSD, just like, what the hell was that, right?
Right.
You were asked to continue the good fight, keep working, and in your own mind you say, no, I'm done with that.
No,
right?
That's right, I was done.
Okay. And then you have another occasion that you detailed for Mr. Harden where Mr. Webster and Mr. Paxton asked you to come to Austin. You come to Austin, and it's just as weird as as the time before. You don't go into the AG's office. You go over to Starbucks. Brent Webster says, 15 grand ain't nothing. I had to eat 40 grand. And you're thinking, that's not going to put, Post Toasties in my bowl here. I don't really care. My word's not yours, right?
That happened.
Okay. And to this day, you've never been paid anything, right?
$0.
Okay. And the reward that you have gotten is not really a good reward, right?
I haven't received any benefit from any of this.
Let me let me apologize for that situation.
Thank you.
That should have never happened.
Thanks.
Should have never happened. All that having been said, Mr. Kamek, it is still true, is it not, that what Ken Paxton asked you to do, find the truth.
That's what he told me when we first met. He just wanted to find out the truth about this first referral.
And that's what you were trying to do.
Yes, sir, that's correct.
I'll pass the witness.
Mr. Harden, or redirect?
No, Your Honor.
Or both of you
You can be excused. Good
finished
luck,
with the
Mr.
witness?
Thank you.
Maybe. Thank you, sir.
And we've been listening to the conclusion of the testimony of Brandon Kamek, who was the special prosecutor investigating allegations made by Nate Paul concerning whether or not the FBI and other federal officials and state investigators acted in a corrupt manner concerning the investigation into Nate Paul.
So listening into who they were calling next, the next witness is Joe Brown, is whom they have called. This is a new name to Tony and myself, so we're all going to find out together who Joe Brown is, who is taking the stand. You see Senator Charles Schwartner walking off the floor there, presumably just for a moment as the witness makes his way to the stand. And interesting because we've now heard from witnesses who have talked about all of the other articles of impeachment against Paxton except for the bribery charges. At this point, those are the charges that or the articles rather, that we haven't heard direct testimony to, that Nate Paul was bribing General Paxton to do this work, to carry out this investigation in exchange for a job for Paxton's mistress and renovation to Paxton's home. And so here is Mr. Brown that you're seeing walk in now. He will be administered the oath, the juror's oath to, not the juror's oath, excuse me, the witness oath, to tell the truth, the whole truth, and nothing but the truth. And I think we're all kind of anxious to hear
who he is and what he has to say. It's interesting because so many of these witness names have been public and we know exactly who they are. But here he goes. Let's listen in.
May I proceed, Mr. President?
Yes, you
Thank
may.
you. Sir, please introduce yourself to the honorable members of the Senate.
Joseph David Brown. I go by Joe.
Mr. Brown, how are you currently employed?
I have a private law practice in Sherman.
Could you please summarize for us, albeit briefly, your history as an attorney, your jobs, positions you've held?
I graduated from SMU Law School in 1995. I started with a civil law firm in Dallas, about 100 lawyers, Coles and Thompson. Did that work for about 5 years, returned to my hometown. Ran for district attorney in 2000 in Grayson County, was elected. Spent 17 years as the district attorney in Grayson County, and then I was appointed as the Eastern District United States Attorney in 2018.
Was that a presidential appointment, Senate confirmation?
Nominated by the senators of Texas and presidentially appointed and Senate approved.
And under which administration were you appointed?
I was appointed by President Trump.
May I ask you, sir, at some point were you contacted by or on behalf of Attorney General Ken Paxton?
Yes, sir.
Can you tell us the substance of that?
I received a call in late August of 2020 from a friend in McKinney who was a mutual friend of the Attorney General. He told me that Attorney General Paxton would like to visit with me if I'd be willing to about a potential criminal special investigation.
Did you meet with with Mr. Paxton?
Within the hour, I received a call from Attorney General Paxton. He introduced himself, we visited a little bit, and he asked me if I would come to Austin to visit about a matter that he had. He did not give much detail at that point. I knew it was criminal. I knew it was a special investigation, but I didn't know the role really. And he said he would explain that to me if I came to Austin.
Did you go to Austin?
I came to Austin on August 27th of 2020.
Did you meet personally with Mr. Paxton?
I did in his office about 45 minutes, and I met about 15 minutes with Jeff Mateer.
Can you give us a summary? I'll ask you, did he provide you some information concerning this potential complaint?
Are you asking me to
Well, I'm asking you, did he give you information about the complaint?
Attorney General Paxton told me about the complaint, yes.
And if you could, in just a few words, tell me what the substance of the report was.
Well, I didn't know what role I would be playing, whether I was going to be an independent prosecutor or under the authority of the Attorney General. So we talked about that, but he told me it involved a guy that was had a warrant executed, and he believed the warrant could have been possibly executed unlawfully. So we continued to visit about that and flesh that out.
On the information that he provided you, just off the top of your head, did you have any? Well, let me retract that. Did you ask of him whether or not he had individuals within his own office who might be able to investigate this matter?
Yes, we talked about the fact. I remember him talking about that it involved potentially a phone line cut on some execution of a search warrant, and the warrant affidavit being changed. And I learned during that meeting that it was involving the FBI and the Securities Board and DPS, and the investigation would be involving that. So, yes, we talked about that, and he said he could not get the people in his office to do anything about it. And I talked a little bit more about that, and he talked about the ranger, the retired ranger that worked for him, that wouldn't do anything about it.
Let me stop you there. Did you ask him a question after he told you that his own people weren't getting work done on it?
Yeah, I said, why don't you fire him?
What was his response?
It was complicated, and it just didn't work that way.
Fair enough. Did he advise you whether or not there were any other people in the race, whether you had competition?
He told me that there was another lawyer, young lawyer, that he was considering, but that he didn't have the credentials that I did. And so I assumed that if I wanted that he would choose me to do that.
You said that he had identified, if I'm correct, the FBI, the State Securities Board, and DPS. Is that accurate?
I remember those entities.
Did those raise any concerns for you? Just that first question.
Yeah, as we're talking.
And let me stop you there, just so I don't get an objection. The answer to the question is yes, correct?
Yes.
Did you relay those concerns to Mr. Paxton, and if so, what did you say?
Yes, I was aware of the fact that his indictment involved those three agencies, and I said I have some concern about the fact that it would be involving, that I would be under your authority and investigating the same agencies that were involved in your indictment. As we talked about it, I eventually, I'm having to process this during this meeting and learn all this, and the red flags are going off. So eventually I say, my preference is that I would write a report and be able to evaluate these conflicts before I would commit to any level of prosecution. And he said, we have people that can prosecute the case, that would be fine.
From your recollection, did he appear affected by these concerns that you raised? Did he indicate that it was a problem?
I'm sorry, conjecture and speculation as to whether or not he was affected.
Your Honor, if I may.
Yes, sir.
From what you observed, sir, did you have any personal observations for how you believed he took that news?
Same objection.
Your Honor, if I may, we're talking about a lay witness opinion. This individual was in the room with him and spoke directly with Mr. Paxton and can testify as to what he observed.
I will abstain. I think you can phrase it better, so try one more time.
Sounds like a challenge, Your Honor, and I'm up for it, I hope. You told him these concerns that you raised, is that correct? What did you observe, if anything?
He told me, when I said I'm concerned about these, he said, I understand, I'm not worried about that, I just want to find the truth.
Fair enough. Did he tell you, did he indicate to you whether the individual involved was a donor?
I did not learn he was a donor until I went to talk to Jeff Mateer.
Did you learn from Mr. Paxton that he had any other relationship with this individual?
No, I had no idea when I left the Attorney General that there was anything other than a guy that he was that was wronged, and I was unclear on why it was going to a special prosecutor other than what he had told me.
So let's fast forward. At some point, do you speak with Mr. Vassar about a potential contract?
Within a few days, he made contact, Ryan Vassar made contact with me by email and eventually gave me a contract. It didn't have any specific terms. It was just a general contract, and we exchanged emails about the scope and some details of the contract.
What was your purpose in defining the scope?
I repeated what I had told to the Attorney General, that because of my concerns about the conflicts, I would commit to investigating, to writing a report, and would not commit to prosecution until I'd been able to evaluate the conflicts further.
Was there an hourly rate that was addressed?
The hourly rate was, I can't remember, it didn't come from me. It was suggested with a contract or by Mr. Vassar.
Would a rate of $300 an hour be accurate?
That was the rate that was given to me.
Did you have any concerns about that rate?
I was in 2 months out from the U.S. Attorney's Office and just starting, and this was giving me an opportunity to stay involved in something relevant. I mean, the Attorney General was asking me to help with an investigation, so it intrigued me, so I wasn't worried about the money.
You were prepared to do any sort of investigation if you cleared conflicts for $300 an hour. Is that accurate?
What was described to me, yes. I mean, I knew I could, if I needed to, get out of it, I could.
Were you prepared to secure any insurance that was necessary as provided by the contract?
Well, the insurance thing didn't come up until when I get the contract. It says you have to have malpractice insurance, and I was 2 months out of the U.S. Attorney's Office, so did not have it. But it was not. That was not what kept me from doing it.
Did you, as a matter of fact, indicate to anybody that you were willing to get insurance within 30 days?
I would have gotten insurance if that was necessary. I thought it was something they could waive.
And did you explain that to Mr. Vassar?
Yes.
Did you feel, in your opinion, that in any way stood in the way of you getting the job if you were to be chosen?
Yep.
I'm sorry.
That would never.
Excuse me, Mr. Brown. Objection, conjecture, and speculation. He doesn't know if it's in getting his way or not.
You also can speak up, Mr. Goudeau, when you speak. Sustain, you can rephrase that.
Did you get a response when you indicated that you could get insurance within 30 days?
We emailed, and he said it was something that he thought they could take care of, or words to that effect.
Very good. After you have raised concerns to the General, Paxton, after you've indicated that you wanted to limit the scope of your work so that you could make sure that those conflicts and concerns were taken care of, after you've indicated that you would work for $300 an hour and get insurance, were you chosen?
No, I followed up a couple times with emails, and it just, nothing happened after that.
Are you familiar with federal filings, or the process of performing federal filings as it relates to search warrants?
Yes.
You ran an entire office of Assistant United States Attorneys, correct?
Yes. I mean, I wasn't on the front line of the search warrants, but I certainly am familiar.
Fair enough. Are you familiar, sir, that when an application for a search warrant is filed, there is an application with accompanying affidavit?
Correct.
And then there is a search warrant order. Is that accurate?
Correct.
Okay. And what we would call the application and the warrant. Is that fair?
Right.
Ms. Manello, if you would please pull up AG 1047. I apologize, Your Honor, we didn't have a digital copy, so we're putting it on the Elmo. If you could look at line number 1, please. Would you agree with me that on August 16, 2019, there is a motion to seal the search warrant application and the search warrant?
That's what's reflected.
And the search warrant application, again, contains the application and the affidavit. Is that accurate?
And the proposed warrant.
If we could go to line number 6 on the second page, please. At the top, would you agree with me here that it indicates that there is a motion for leave to disclose the search warrant, the sealed search warrant, correct?
That's the entry.
Would you agree with me that there is nothing on that entry that indicates that there is a motion for leave to disclose the sealed search warrant application, which would include the affidavit?
There's nothing that mentions the application.
Very good. Sir, are you familiar with OPR as it relates to federal government?
Yes.
Could you tell us what those initials stand for, please?
The Office of Professional Responsibility.
Do all assistant United States attorneys who enter on duty, at least during your time, are they made aware of the Office of Professional Responsibility and their jurisdiction to investigate complaints regarding United States attorneys?
Objection, conjecture, and speculation.
I'm asking from his direct knowledge, Your Honor.
Oh, you asked for
Overruled.
Please answer the question.
Assistant United States attorneys are familiar with what the OPR is and what their jurisdiction is, yes.
If there was a complaint regarding an AUSA and the conduct in any one of their investigations, would the Office of Professional Responsibility be charged with investigating them?
Objection, conjecture, and speculation.
Overruled.
Please, sir.
That's one agency that could.
As a former United States attorney, presidentially appointed, are you aware if there is an OPR investigation ongoing, whether the United States Attorney's Office, where that employee who is complained of works, has any jurisdiction over the matter, or if it is entirely within Office of Professional Responsibility?
I'm sorry, objection vague. I don't understand the question.
Your Honor, if I may, I think it's more important if the witness understands it.
Overruled. You may answer.
I'm not sure I do, so.
That answers Mr. Goudeau's question. Would it be fair to say, or let me ask you this, in your experience as a presidentially appointed United States attorney, if somebody within your office, an AUSA within your office, was being investigated by the Office of Professional Responsibility, would your office, the office in which they worked, have any sort of responsibility for the investigation, or would it be entirely OPR?
No, my understanding is it goes to OPR out of Washington, D.C., and they keep it separate.
So the office where the AUSA works has no responsibility for that, correct?
That was my experience.
Are you familiar with OIG?
Yes, the Office of Inspector General.
Similarly, based on your experience working as a presidentially appointed United States attorney, are AUSAs within your office made aware of and trained on the Office of Inspector General and their jurisdiction?
They're certainly aware of it. What the level of training on it is, it doesn't take very long before they know that there's oversight organizations within the different areas of the Department of Justice.
If there is a complaint for an agent within the Department of Justice, not an AUSA anymore, but an agent, would the Office of Inspector General have oversight and jurisdiction?
It's my understanding they do. That's who investigates the investigators.
Same question. Investigates the investigators, and it is taken out of the hands of the regional or local United States Attorney's Office. Is that correct?
That's my understanding.
Thank you, sir. Pass the witness.
Thank you, Mr. Donnelly. Mr. Cogdell?
Hi, Mr. Brown.
Good afternoon.
I think we met?
We have.
Okay. In Sherman.
The courtroom in Sherman, yes, sir.
Lovely courtroom, lovely judge. Nice to see you again. When you were meeting with Mr. Mateer, Mr. Brown, did he tell you that this is a bogus investigation and it shouldn't be investigated?
No, sir.
Did he, that is Mr. Mateer, give any indication to you that the investigation or that the job that you were applying for was unnecessary?
No, I sensed a little, I sensed something, but he never said anything directly other than he was glad that I was being considered because I would tell the Attorney General the truth.
Okay. And same with Mr. Vassar, when you were communicating with Mr. Vassar about the details of the contracts, did he suggest in any shape, form, or fashion that the job that you were applying for was unneeded, unnecessary, a sham, anything of the sort?
No.
And I hear you, Mr. Brown, on the potentially troubling fact that these are the same agencies or some of the same agencies that had charged Mr. Paxton with the state securities fraud case, which, by the way, do you know of your own personal knowledge if that thing is still pending after 8 years?
Objection, Your Honor, to the relevance as it relates to this witness.
Overruled.
Are you aware, Joe, that that case is still pending?
The case against the Attorney General?
Yes, sir.
Yes, I'm aware of that.
Okay. That was what was potentially troubling to you, right?
That was part of it?
Yes, sir. But not the allegations or the claim or whatever that the FBI or these different agencies had potentially engaged in misconduct. You were still willing to investigate it, right?
I left it open that could happen. I was willing to.
And you are the former United States Attorney for the Eastern District, right?
Yes, sir.
In fact, I think, and somebody said that the other applicant wasn't as qualified as you. Probably true, because there are very few people in the Eastern District that, on paper at least, would be more qualified than the former DA from Grayson County and the Eastern District United States Attorney, right?
That's your words.
Okay. In any event, you're a very qualified person. You weren't chosen, but you did make 2 or 3 calls trying to follow up to see if you could get the job. Am I recalling that correctly?
I was willing to do the job, and I didn't know what happened. Yes.
Okay. Fair enough. Thank you, Joe. Nice to see you.
Thank you.
No redirect, Your Honor.
Are both parties finished with the witness?
No problem. No.
Excuse, Your Honor.
Okay. You're excused, Mr. Brown. Thank you, sir.
No,
Next witness.
Thank you, Mr. President. The House calls Kendall Garrison.
Bailiff, please bring in Kendall Garrison.
Doing this investigation. The next witness has been called. That person's name is Kendall Garrison.
Yes, and so again, this was interesting and brief, quick questioning and cross on Joe Brown, because I don't know what much more he could have added.
And actually, a stroke of Google, if I have this correct, shows that Kendall Garrison is the President and Chief Executive Officer of Amplify Credit Union. I have a sense that I am correct, that is the correct Kendall Garrison, because we know that Amplify Credit Union was targeted for some of these subpoenas that were being issued by Brandon Kamek. Accompanying him was Michael Wynn.
Right, and as he's walking in, I do believe that is the correct Kendall Garrison that you have there, presumably accompanied by his attorney. That's who's been allowed on the floor with these witnesses.
The evidence I give upon this hearing by the Senate of Texas of impeachment charges against Warren Kenneth Paxton Jr.
He is now taking his oath.
Nothing but the truth, so help me God.
And certainly will be interesting to see what he has to say about the subpoena that was served to him by Brandon Kamek, accompanied by Nate Paul's lawyer, Michael Wynn.
Please introduce yourself to the ladies
Let's
and gentlemen
listen
of the
in.
Senate.
My name is Kendall Garrison.
Mr. Garrison, could you speak up a little for me? It's a big room.
My name is Kendall Garrison.
Thank you. And where do you work?
Amplify Credit Union.
What is your role at Amplify Credit Union?
I'm President and Chief Executive Officer.
As you might have heard, I want to go through this a little quickly, so I'm going to jump right in. I'm going to turn your attention to 2020. During that time frame, were you familiar with Nate Paul or World Class Holdings?
Yes.
How so?
Mr. Paul and World Class Holdings obtained loans from Amplify Credit Union.
Okay. And what was the status of those loans in the summer of 2020?
In the summer of 2020, we had issued a demand letter in as much as those loans were delinquent and were working their way toward foreclosure.
Okay. Did you, in the course of your employment, and does your staff create records specific to Amplify their banking and their foreclosures?
Yes.
Have you provided those to the House?
I have.
Would it surprise you to know that we have provided copies to the defense?
It would not surprise me.
Did you provide a business record affidavit for those documents?
Yes.
And for the Senate, for Mr. President, that's been on record for over 14 days, the business records affidavit, and as such, I've provided a copy to defense, and I have a copy for the court. Mr. President, you'll notice I provided you an external document. I'll refer to that in a moment. In the meantime, the Exhibit 657 has been pre-admitted. Mr. Garrison, I would like to talk to you a little bit about those records. Do you remember 3 loans in particular related to Nate Paul in the summer of 2020?
I do.
And I'd like to move you forward to the end of July, early August of that year. What was the status at that point of those loans?
Those 3 loans had been posted for foreclosure.
And when you say posted for foreclosure, what does that mean?
That means we had requested a substitute trustee, and we had filed notice with the various counties on where those 3 properties were located that we intended to foreclose on those on the first Tuesday of August.
Was Nate Paul aware of your intent to file and proceed with foreclosure?
He was aware.
Is documentation consistent with that provided in Exhibit 657?
Yes.
Now, after providing notice to Nate Paul, does he immediately file a bankruptcy?
He does not.
And just so that we're all aware, does the filing of a bankruptcy create a legal automatic stay foreclosing the ability to move forward with a foreclosure, for example?
The filing of a bankruptcy does create a stay.
Would we call that a nuclear option, though, for Mr. Paul?
Objection, leading, argumentative.
Sustained.
Does Mr. Paul make an effort to prevent foreclosure and avoid bankruptcy?
Objection calls for speculation as to Mr. Paul's intent.
If he knows, Your Honor, which he does.
I'll overrule. Answer the question.
I'm sorry, can you repeat the question?
Yes, sir. So at the end of July, early August of 2020, does Mr. Paul make any efforts to avoid foreclosure and also avoid bankruptcy?
He had discussions with our staff, and his counsel had discussions with ours about options to avoid foreclosure.
Yes, sir. Stacy, if you would for me, would you pull up Exhibit 657, specifically .190? Can you see that? Excuse me. Can you see that, Mr. Garrison?
It's small, but I can see it. It's more legible now. Thank you.
And what does this appear to be?
Hang on a second. We don't have anything on our monitor.
We'll hold one moment. Ms. Epley, you said it was admitted. We do not have that on our sheet as being previously admitted. Did I mishear you?
It is possible, Your Honor, and I'm happy to lay a predicate right now. This is easily correctable.
Mr. President, I can't see anything. It's not on my screen. I don't know if the jury can see it. I hope you can, but I don't have anything on my monitor. As hopefully everybody can see here.
And, Your Honor,
hold on one second. Hold on.
Sure.
Is it up now? You have it?
It is not.
Okay, hold on. Do the jurors have it? I have it. Can we have Damien, if you can take a look? We'll just pause there for a second.
Your Honor, could I ask that this not count towards my time?
Yes, ma'am. It won't count towards your time.
Thank you.
I'm getting a signal.
Jurors, are your monitors black now? Okay, they're all blank now, Damien.
It's up now, Mr. President.
Are we all go? And Your Honor, Mr. President, for the record, I want to ensure I'm getting confirmation that 657 was pre-admitted by agreement with defense. If, however, you would like me to lay a predicate, I can do that quickly.
That's not necessary. No objection.
Okay, we just didn't have it on our list. But
thank you, Your Honor.
Go ahead, and I will be sure you get a minute back. So there
Thank
you go.
you.
Okay.
Thank you. Now, Mr. Garrison, I'm going to draw your attention back to Exhibit 657 at page 190. Does this appear to be an email from Nate Paul?
It does.
And what's the date?
The date is August the 3rd of 2020, Monday, August 3rd.
Now, the senators and people viewing at home can read, so I want to move you directly to the link embedded in that email. Do you know what that is?
I do.
And what is it?
This was a link to an attorney general's opinion that we referred to internally as the midnight opinion.
Yes, sir, we refer to it the same, and I think the senators are familiar with the foreclosure letter or the midnight letter. Let me ask you, what was the impact of receiving that at Amplify Bank? We had lots of discussions internally and with our counsel on how to proceed. This was highly unusual, and I am in my 44th year of banking, and this is the first time I've seen something of this nature. As a direct result of
Object to the narrative.
Sustained.
That's okay. I'd be happy to break it up. You mentioned that it's the first time you'd seen something like this, but to be fair, because I'm sure Mr. Little will ask, wasn't it in the middle of COVID?
It was.
So that's kind of unprecedented time anyway, correct?
In many ways.
So other than COVID, what was surprising about this?
It was surprising to see a ruling issued on a Sunday night or Sunday morning, I believe, maybe it was Monday morning, that essentially prohibited foreclosures in the state of Texas.
What's the impact of that for Amplify and for your resources and assets?
We had no choice other than to pull those bankruptcy filings. I'm sorry, those foreclosure filings.
Thank you. We've heard that no foreclosures in Texas were stopped because of the foreclosure letter. Is that your experience?
Objection. Objection. Leading.
Well, let me come back.
Sustain, re-ask. Yes.
Yes, Mr. President. In that case, I've provided defense a copy of Exhibit 676. They received a copy of this over the weekend. It is external to the business record you already have. I'll approach the court.
Is there any objection, Mr. Little?
To 676?
Yes.
No objection.
Please enter 676 into evidence.
And Mr. Garrison, what is this?
This is an email from Ann Nguyen to Brian Elliott, who was the in-house counsel for World Class.
You'd mentioned a moment ago that you had changed your course in regards to the foreclosure. Is that right?
That's correct.
What did you choose to do?
We chose to withdraw those foreclosure notices and not proceed with foreclosure on that Tuesday, the 4th of August.
On all three properties tied to Nate Paul?
Correct.
What was the value of the bank's assets in regards to those properties?
We had...
Objection, vague.
Overrule.
We had loans outstanding to the world-class entities with Mr. Paul as a guarantor to the tune of about $11.5 million.
And were you receiving payment on that note?
We were not.
Hence the foreclosure, correct?
Correct.
And by forestalling or delaying that foreclosure, did it help make you money or cost you money?
It was a cost to us.
After delaying the foreclosure, did the bank sell the properties?
Can you ask that question again?
I sure can. So on August 4th, the properties were going to be foreclosed, but were not, correct?
Correct.
Did you maintain control of those notes?
We did maintain control of those notes for some period of time after that.
Okay. And then ultimately what happened?
Ultimately on, I believe the date was September the 9th, We sold those 3 loans and assigned the deeds of trust to a third-party buyer.
And just to be clear, because of allegations made by Nate Paul's side of things, did you sell those at a great deficit? Did you lose money?
We did not. We essentially sold the loans at par, and we received our past due interest and some attorney's fees, as I recall.
So in regards to your dynamic with Nate Paul and foreclosures in August of 2020, who benefited from the foreclosure letter?
Nate
Objection calls for speculation.
Overruled.
Thank you. I don't think we heard you. Can you repeat that?
Nate Paul and the world-class entities.
Pass the witness.
Mr. Little.
Mr. President, thank you.
Counselor, can we have just a moment?
Please.
Ms. Epley, could you come up, Mr. Little?
Happy to.
We've been listening to, or we listened and now have finished listening to testimony from Kendall Garrison. He was the president and CEO of Amplify Credit Union. He testified that Amplify Credit Union planned to foreclose 3 of Nate Paul's property after 3 of Nate Paul's properties. They were not receiving payment on those properties, and they had loans out to Nate Paul's companies for $11.5 million, but that their plans to foreclose those properties were halted once they received that order, that letter from that opinion from the Attorney General's office saying that foreclosure sales needed to be halted and needed to be paused and could not happen pursuant to Governor Greg Abbott's COVID order.
And that opinion, one of the underpinnings of this whole case, there's a whole article dedicated to this opinion, and the way it goes is the allegation is that Kim Paxton essentially ordered his staff to draw up an opinion that was a different opinion than they had formed on their own concerning foreclosures. And again, this idea that was done to benefit Nate Paul.
And so now let's watch as Mitch Little, the defense attorney, cross-examines Kendall Garrison.
No, I don't have any documentation before me in this moment.
I don't like working in 2-inch piles of paper, okay? I'm going to show you exactly what happened. We're going to go document by document, okay? Your Honor, may I approach the witness?
Yes, you may. You can start the clock again. It was a brief pause. Mr. Little. Thank you for helping to clarify, Ms. Epley.
Now, Mr. Garrison, interesting times during COVID as a banker. Yeah?
Without a doubt.
I'm sure your customers took out PPP loans. Yes?
They did.
And you were probably working that all from March forward. Yes?
We were.
With major clients of the bank, I'm sure. True?
Yes.
You had loans in workout from customers who couldn't transact as much business probably as they wanted to. True?
No. You
didn't have any loans in workout during COVID?
3.
3? 3 total for the bank?
Yes, sir.
All right, we're going to go one by one through them here in just a minute. Okay. You familiar with the CARES Act that prompted the PPP loans?
Objection, Mr. President. Relevance.
It's about to get real relevant.
I'm willing to let that question end. Overruled.
Okay. You familiar with the CARES Act?
I am familiar in as much as I know it exists. I did not read it in its entirety.
There was an eviction moratorium, wasn't there?
Objection, providing facts not in evidence. He said he's not familiar with it.
Sustained.
Let me try again. Did you know there was an eviction moratorium under the CARES Act?
Yes.
Did you know there was a foreclosure moratorium under the CARES Act?
Yes.
Did you know that it went until July 30th of 2020?
I did not.
As the president or CEO of your bank, was you president or CEO or both?
Both.
As the president and CEO of the bank of Amplify Credit Union, why don't you tell ladies and gentlemen of the jury when the foreclosure moratorium ended under the CARES Act?
Objection, relevance.
Overruled.
If you would.
I don't know.
You don't know? Okay.
No.
Amplify wasn't Nate Paul's senior lender or anything, was it? You had three
Objection,
loans.
speculation.
Sustained.
Was Amplify Nate Paul's senior lender?
Objection, speculation.
If you know.
He asked the question. Overruled. You can answer.
We were with respect to these three properties.
Three special purpose entities that Mr. Paul set up, true?
Yes.
Okay. I want you to take a look at what's been marked as Exhibit AG 1031. And Your Honor, at this time, we move for admission in bulk of Exhibits AG 1031 through 1044.
Any objection?
Your Honor, I don't know. He has not provided me a copy.
I handed it to you, didn't I? Big stack right there.
Oh, I don't know.
Got a sticky note, it's purple. That's the ticket.
I
Ms.
stand
Epley.
corrected. Your Honor, or Mr. President, I think they're exact duplicate of what I've already provided. No objection.
Not quite. These are actually in chronological order. But no objection, right?
No objection, Ms. Epley?
No objection, Mr. President.
Mr. Arroyo, if you would.
Hold on 1 second. Let me submit them to evidence. AG 1031 to 1044, please. AG 1031 through 1044, please admit to evidence.
Mr. Arroyo, if you would. AG Exhibit 1031. Your lawyers are Streisand, Landon, Osborne, and Lemon, correct?
Yes.
And Steve Lemon is a partner in that law firm, correct?
His name's on the letterhead, so one would presume.
Yeah, and he was actually the lawyer representing the receiver in a separate Nate Paul case, correct?
Objection, speculation, and relevance.
Overruled.
I don't know.
You don't know. Okay. What's the date of this item here?
The date is May 27th of 2020.
Okay. And what is this document?
This is a notice of default and demand for payment.
Okay. At least as of May 27, 2020, the bank had hired, I'm referring to Amplify Credit Union as the bank. Is that okay with you?
Perfectly fine.
Great. The bank had hired an attorney, and it had hired an attorney to make a demand on WC Alamo Industrial Center LP, a Nate Paul entity, true?
In this case, yes.
Mr. Arroyo, Exhibit 1032, please. Same thing with regard to WC 707 Cesar Chavez, yes?
Yes.
AG 1033, Mr. Arroyo. Same thing with regard to WC Custer Creek Center Property LLC, correct?
Yes.
All three of those entities are in default at the bank as of May 27 of 2020, right?
Yes.
So you posted them for foreclosure in July of 2020, right?
We would have had to post those.
Object not responsive.
Sustain. Answer the question.
So you posted them for foreclosure in July 2020, right?
Yes.
No. You never did you?
Then I object to relevance, Your Honor.
Did your bank post...
Overruled.
Did your bank post these three properties for foreclosure in July of 2020?
Objection, relevance.
Overruled.
Can you ask the question again?
Let me try for the fourth time. Did your bank post these three properties for foreclosure in July of 2020? Yes or no?
I don't know when we posted them for foreclosure, but they were posted for foreclosure.
That wasn't my question. And I believe the answer to my question is you don't know, right?
Then if that's my only choice, then I don't know when we posted them for foreclosure.
They weren't posted for foreclosure in July of 2020 because there was a foreclosure moratorium under the CARES Act, true?
If I am not aware of that, how long that moratorium was actually in place. But if you want to foreclose on a property, you have to file a foreclosure, I believe, 21 days before the scheduled foreclosure date.
That's right.
So filing is not a foreclosure. It is the notice of intent to foreclose on the first Tuesday of every month as foreclosures take place in Texas.
And surely the bank wanted to get its money back through foreclosure as fast as possible, right?
Objection, argumentative.
Sustained.
Did the bank want to get its money back as fast as possible through foreclosure?
We wanted to receive repayment by whatever means necessary.
Very good. Mr. Arroyo, Exhibit AG 1034, if you would. Now, this is an affidavit of posting of a property for foreclosure, right?
It appears to be, yes.
And the date of this is July 10 of 2020, yes?
Yes.
And the entity that's being foreclosed upon is W.C. Custer Creek Center Property, LLC, yes?
Yes.
And that's in Plano, Texas, my neck of the woods, Collin County, Texas, right?
Yes.
So you posted this one on July 10th for August foreclosure, yes?
It appears to be that. Yes.
Your testimony on direct was you posted all three of them for August foreclosure, correct?
That is my recollection.
That's not right, is it? Let's take a look at what's marked as Exhibit AG 1035. This is an email from Nate Paul to some people at the bank, yes?
It is.
And Nate Paul says, I'm writing to confirm you're aware of the attached announcement. Ms. Epley went through that with you, correct? Correct?
Can you ask that once again, please?
Ms. Epley went through this email with you, correct?
Yes, and I saw the email at the time.
Last sentence of that first paragraph, it says, in light of foregoing, please confirm before 5 p.m. today that you will not be attempting to proceed with a foreclosure tomorrow. A foreclosure tomorrow, not 3. True? That's what Nate Paul says in this email, right?
He does use the words a foreclosure.
And on when responds the next day. That's House Board of Managers Exhibit 676 that was on the screen earlier. And she says, Brian, it is, and she's writing to Brian Elliott at World Class, it is our position that the restrictions cited in the unsigned informal guidance would not apply to our particular foreclosure sales. However, as a courtesy to borrowers and per your/their request, Amplify is willing to postpone the foreclosure sale to September 1, 2020, right?
I don't have that document on my screen, so I can't confirm or deny that's what it says.
Would you like to look at my copy?
Sure.
Mr. President, the House is willing to concede that the email written by them, his client, is in the singular.
It's a little late for your concessions. I'd like the witness to answer my question if I could, Mr. President.
Let him read it, and then you can repeat the question.
Thank you.
She does use the word the.
Mr. Arroyo, Exhibit AG 1036, please. You didn't even notice the substitute trustee sale for WC 707 Cesar Chavez until August 7 after the AG's opinion was issued, correct? Correct?
I have a different recollection of those events.
Well, that's why we have documents, right?
I believe this was the second posting.
Oh, really?
To make it for the September sale.
Do you have a document with you, perhaps, or in that massive pile of documents somewhere where your bank posted the other 2 properties for foreclosure in August?
I do not.
It seems kind of important-ish, isn't it? You don't have that, do you?
I do not have a document of that nature before me.
Well, in any event, we know for sure that there's an August 7 posting of that after the foreclosure sale, yes?
It appears to be a notice regarding substitute trustee sale, yes.
Exhibit AG 1037, if you would, Mr. Arroyo. WC Alamo Industrial Center also posted on August 7 of 2020 after the opinion was issued. True?
Yes.
Exhibit AG 1038, if you would. A separate notice regarding substitute trustee sale, August 7 of 2020 for WC Alamo. True?
Yes.
After the opinion, yes?
Yes.
And just to be clear for the ladies and gentlemen of the jury, and for the media who's gathering information on this, you told the media you had all 3 properties posted for foreclosure in August of 2020. And we read about it in the newspaper, true?
Yes.
In fact, not in evidence.
But you don't have...
Objection.
What is your objection?
Facts not in evidence, relevance, and counsel's testifying.
He just said yes.
Sustain the objection.
You told the media you had all 3 properties posted for foreclosure in August of 2020, correct?
I don't recall my exact words, but I did tell the media that we had those, that we had world-class properties posted for foreclosure, yes.
You don't have a document to prove the other 2, do you?
No.
Show you what's marked as Exhibit AG 1039. This is the affidavit of posting for WC 707 Cesar Chavez, correct?
Yes.
Exhibit AG 1040, if you would, Mr. Arroyo. We're going fast, but I think you can keep up. Mr. Garrison, was it? We're at August 10 of 2020. It says notice regarding substitute trustee sale. This is for WC Custer Creek. True?
Yes.
You re-noticed it for the next month. Is that right?
Yes.
Tell the ladies and gentlemen of the jury, were any foreclosures being stopped in Collin County, Texas at this time?
I wouldn't have knowledge of that.
You don't know, do you?
No.
So when you testified on direct that for whatever reason, this opinion disrupted the business of foreclosing these properties at the bank, you don't really know whether Collin County stopped doing any foreclosures at all, do you?
Objection, asked and answered. As to Collin County.
Overruled.
You don't know, right?
I only have knowledge of what Amplify Credit Union did in response to the midnight opinion.
That really wasn't my question, so let me try again. Do you know whether Collin County was doing foreclosures at this period of time or not?
I do not.
Mr. Arroyo, Exhibit AG 1041, if you would. And this is your affidavit of posting of WC Custer Creek Center property for foreclosure on August 10 of 2020, correct?
Yes.
Now, you sold all 3 notes, right?
We did.
So you didn't have to foreclose any of the 3 properties, correct?
Ultimately, we did not have to foreclose on any of the 3 properties.
And you didn't have to foreclose any of them because your bank lost $0. You sold all 3 notes and your bank lost $0 as a result of whatever this informal legal guidance was, correct?
That is correct. We ultimately sold those notes.
And you didn't lose a single dollar. Just tell the jury.
We did not.
Why? Well, let's put our heads together. How did all 3 notes get sold at the same time? Doesn't that seem coincidental?
It was not a coincidence at all.
It wasn't a coincidence because Brian Hardiman is a man who his name may or may not have come up in this trial at some point. He put together 3 special purpose entities and he had his agents come and buy these notes from your bank. Yes?
I have no idea. I know that the notes were purchased. I do not know who formed the special purpose entities. I only know who I interacted with.
Isn't it true that all three of these notes were sold to special purpose entities of Brian Hardiman?
I don't know.
Isn't it true this is the same Brian Hardiman who's the subject of the bid rigging investigation in Travis County District Attorney's Office referral number 2, and the same man who sent Ken Paxton a picture of a dead deer?
Objection, Your Honor.
I'm sorry, I'm
Mr.
not quite
President,
done yet.
no, absolutely not. Facts not in evidence, and absolutely staining someone who's not here without any basis.
Wasn't quite finished, but
Mr.
President.
Sustained.
Very well. Do you know who Brian Hardiman is?
I do not.
Who did you interact with on the sale of these 3 notes?
Justin Bain.
Justin Bain. Okay. So I guess what we would need to do if we wanted to see if there was any connection between Justin Bain and Brian Hardiman, we could just probably Google Justin
Objection,
Bain and
Your
Brian
Honor,
Hardiman,
if I
right?
could, Mr. President.
Sustained.
Thank you.
If you would, Mr. Arroyo, Exhibit AG 1042, please. Sold that note to somebody called Alamo Lanark, right?
Yes.
Justin Bain entity, B-A-Y-N-E, true?
Yes.
Didn't lose a dime, yes?
I'm sorry, say again?
The bank didn't lose a dime, right?
Right.
Exhibit AG 1043, if you would, Mr. Arroyo. Sold this note to something called Cesar Rainey Street LLC, right?
Yes.
Bank didn't lose a dime, right?
Right.
Justin Bain entity, B-A-Y-N-E, right?
Yes.
Exhibit AG 1044, please. Mr. Arroyo. Sold this note to something called Spring Custer LLC, and the bank didn't lose a dime, right?
Yes.
Justin Bain entity, B-A-Y-N-E, right?
Yes.
You've been in banking 44 years, did I hear that?
Yes.
That's a long time, right?
It is.
If somebody wanted to, I don't know, foreclose on a piece of property themselves and wipe out the existing owner's equity, this is probably a good place to start, isn't it?
Objection, Your Honor. The default has to occur first. He's implying things that aren't relevant.
Sustained.
No further questions.
Redirect, Ms. Epley.
No, Mr. President.
Do both of you excuse the witness? Mr. Little, excuse the witness?
He is, Mr. President.
Okay. You're excused. Thank you, sir.
Thank you.
And I believe this was the last noticed witness of the day, if I'm not mistaken. I
That's
am
inaccurate.
mistaken. I am mistaken.
Ms. Epley, who are you calling? Or Mr. DeGuerin? I'm not sure who's calling the witness.
Yes, Your Honor. The House Board of Managers calls Darren McCarty.
Bailiff will bring in Darren McCarty.
And we've been listening to testimony from the president and CEO of Amplify Credit Union, Kendall Garrison, whose bank was the subject of
just hold the witness
subpoenas
for a moment.
that were issued to that financial
Mr.
institution.
Mosby, Mr. DeGuerin, I understand that both sides have agreed to exhibits. I guess that was earlier today, this morning.
That is correct, Your Honor.
And we're going to read those exhibits into the record now, correct? Mr. Guerin?
Yes.
Both of you have agreed, okay? You may read these
Yes, Judge.
exhibit numbers.
I'm going to start.
Turn on the microphone. It's right behind the laptop there. There you go.
I'm going to start with the House Board of Managers exhibits first, Judge.
And read through them relatively slowly. Don't race through them.
Yes, Judge. House Board of Managers 55, 62, 77, 85, 86, 91, 92, 94, 324, 346, 657,
677, 678, 680, 681, 682.
And just to establish, while we are going over these exhibits that will be entered into evidence, the next witness who this House prosecution plans to call or is calling is Darren McCarty. Darren McCarty was also one of the whistleblowers. He was the Deputy Attorney General of Civil Litigation. He resigned from his position in October 2020. So then that will make the six of 8 whistleblowers that we will be hearing from during this proceeding. Again, right now they're just going into talking about all of the evidence as part of his testimony that they will submit. But again, Darren McCarty was one of the original 8 whistleblowers who will be taking the stand shortly, coming up on about 10 minutes after 5 o'clock. Likely we will hear direct examination of him this evening. The Lieutenant Governor saying that testimony will continue most days until about 6:30 or 7 o'clock. So depending on the number of questions that House prosecution officials have for him, he could stay on the stand for a couple of hours. He will clearly be questioned by Dick DeGuerin in this case, one of the leading prosecutors working on behalf of House impeachment managers. Let's listen in.
You may bring in the witness now.
No.
Please step over there, Mr. McCarty. Raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, nothing but the truth, so help me God. Please be seated. And is that stack of papers there from the last witness?
It must be.
Okay, let me pick those up. And as closely as you can speak on the microphone. You might want to raise that. You're a little taller, just a little bit. There you go. Mr. DeGuerin, your witness.
Mr. McCarty, we've had trouble with the sound in here, so please get close to the microphone.
Absolutely.
And tell the senators your name, please.
My name is Darren McCarty.
And what is your occupation?
I'm a lawyer.
Give us the benefit of a brief statement of your training and experience.
After law school, I clerked for Karen Williams on the United States Federal Court of Appeals, the Fourth Circuit. After that, I went to work for Gibson, Dunn & Crutcher in Dallas. I did do a couple of stints at smaller firms and sort of finished my original stint in private practice at Alston & Bird's Dallas office. Actually helped found that office. And then after that, I came to the Attorney General's office.
What year did you come to the, month and year did you come to the Attorney General's office?
I believe it was maybe late April, early May of 17.
And how did you get that job?
Jeff Mateer, who was the first assistant at the time, was somebody that I had known, I had met, actually working as an intern for Congressman Dick Armey in D.C. when we were both quite young. I think I was 17 or 18 years old, and I think Jeff was a couple of years older than that. We lost touch over time, but got reacquainted because we were both doing pro bono work on religious freedom cases. Sort of kept up our friendship, et cetera. And when he took the job here, he initially approached me. I initially declined because it just had a lot of things going on at the time. I couldn't move to Austin. But then eventually, maybe 6-8 months later, recontacted him, or he recontacted me, something like that.
And when did you first meet Ken Paxton?
When I was interviewing.
And did General Paxton interview you himself?
He did.
Okay. It may not matter, but are you a rhino, a Republican in name only?
Well, no, I wouldn't say that. I think I started out when I was in 8th grade of my own volition, hanging door hangers for Ronald Reagan, and was a youth delegate of the Republican National Convention. I took a semester off of college to help staff a congressional campaign. It was actually the last campaign of a Republican against Jim Wright before he stepped down from his congressional office. And then, I continued working sort of in politics while I was at the University of Texas. I think I was the press secretary for the University Republicans, and it's what I've been for a long time.
Okay, could we have the organizational chart up, please? I want to put on the screen in front of you and in front of the senators the organizational chart of the Office of the Attorney General. Highlighted to the far right of the chart is your name and photograph. What was your role in the year of 2020 in the Attorney General's office?
I was a Deputy Attorney General for Civil Litigation. In that role, I oversaw all of the civil litigation for the office. I think it was 12 divisions, roughly 325 attorneys, and I think total personnel somewhere north of 600.
Among those duties, among those responsibilities, was the charitable trust division within your purview?
Yes, it was the financial litigation and charitable trust division.
And briefly, what is the Attorney General's role statutorily with regard to charitable trusts, charitable foundations?
Very briefly, the Attorney General sort of has broad powers to protect the public interest in charity.
The public interest in a charity, does that sometime include protecting a charity from attacks from without?
Absolutely.
And does it sometimes include protecting a charity from itself or from mismanagement?
Yeah, from breaches of fiduciary duties, some sort of mismanagement, yes.
Is there a requirement under Texas law that when a lawsuit involving a charity occurs that the Attorney General is to get notice of that lawsuit?
Yes.
What does the Attorney General do then? What does your charitable trust division do then when given notice?
They look at the lawsuit and do some investigation to determine whether the charity is qualified to protect itself and is protecting itself. In other words, if there's some sort of mismanagement issue at the charity, or there's some inability to legally represent itself, the charity in the litigation, that might be a place where the Attorney General's office steps in to protect the charity.
Give us a rough estimate of how many charitable trusts exist in the state of Texas, if you know.
I do not. Quite a number.
Is it in the hundreds of thousands?
That would not surprise me.
Okay.
Yes,
and give us a rough estimate, if you will, of how many times the Attorney General's office, let's say in a year, involves itself in some way in a charitable trust litigation.
It's a handful.
A handful.
At most.
Okay.
So it may be, again, it may be a management problem. Sometimes charitable trusts, are falling into a state where they sort of can't be self-sustaining anymore, et cetera. And so, the AG's office will get involved, but it's not a common occurrence. What
procedure does the Attorney General's office go through to determine whether to involve itself in litigation involving a charitable trust?
Well, first, the Financial Litigation and Charitable Trust Division, as it was organized then, They have a group, obviously, within that looks at charitable trusts. So they analyze the situation. They make, the staff attorney will make a recommendation, I think initially to the head of the charitable trust group within the division as to whether to intervene or not. And then that's sort of, if it's a non-intervention, typically it sort of stops at the division level. It won't necessarily come up to me unless they think it's a close call and they would need someone in my role's advice. If that's not the case and they believe that they should intervene in the case, then there would be an executive approval memorandum, and that would be signed off on. That would be signed off by the division chief. It would be signed off by me. I believe it would have been signed off by the deputy first assistant attorney general and also by the first assistant.
I want to ask you some questions about the Midi Foundation and some litigation involving the Midi Foundation and Nate Paul are World Class Holdings. You're familiar now with that litigation, aren't you?
Of course, yes.
We do not have an agreement on Exhibit 54, but I'm going to hand you Exhibit 54 and ask that it be introduced once he identifies it, Your Honor.
Thank you.
Any objections from the?
No, Your Honor. We'll allow this.
We'll admit Exhibit 054 into evidence.
Will you pull that up, please? I want to direct your attention to the first paragraph of this memo. First, what is the memo?
This looks like a memorandum that recommends, I shouldn't say it looks like, it is a recommendation by...
Keep your voice up and get close to the microphone.
I'm sorry, I was busy trying to read this. This appears to be the memorandum that
I'm sorry, it is on the screen if that's easier for you.
Okay, that is easier, thank you. This is the memorandum that declined to involve, for the AG's office to become involved with the Midi Foundation. So this would have been prepared at the division level, and highly unlikely that it would have come to me initially.
All right. I want to draw your attention to the first paragraph, and I'll just read it as you look at it. If you'll highlight that first paragraph. I recommend waiving the Attorney General's interest in this matter regarding a private real estate company's breach of fiduciary duties to its investors, one of which is a charitable trust, the Midi Foundation. Did I read that correctly?
You did.
And that's a memoranda recommending to waive the Attorney General's interest.
That's correct.
On the second side of that letter, if you go to the second page, I want to highlight the paragraph in the middle, in my opinion, starting there.
I see that.
This office does not have a role in this matter. The trust is zealously represented by counsel. Counsel stated that once the receiver sells the First and Trinity LP and WC Third and Congress LP, the trust will likely make a massive return on its investment. Did I read that correctly?
You did.
And finally, at the bottom, I recommend the Attorney General file a waiver for the following reasons. The trust is represented by counsel, the trust's assets are diversified, and the litigation will not critically impact the trust's 2020 distributions. Is that right?
Yes, that's how it reads.
Following this, did the Attorney General waive filing any waive interfering in this lawsuit?
Yes, we did not intervene in January or around that time frame in 2020.
Pull up Exhibit 55, please. I believe this is agreed. Entered by agreement. This is the Attorney General's waiver, isn't it? Filed in the lawsuit, styled the Midi Foundation against WC and Trinity, so forth, the world class, or Nate Paul's organizations.
That's correct.
I want to highlight at the bottom of that first page of the waiver, if any pleading is filed herein that adds additional parties or causes of action, then that would constitute new or additional proceeding, and then the Attorney General might intervene, correct?
That's correct.
Did any new parties, additional parties, or additional causes of actions ever get filed in that case?
I certainly don't recall any new parties, and I was not aware of any additional causes of action.
Did General Paxton order that an intervention be made?
Well, yes.
Let me ask you this way. Did you have a conversation with General Paxton in which he expressed his request or order that the intervention be made?
Yes, I did. So General Paxton eventually came to me, and this was my first involvement with this case, substantive involvement, right? There are 34,000 matters.
Okay. So let me get it this way. Was this on your radar screen at first?
No.
How did it get on your radar screen?
It got on my radar screen because General Paxton particularly wanted to intervene in this matter. I don't think my first discussion about this matter was with General Paxton. I think it was probably with Jeff Mateer. But at some point soon thereafter, I had a meeting with General Paxton, and he expressed a high level of interest and some insistence that we should intervene in this matter.
In your experience, had General Paxton ever expressed interest in any litigation involving charitable trusts that the Attorney General was involved in?
Objection, Your Honor. That's speculation.
Sustained.
Had there been any other litigation involving charitable trusts that you'd had any conversations with General Paxton about?
I did not.
I'm sorry, I didn't hear you.
There were not, no. I had no other conversations about any other charitable trusts.
What was your thought about General Paxton getting involved in this litigation?
I did think it was unusual at the time.
I'm sorry?
I did believe that was unusual at the time. And that's probably all I thought about it at the time. We had so much going on in my divisions at that time with COVID and the Google lawsuit, et cetera. I did not spend a great deal of time thinking about it other than sort of a mental note that was out of the ordinary.
All right. So at any rate, did the Attorney General's office file an intervention in that lawsuit?
We did.
At the time it was filed, do you rely on advice from your staff of attorneys that generally have hands-on handling of the litigation for advice?
Of course, I always
If we could have the
thought advice for them.
organization chart again, please. Down the list of people under you, there is a Joshua Godby. Who is he?
Your Honor, I'm sorry. Sorry, Mr. DeGuerin. Our screen shows the previous document. I'm not sure why that is.
I think you've got a glitch over there.
Clearly.
We have the correct.
I can tell the court reporter does, but for some reason our table has something completely different. And I'm not trying to take away your time. I'm not trying to take the man's time.
We'll pause the clock for a moment.
Literally just our table.
It's just our table that keeps doing this. I'm not suggesting a conspiracy, Your Honor. I'm just saying it's happening.
Are the rest of the tables of your attorneys have the right screen? Damien will come to the rescue.
Okay.
It looks like the senators have the right one. I'd request an extra 15 minutes for this delay.
I bet you could negotiate him down to 1.
We've given you 6 more minutes today, so plus we saved you 5, so you're 11 minutes to the good.
Mine's still just frozen up.
Mr. DeGuerin. Mr. DeGuerin.
And so what we're looking as they're trying to work out this technical issue is we are hearing the testimony of Darren McCarty, who is the former Deputy Attorney General for civil litigation within the AG's office. He is one of the 8 whistleblowers who reported Paxton to the FBI. And some of what he has been detailing for us in this early part of his testimony is about the lawsuit with the Midi Foundation. I'm listening to Patrick talk now. Let's listen in.
And then we may be finished by a little earlier this evening. So 10 minutes, come back at 20 minutes before the hour of 6.
And so there we have it. So they're going to take a brief 10-minute break. They're announcing that Darren McCarty is going to be the final witness that we're going to hear from today with the prosecution. Okay. I think there's a question that we want to listen in on. As you can see, that's happening on your screen there. Let's give it a moment to see. I'm trying to talk to you and pay attention to what's happening right now. So let's just give it a moment to see what they're going to talk about and listen to what Dick DeGuerin is about to say. He seemingly has a question as they're trying to work out a technical issue as to what's being shown on the screens. And not talking yet, so we'll go ahead and finish up Darren McCarty. As I was saying, McCarty is speaking about the Midi Foundation and the intervention of the Attorney General's office into a lawsuit between Nate Paul and the Midi Foundation, and that they were, the House managers say that Paxton was intervening in this lawsuit on Paul's behalf and in order to help Paul, which ran counter to what the Attorney General's office typically does, which is when they typically are on the side of a nonprofit or a charitable organization. And some of the questions, just based on some of the testimony that we've heard earlier, has to do with the Midi Foundation entering into a real estate deal, a multi-million-dollar real estate deal with Paul's company's world-class investments. We know that Paul is an Austin real estate investor. And so we're getting pretty early on into the testimony with McCarty. So let's talk about some of the other testimony that we've heard today as we are on this 10-minute break that we have. We started the day hearing from Brandon Kamek, who is a man who is directly named in one of the articles of impeachment against Attorney General Ken Paxton. Brandon Kamek came on and was hired to be sort of a special prosecutor for the Attorney General's office. And we listened to him talk about the details of how he was hired and what he did and his ultimate firing from the office. And some of the things that are interesting with his testimony, as well as the person who testified after him, which is Joe Brown, who is another attorney who also met with Paxton, interviewed, if you will, for this position of special prosecutor, is the experience between them. Brandon Kamek had been an attorney for about 5 years at the time when he had the conversation with Ken Paxton. Joe Brown, on the other hand, was the former Grayson County District Attorney. He served in that role for, I believe he said, 16 years. He was also a U.S. attorney, so a USA, and so he had much more experience as a prosecutor, whereas Brandon Kamek did not have experience serving as a prosecutor before he was hired by the Attorney General's office. Now, we learned from Jeff Mateer on the very first day of this trial, as he was detailing the hiring of Brandon Kamek, that there were actually 3 candidates being considered for this role of special prosecutor, outside prosecution, being hired by the Attorney General's office to look into the claims that Nate Paul was making against the federal government. And the first attorney, Mateer mentioned, because he didn't mention the first 2 by name, but he said the first attorney didn't have insurance in Texas, and the second was too expensive. Well, based on his testimony, we now know that Joe Brown is the attorney who did not have the insurance, and he told the AG that he would get, the needed insurance to carry out this investigation, though he did think it was strange that the Attorney General told him, I want you to carry out an investigation and look into a criminal case that my staff is not willing to cooperate on. Joe Brown actually said, and you have to remember, this is a former DA, actually pushed back on that and said, well, why didn't you just fire them if they're not agreeing to do what you're telling them to do? And he says Paxton told him, well, it's a little more complicated than that. I can't do that. But ultimately, he said that same thing to Brandon Kamek, that you would be investigating something that my staff refuses to work on. And Brandon Kamek was not off-put by that. That didn't raise any red flags for him. Instead, he saw this as a really big opportunity to propel his career, to work with the Attorney General's office of Texas and sort of move forward. And so really a big difference between those 2 attorneys and their testimony on that point. Brandon Kamek then went on to talk about how he was investigating and just really the access that he had to Attorney General Ken Paxton throughout all of this. He talked about eventually getting a separate cell phone that he just gave Ken Paxton the number to ensure that he would never miss a call from Paxton, because Paxton was calling him not on his official numbers but on 2 different cell phone numbers, and that he wanted to make sure he always picked up the Attorney General's call when he called, and so he had a separate phone line. He said that at Paxton's request, the 2 of them would send text messages using an app called the Signal app. And this is an app that has, according to the company itself, state-of-the-art end-to-end encryption. It also allows you to not only send encrypted messages, but to set a time limit of how long those messages are visible. And so those messages can self-delete if need be. And he also talked about communicating with the Attorney General using Proton Mail. And this is a private, secure, encrypted email account that we now know all of the top leaders in the AG's office had Proton Mail, particularly because for 2 reasons. One, they took a trip to China and they had concern about the Chinese government hacking their emails, but then also because they were in the process of suing Google, and so there was concern about Google having access to their emails, and so that's why they decided to use this system that's headquartered in Switzerland. And those were the ways that he communicated with the Attorney General. And interestingly, he said he never even knew that there was an Office of Attorney General, the actual official email, so the aog.texas.gov. He didn't even know that existed until he received a cease and desist letter from one of Paxton's top aides via his email from his official email address. And he got 2 of those cease and desist letters actually served to him. He also described what happened when, the end of him working for Ken Paxton and Ken Paxton and his staff, that he was summoned to Austin for a meeting with Paxton, and I say summoned to because Brendan Kamek is based out of Houston, and he was driving back and forth sort of at Ken Paxton's direction to and from Austin, and that he arrived at the office assuming that they were having a business meeting, but rather Paxton and his team got Kamek in a car with him and instead drove him to a Starbucks where Paxton, someone who he had phone calls with and text messages and emails, did not say a word to him, but rather it was Brent Webster, who was at that time Paxton's now, second in command, who actually said your contract is not voided, you no longer are working for us. And when Kamek asked about his payment, his $14,000 that had been billed, he said, well, you're just going to have to eat that. So essentially, we're not going to pay you for it. Even though you were doing this work on behalf of the Attorney General of Texas. And at some point, it's certainly worth noting, Kamek had a signed employment contract with, he says, Ken Paxton's signature on it. Now, this is significant because Article 5 accuses Paxton of misusing his power in the hiring and the laws governing the hiring of attorneys, because there is a process and a protocol by which the Attorney General's office goes about hiring attorneys, and Ken Paxton himself does not sign those employment contracts. And so it is significant then that not only A, that Ken Paxton has signed this contract, but also B, that Michael Wynn, Nate Paul's personal attorney, is who had the signed contract and who gave that contract to Brendan Kamek. And so really, we're hearing from a man who believed he had certainly been wronged by the Attorney General and the AG's office in him just doing out a job that he says he was hired to do. After hearing from Brendan Kamek and Joe Brown, we then had the third witness of the day, Kendall Garrison. Now, Kendall Garrison is the president and CEO of Amplify Credit Union. Amplify Credit Union has loans on 3 of Nate Paul's properties. He says that at this time, Nate Paul owed $11.5 million to this credit union, and they had not been receiving payment. And because of that, and keep in mind this is early 2020, because of that they had plans to foreclose 3 of Nate Paul's properties. But that foreclosure was in fact halted after they received a copy of an opinion from the Attorney General's office saying that due to Governor Greg Abbott's COVID orders, foreclosure sales could not happen in the state of Texas. And so this is very interesting because it as well speaks directly to one of the articles of impeachment against Attorney General Ken Paxton. Article 2 claims that he misused his official power to write legal opinions, and that he did that and had his employees reverse their legal conclusion to benefit Paul. And if we talk some more about exactly how that happened and what happened to make that happen, that reversal of opinion. So Ken Paxton says that he asked his employees to write an opinion about whether or not foreclosure sales could happen during the pandemic. They say they wrote that opinion to say, yes, they can in fact happen. And when Ken Paxton reviewed it, he said, no, I wanted to say no, that the sales cannot happen, go back and fix it. And this was all happening, we should note, very quickly. We're talking over the weekend.
Yes. They called it the midnight opinion.
The midnight opinion, because this was not typically how they did this. It would normally take, weeks, if not months, to create these opinions. But they did that at the request of Attorney General Paxton. And what's notable about the opinion process is there has to be a solicitor for one of these opinions, and not anyone can solicit such an opinion from the Attorney General of Texas. It would have to be a lawmaker who is a sitting chair of a committee or
I think in some instances, can a government entity request an opinion as well?
In terms of open records,
right?
But
exactly.
in terms of a general opinion such as this one, there's a very limited.
This
number.
Was not dealing with open records.
There's a very limited number of people who can actually request one, and so Paxton, according to the witness, gave his attorneys the number of someone who he says solicited the opinion. The attorney said that when they called that number, a gentleman answered who had no idea what they were talking about, had not requested an opinion, didn't even know what this was, and that later State Senator Brian Hughes requested that opinion. Hughes, a longtime friend of Paxton, who has said he requested it because Paxton asked him to do it.
Brian Hughes, one of the jurors in this case,
and directly named in that article of impeachment, that article that we're talking about, Article 2, and so. All of that to say, when Kendall Garrison took the stand, he said once they received that opinion on a Sunday, I believe he said, which was very odd because, again, you're getting this on a weekend and not a weekday, that they stopped the foreclosure sales of Nate Paul's properties.
Exactly, and again, that concluding testimony from Darren McCarty, now making 6 of the 8 whistleblowers we have heard from. Actually, I was just having a conversation with some local attorneys who have been following this as well. And James Wood, our guest earlier today, made this point, and that is whether or not or when Mindy Montford, who is a former first assistant for the Travis County District Attorney's Office, she was involved in conversations with Ken Paxton in which he apparently or allegedly was trying to convince the Travis County District Attorney's Office to investigate this matter as well. But those attorneys who I was talking to suggesting that she could possibly be the final witness for the House impeachment, given impeachment managers, given her reputation in the legal community, not only here in Austin, but across the state. They were suggesting that perhaps her testimony could in fact be powerful and a strong note for the House impeachment managers to end on.
And certainly interesting because yesterday we heard from former Travis County District Attorney Margaret Moore, whom Mumford was working under, and she actually read a letter that Mumford wrote to the AG's office to say, we do not have the resources to investigate Nate Paul's claims. And we think that this is better suited for you all to handle, not for us to handle.
Well, and Margaret Moore said on the stand yesterday, she told me at the time that this was happening, when all of these allegations first broke loose in October 2020, how preposterous it was that the local district attorney's office would investigate the FBI and a magistrate judge, and whether or not a clerk was in on this, that it was just nothing that they would ever investigate. And in fact, Margaret Moore saying yesterday that when they routed that complaint, the referral to the AG's office, that she personally called David Maxwell because, in her words, I wanted to make sure he knew I had the good sense enough to know that this was not a viable complaint.
Well, also interesting to hear her discuss and say, what she saw as offense. She almost took offense to this idea that the FBI was doing, was involved in such wrongdoing, which was sort of the line of questioning she was being asked by the defense attorney, to say, I worked with the FBI. They would not be doing this. You can see there that they're
Mr. DeGuerin, before you
calling
start, I think we
everyone
had one
back
correction
in,
on the exhibit
and
list I was told about.
before
there was
they
one mistake. These are exhibits that both sides agreed to.
Okay, we just needed to listen in on what he was saying as they're talking about the exhibits and the evidence that they're talking. But
it was incorrectly,
let's listen
inadvertently represented that we agreed to the following exhibits. So the following exhibits have not been agreed to for pre-admission: AG Exhibit 334, 335, 336, 337, and 345.
Thank you. Mr. DeGuerin, you may continue.
Thank you. I started to ask you about Josh Godby, who's shown on the organizational chart as being several levels below you. Who is Josh Goudeau? Yep.
Josh Goudeau was the division chief for financial litigation and charitable trusts. Actually, was not several levels below me. He reported sort of directly to me and David Hacker, who was my associate deputy attorney general for civil litigation.
Okay, and I asked you about that because I wanted to ask you whether in deciding any intervention in a charitable trust litigation, do you rely on advice that you get from the people in the trenches, the ones that work on it?
I certainly seek and consider that advice, yes.
Well, with the Midi litigation, was Mr. Goudeau opposed to an intervention?
He did not believe an intervention was necessary.
And yet you intervened. Why?
We intervened because the Attorney General Paxton, believed that it was.
I'm not asking what he believed. Did he tell you to intervene?
Yes, General Paxton told me that we should intervene in the litigation because the Midi Foundation was wasting a lot of money on unnecessary litigation, and that the Midi Foundation had management problems in the past, although those are pretty far in the past, I think, at that point. And that it didn't make sense for this lawsuit to continue and go forward, and that we needed to try to intervene and see what we could do to bring it to a conclusion.
Well, what was one of the reasons that the Midi Foundation was wasting money on attorney's fees?
Well, they were locked in a very, very contentious litigation with the world-class limited partnerships that were headed by Nate Paul.
Is it true that in the type of lawsuit that the Midi Foundation originally brought, if they were successful, the Midi Foundation would recover their attorney's fees?
I don't know, actually.
At any rate, we've previously seen that there were, I think, two people that wrote the waiver menu. The waiver memo, a woman named Henderson and a woman named Day. They're not even on this chart. Were they further down in the hierarchy?
Yes.
Okay. So when General Paxton asked that you intervene, did you do so against the advice of Josh Goudeau and who you relied on for advice?
Objection, Your Honor. This is calls for hearsay from people that haven't testified.
Sustained.
Okay. I want you to describe for the senators, please, the level of interest that General Paxton took in the Midi Foundation litigation.
Objection, Your Honor. Speculation.
As you observed.
Sustained and re-asked.
Well, I was trying to cure the objection by saying that you observed. Describe for the Senate the level of interest that General Paxton took in this litigation, as expressed to you by General Paxton himself.
Again, Your Honor, if he wants to tell us what General Paxton may have said to him, I won't object to that, but just telling us what was in his mind, he cannot do that.
I think that's what I asked.
Speculation.
As expressed to him by General Paxton.
I think that's what you asked. Overruled.
You may answer.
General Paxton expressed sort of more interest in the Midi Foundation litigation than almost anything else that my divisions were interested in. There was a certain urgency and almost anxiety around what we were doing in the Midi Foundation lawsuit, to the extent that, at times I got calls, I remember a call very early in the morning one time. I got pulled out of an important teleconference that I was in to talk about the Midi Foundation. That was highly unusual. That really didn't happen with any frequency about anything. And, General Paxton wanted to be kept abreast of any developments in the Midi Foundation lawsuit.
Was there other major litigation going on that you were supervising?
Well, at the time...
That's a yes or no. Was there other major litigation?
Well, yes, absolutely.
What was the Google investigation and litigation?
So I have been tasked to lead the Google antitrust investigation that was being conducted by a number of states. So it was a multi-state investigation, I believe 48 states at that point. Only Alabama and California had not joined. And we were investigating Google search function, antitrust potential violations, and the Google ad tech antitrust violations. Texas was really the lead on the ad tech issues. So I sort of had a day job that was overseeing the divisions, the civil divisions. And then in addition to that, I was trying to provide a leadership role for all the states on those investigations. And, of course, both of those investigations, probably most of the people here know, resulted in significant lawsuits filed not only by Texas, but follow-on suits by the federal government and even in Europe.
So, in a nutshell, was the Google litigation a major involvement of the Attorney General's office? Yes or no?
Absolutely, yes.
And compare the significance of the Google litigation with the significance of the Midi Foundation against Nate Paul litigation.
Well, the Google litigation, of course, has had the potential to impact virtually every Texas and U.S. citizen, and frankly, citizens across the world. The Midi Foundation litigation, as I understood it, was, a dispute that Texas, in my view, did not have any significant interest in. And, I believe that the Midi Foundation was being, especially when I got involved with it, I believe that the foundation was being zealously represented.
Okay. And that's one of the criteria for intervening or not intervening. If everything's going smoothly with the foundation, they're zealously represented, correct?
Yes.
All right. So, I think you mentioned being interrupted as an example of General Paxton's interest in the Midi litigation as opposed to anything else. Was there an occasion when you were interrupted during an important Google conference? Yes. Or no?
Yes.
Okay, what was that occasion?
I recall that I was on a teleconference with an international economist of some reputation, trying to interview that economist to decide whether he would be a good fit to work on the Google investigation at that time and possible litigation. And General Paxton sort of opened my door and I put it on mute, and he said, "Hey, can you come down to my office?" And I explained roughly what I was doing, and I said, "Should I break this off and come down?" He said, "Yes." So I did, and I went to his office and we had a discussion about the Midi Foundation.
Did that seem unusual to you, that he would pull you away from an important conference on the major litigation over Google to talk about the Midi Foundation litigation?
I don't recall another time when General Paxton interrupted a conversation or discussion with anyone else I was having to pull me away.
Let's talk about some of the things that you were requested to do. Did there come a time when you received, and you were on the email chain, of complaints from Nate Paul about how the Attorney General's office was handling the Midi Foundation litigation.
Yes, after I had
Okay, that's the answer to that.
Yes.
Then I'll ask you about it.
I'm a lawyer. I'm a bad witness. I'll try to be better. I'm sorry.
Lawyers are some of the worst witnesses. Yes, I agree. So what happened with the emails that the office and you were copied, and particularly Josh Godbee was getting from Nate Paul?
Yeah, so we got a few communications. I don't remember how many, from Nate Paul, and I think one was either from Nate Paul or from Michael Wynn copying Nate Paul or something like that, vigorously complaining in really sort of a demeaning fashion about our work in the Midi Foundation lawsuit, and demanding that we do more in the lawsuit, sort of taking a tone of directing us.
Let me stop you there.
Mm-hmm.
So you said it was the emails were taking the tone of Nate Paul directing you, the Attorney General's office?
Your Honor, I object. We have the emails and we can look at them, but this is misrepresenting what the emails say, and I object to it.
Well, let's look at the emails. I agree. House Managers 86, it's in by agreement, if you could pull that up. Let's start. Let's start on the second page of that. At the bottom of the second page, an email from Nate Paul to Josh Godbee in the Attorney General's office. I'll just read that first line. Josh, I am following up to my previous emails for the fourth time. Your decision to not even respond to my emails has only amplified my concerns about your bias toward helping the Midi Foundation. You see that?
I do see that.
First, is it proper for a litigant who's represented by counsel to contact the lawyer for one of the other litigants? Is it or not?
It's certainly not something that's certainly something that's generally not done. That is correct.
All right. A little bit above that, a little bit later, July the 2nd, Josh, I need to hear from you. You are delaying this and it is unacceptable. Is that the kind of tone that you're used to receiving from a litigant?
Absolutely not.
The first page of that exhibit, Sunday, July the 5th, from Nate Paul. Josh Godbee, Josh, you have exhibited highly unprofessional behavior. You see that?
I do.
And above that, Josh, I just wanted to make sure your office is aware that you never responded to any of the emails below. First, what's your testimony about whether it would be proper for Joshua Godbee to respond to Nate Paul's emails?
That was something that we would not typically have done.
So, what was your thought about what was going on here and how Nate Paul was treating the Office of Attorney General?
Well, I thought his tone was demeaning and demanding and wholly inappropriate, because thinking about this, the way this is structured and the way our involvement with charitable trusts is structured, is we are making the decisions about what is in the public interest of the charity, not somebody who's working against the charity in a lawsuit.
Now, while this is going on, what's your contact with General Paxton about what you're doing in the Midi Foundation lawsuit?
I was having fairly regular conversations with General Paxton about.
What was he asking?
He was asking, about ideas for how we could really get to a point where we could terminate the litigation. I think he was looking for a creative way to do that. And, and I don't mean creative in a sense of outside, legal means, but a creative way for us to, our involvement to accelerate the termination of the lawsuit.
Let's talk about that for a second. Yeah. To accelerate termination of the lawsuit, in essence, was the lawsuit, the Midi Foundation suing Nate Paul because they were claiming that he was cheating them.
Yes.
And so...
In so many words, yes.
Well, I was trying to shorten the description of it a little bit. And so if that's the fact, if they're suing Nate Paul for trying to cheat him, what's the public interest in the Midi Foundation litigation for the Attorney General to take? Which side are you supposed to take?
Well, we're clearly supposed to take the side of the foundation.
And what was General Paxton's direction to you?
General Paxton was highly critical of the Midi Foundation's litigation efforts, and he characterized those to me as being overly zealous and wasteful.
Okay. Did you become aware during this time that there had been a settlement of the lawsuit previously by mediation between Nate Paul's interests and the Midi Foundation?
Yes.
What was that settlement? What was the dollar amount of that settlement, if you remember?
It's testing my memory a little bit, but I believe that Nate Paul's entities had agreed to pay the Midi Foundation $10.5 million to buy out their interests in the world-class properties.
And did he pay it?
No, the world class did not pay it and therefore breached the settlement agreement.
And that was a settlement agreement after mediation?
After a mediation, yes. Can I pause there? I actually don't remember whether it was the result of a mediation, but it was certainly the result of some negotiation.
Fair enough. Did General Paxton press you to move for a second mediation? I know you don't know whether it was second or first, but did he press you to move for a mediation?
Yes.
Now, was Mr. Godbee supposed to be handling this?
Mr. Godbee had sort of taken frontline responsibility for this prior to my involvement, yes.
And after these emails where Nate Paul was criticizing Josh Godbee and his handling of it, what did General Paxton tell you to do?
Well, on more than one occasion, he asked me to be directly involved.
Is that unusual?
Incredibly unusual for someone in my role at that time, yes.
Explain why that's incredibly unusual.
Well, as I said before, we had 12 divisions, we had 325 lawyers, and we had 34,000 open matters. So for someone in my position to have direct involvement in any particular litigation what was just highly abnormal. And so in my experience during the 2 years I was in that position, there were only a very few limited examples of when I was directly involved in litigation.
Okay.
Very few.
So ordinarily, would it be handled by somebody down the chain?
Yes. I might be advising if there were a problem or it was significantly important, but not important enough for me to be indirectly. But for me to appear and be personally involved was highly unusual.
So did there come a time when General Paxton ordered you to appear in a hearing?
He did call me very early one morning. I want to say it was sometime around 7:30, and asked me to appear at a Midi Foundation world-class hearing in Travis County District Court that morning.
Now, not to diminish the importance of a Travis County District Court, but educate the senators on whether the appearance of a deputy attorney general in district court in Travis County would be unusual.
I only did that one other time during the course of my role, and that was when Google contested our right to get information under a confidential information demand issued by our antitrust division.
But in this case involving the Midi Foundation lawsuit trying to get or suing Nate Paul for fraud or cheating him, what's the unusual thing about having a deputy attorney general appear there?
Well, I think in retrospect it certainly sends a message of interest from the Attorney General's office that's highly unusual. And also, that, as I recall, that hearing was going to be a very long hearing. I think it was scheduled for a very long period of time. And, obviously there were a number of things going on at the AG's office, and we've concentrated on the Google matter, but the COVID matters were hot and heavy, I think, still at that point. There were mask mandate issues, and there were also, we were getting calls and concerns from major cities about potentially releasing people from jail that have been accused of violent felonies. I mean, there were times.
Okay, let me stop you there.
Yeah.
So what you're saying is you had a lot of other stuff on your plate.
Yes, particularly at that time.
And you get a call at 7:30 in the morning from General Paxton asking you to appear in Travis County District Court on motions that might last all day?
My recollection is that it was to be a lengthy hearing, yes.
Were you prepared?
I was not prepared at all.
What did you say to him?
I said it didn't make any sense for me to do it. Because I wasn't prepared and because of the time and all the other things I had scheduled that day.
And what did he say to you?
He said, well, then I'll do it.
He'll do it? General Paxton will himself go to district court in Travis County to argue a motion?
Yes, that's what he told me.
What did you think about that?
Well, I talked him out of it.
What?
I talked him out of it.
Again,
I guess what I thought about it was that it was a terrible thing for him to do.
And why?
Because he was the Attorney General of Texas. He never appeared in court, not once, not a single time. And, as a representative, right, as a lawyer, I should say, let's put it that way. And for him to make an appearance in that type of hearing sends a very odd message. And it didn't seem appropriate for our office to have that sort of level of involvement in a case like this at all.
Okay, I don't want to get too far in the weeds of all the stuff that happened in the Midi Foundation litigation, but was there an occasion where General Paxton told you to go to a mediation, a virtual mediation, but told you to go to a mediation?
Yes.
And what did General Paxton tell you to do as far as trying to get the Midi Foundation to accept less than they'd accepted before?
Well, General Paxton asked me to attend the mediation on behalf of the state and work to get a settlement in the case for, to essentially terminate the litigation.
What do you mean by terminate the litigation?
Well, via settlement. Terminate the litigation via settlement. And so we worked hard. We actually filed a motion to stay the proceedings in favor of mediation.
Let me ask you that. As I said, I don't want to get in the weeds of what happened. The motion to stay the proceedings, of mediation, pressure during the mediation. In retrospect, and knowing what you know now, was that in the public interest of the Midi Foundation for the Attorney General, Paxton, to take that position? Yes or no?
Knowing what I know now, no.
Why not?
Because our involvement in the Midi Foundation litigation added complications for the Midi Foundation. And we stayed, and briefly, and I was pretty adamant that we needed to do it quickly if we were going to stay the proceedings. But, it stayed the proceedings for a period of time. I think that the Midi Foundation saw it as fairly heavy-handed. And it just,
Let me ask
knowing
you
now
about
what I know, I don't think that we were helping the Midi Foundation in any way.
Say that again. You were not helping?
We were not helping.
Wasn't that what the Attorney General's office is supposed to do?
We are supposed to protect the public interest in charitable trusts.
And as it turned out, were you actually trying to protect Nate Paul's interest because that's what Paxton told you to do?
Objection, leading.
That is leading. I'll rephrase it. What did General Paxton tell you to do? Whose side to take in the mediation?
Well, he told me to contact Sheena Paul, who was Nate Paul's sister, and work with her to, sort of develop a strategy for the mediation, or a strategy. I mean, I don't know if he said the word strategy, so I don't want to, I want to be careful about what was actually said, but he told me to call her, try to understand their position, and, I think he said, sort of dramatically, I just want all this to end.
General Paxton said he wanted all this to end?
That's correct.
Was that in the best interest of the Midi Foundation or the public interest in it?
Well,
yes
certainly.
Yes or no?
Can I explain?
You can, but I'd like to get a yes or no to that. Was that in the best interest of the Midi Foundation or the public interest in it, or was it in the best interest of Nate Paul?
Well, understanding everything that was going on and the fact that the Midi Foundation thought that there was far more return on this investment available than I think even the $10.5 million settlement that had been reached before. No, because it was clear that we were not going to settle for $10.5 million. The Midi Foundation was not going to settle for $10.5 million. I'm sorry. They were not going to get $10.5 million because the world-class entities were not going to offer it. And they thought that they could get more than the 10.5 through litigation. And so no, we were not helping the Midi Foundation.
Did the mediation fail?
It did.
And so after that, and getting forward now to the end of September, what did you learn about the Attorney General's office involvement in other matters that involved Nate Paul?
Objection. This answer calls for information based on hearsay. Sustained.
On September the 29th, did you get a call?
Well, on September 29th, I was called to a meeting.
Where?
In Jeff Mateer's office.
Without going into what was said, one of the previous witnesses today was a young lawyer named Brandon Kamek. Did you learn anything about him, yes or no, that day? I'm not asking you what you learned.
Yes.
And did you learn or see subpoenas, grand jury subpoenas, that had been issued to players in the Midi Foundation case?
I saw a criminal grand jury subpoena that had been issued to a bank.
What was your reaction to that?
I was stunned.
What do you mean? Explain it.
I saw a criminal grand jury subpoena directed to a bank that was clearly seeking information that would have aided world-class Nate Paul's efforts against the Midi Foundation.
Why is that bad?
Well, it's one thing is it's lawyer ethics 101, so that was the first thing that came to my mind. We are weaponizing the criminal process to aid a civil litigant, and that is a big no-no.
So, as far as the Midi Foundation was concerned, and now you learning about these grand jury subpoenas issued to players in the Midi Foundation lawsuit, what was your opinion about what had happened to the Midi Foundation as a result of the Attorney General Paxton's request that, or demand that you become involved?
I believed that the Attorney General's office's involvement in the Midi Foundation litigation was unethical, against our statutes, and I highly suspected corrupt.
What did you do as a result? By the way, did you attend a meeting, a conference between a number of the deputies of the top deputies of the Attorney General's office?
I did.
And did you trade information?
Yes.
Did you learn things that you had not known about before?
Several.
And did it concern you?
Deeply.
What did you do with regard to the Midi Foundation litigation as a result of what you learned?
Within 24 hours, I don't remember exactly how quickly, I ordered Mr. Godby, the head of the Charitable Trust Financial Litigation Division, to dismiss our intervention in the lawsuit.
House Manager's Exhibit 92 is in evidence by agreement. This is an email from you dated September the 30th, 2020. It's to Josh Godby, Rachel Obaldo. I don't believe we've heard her name before. With copies to Mateer and to Bangert. What did you order done?
Please immediately withdraw from and cease all representation, investigation, or participation concerning the Midi Foundation that may in any way whatsoever relate to World Class, its related entities, or NAPOL.
You let your voice trail off.
I'm sorry, it may have been the microphone. I can read it quickly. Please immediately withdraw from and cease all representation, investigation, or participation concerning the Midi Foundation that may in any way whatsoever relate to World Class, its related entities, or NAPOL.
And why did you do that?
I did it because I believed at that point that the AG's office intervention into the Midi Foundation was unfounded And as I said, I believed unethical, and I believed it was actually attacking a charitable trust as opposed to defending the public interest in a charitable trust. I believed I had an ethical duty under our rules because we had now used the criminal justice system essentially against the Midi Foundation. And, frankly, my name, my colleagues' names, including Jeff Mateer, Josh Godby, I think Ryan Bangert, and now my recollections refresh, Rachel Ubaldo. Importantly, the Attorney General's name, and maybe most importantly, the state of Texas's name, had been used and invoked improperly, clearly improperly, against the Midi Foundation that was a public charity.
Were you one of the 7 deputies that went to the FBI?
Yes, I was.
Why, briefly, did you go to the FBI? First, did you want to?
Absolutely not.
And did you decide to be one of the 7 that went to report to the FBI?
Yes.
Why?
Because I believed that the Attorney General's office had been, and its resources, and I'm sure those in this room understand that the Texas Attorney General's office is one of the most powerful in the nation and incredibly important for a number of reasons. And I believe that it had been turned over by Attorney General Paxton to a private citizen to do his bidding, and it was acting against the interests of the state of Texas. And in my own experience with the Midi Foundation, I believe acting against another citizen, a charitable trust and all of its beneficiaries, in the state of Texas, and that the criminal process that had been initiated that I just learned of was potentially immediately endangering the public, the Midi Foundation, and potentially others.
Did you and the others ask General Paxton to meet with you after that?
Jeff Mateer, I recall, sent General Paxton a text asking him to meet with us.
And did he meet with you?
He did not.
I want to talk very briefly about any retaliation against you for being one of the persons that went to the FBI. Were you retaliated against?
Well, yes, frankly, and I want to make this clear, I don't believe I suffered the level of retaliation that some of my colleagues did. However, I remember the first thing that I was sort of stunning to me was that I saw a press release released by our office, not by General Paxton or his campaign, but by our comms office, a press release that said officials in his office were being criminally investigated for impeding, impeding an investigation or something of that nature, which was sort of shocking and I suppose supposed to be intimidating.
Was that true or not?
I am not aware of I was never made aware of any sort of criminal investigation of any of my colleagues, no.
Were you called a rogue employee?
Absolutely.
Do you believe you were a rogue employee?
No, I believe that I was doing what I had to do, as unpleasant as it was, and it was quite unpleasant.
I'll pass the witness, Your Honor.
Mr. Busby. Are you represented by a lawyer?
Yes, sir.
Is it Johnny Sutton? Let me guess. It's Johnny Sutton?
Yes.
And how much have you paid him so far?
I have not paid Mr. Sutton anything.
So just like all the other ones of you, Johnny Sutton's been working on your behalf, spending his days here with all you guys for free?
I don't know.
You don't even know what you owe him, do you?
No, I don't know what I owe Mr. Sutton.
What's his hourly rate? Do you even know that?
No, we have never entered into a fee agreement.
So what? So just so we're clear, you don't know what you owe him, you don't know what the agreement is, and you don't even know what his hourly rate is. Is that right?
I'm not sure I owe him anything, but I don't know.
You say under oath you don't owe him anything?
I don't know that I do, no.
Johnny Sutton, who's standing there to my left, according to you under oath, could very well possibly be working for free.
He could be working pro bono correctly.
Okay, you don't know.
I have not asked him. Mr. Sutton did a significant amount of work for us rather immediately. I knew Mr. Sutton and I called him at the last minute before we went to the FBI.
The question was, you don't know, do you?
Whether
you don't know what you owe him or what his rate is. That was a question. You don't.
Yes, that's correct. I don't.
Okay. What you do know is that Jeff Mateer attempted to have the Attorney General's office set aside $50,000 for that man right there, Johnny Sutton. Isn't that right?
I don't know that Mr. Mateer attempted to do that.
You didn't know about that?
I knew that there was a discussion about it, but I don't know that Mr. Mateer attempted to do that, no.
He sent an email to the controller. He sent an email to Lacey Mays. You didn't know any of that?
I did not.
Now, I just want to make sure we're clear. You don't know it. You don't have any personal knowledge about any house repairs of General Paxton, do you?
I do not.
You don't have any personal knowledge about a job for Laura Olson, do you?
I do not.
You don't have any personal knowledge about whether Nate Paul donated $25,000 2 years before all these events that we're talking about, right?
I think I do know that, but I'm not.
Thing about campaign donations, if anybody wants to see who is giving money to what candidate, all they have to do is get on the Texas Ethics Commission's website and can figure that out pretty quick, right?
And I think I did that, yes.
And it's not secret, is it?
No.
Okay. You don't know anything about late night legal advice, at least, or legal guidance. You didn't have a role in that, did you not?
Well, I certainly didn't at the time, no.
Okay. I'm just talking about what you knew.
Yeah.
You didn't know anything about whether there was any foreclosures stopped, right?
Not at the time, no.
You don't know anything about some secret meeting in an alleyway in the dark of night between Nate Paul and young Drew Wicker, right?
No, I don't.
That sounds ridiculous, does it not?
Not necessarily.
Did you know this guy Maxwell, this Texas Ranger, this guy that's in the Ranger Hall of Fame, you know who I'm talking about?
Absolutely.
Did you know that he told these people when he was interviewed that there had been a secret meeting in an alleyway in the dark of night where a folder was handed over from Drew Wicker to Nate Paul? Did you know he had said that?
No,
Objection. Cross-examination by what someone else might have said is not proper.
Sustained.
He said he heard that from 5 or 6 people. Did you tell him that?
I did not tell him
Okay.
that, no.
And you didn't have any role whatsoever in the retention of outside counsel at the AG's office, did you? I'm talking about specifically Mr. Kamek.
Oh, that retention of outside counsel? No.
Okay. So that just kind of forecloses. Sounds like what you were involved in was the Midi Foundation intervention as it relates to this proceeding. True?
I think that's largely yes.
Yeah, so when we talk about personal knowledge, and you know what 602 personal knowledge is under the rules, do you not?
Reasonably well.
Yeah, you're not supposed to testify about things unless you have personal knowledge. That's rule 602 of the rules of evidence, right?
I'll take you at your word. It's 602. I don't remember the number, but yeah.
I had a federal judge that made me learn the numbers, so they're burned in my brain. So let's talk about what you actually have personal knowledge of. You know, Mr. DeGuerin has been telling us, using the words ordered, demanded. Remember him using those words?
He may. I'm not sure, but he may have.
I mean, we know General Paxton. We call him General Paxton, but he's not in the military, is he?
No.
Okay, he doesn't go around barking orders, does he?
I would not say he barks orders.
Yeah, this guy, if anybody's ever dealt with him knows that he's pretty low key, pretty laid back, right?
That's a hard description for me to use.
But he's not some right-wing, crazy authoritarian walking around in lockstep, is he?
Well, that's a hard way to say it. You know,
to give you an easier way to say it.
Yeah.
He's not the kind of guy that screams at people and tells them, you go do this, you go do that. He doesn't do that.
Well, I can't answer yes to that because I have heard him do that before.
Okay. Now let's focus. Eric, could you put up Article 1? Since you're here to talk about the Midi Foundation intervention, it's titled Protection of Charitable Organizations, right?
I'm reading it? Yes.
Yeah.
Yes.
I mean, you've read this before, have you not?
I have read this before,
Sure.
yes.
And you knew you were here to testify and that most of your testimony would probably relate to this article, right?
Well, the Midi Foundation, yes.
Sure. The very first sentence, protection, or I guess you should say the second sentence, protection of charitable organization there, that's not even correct, is it? Because that's not what the role of the Attorney General's office is it?
Well, we're tasked with protecting the public interest in charity.
Protecting the public interest in charity, isn't that right?
That's right.
Not protecting charities, right?
There's some overlap there.
Some overlap, but that's not what the AG's role is it?
No, that's right. I mean, we are not obligated to protect charitable trusts generally as, you know, if they are protecting themselves, for instance.
Now, we'll come back to that, but let's look at, I know you were several levels up the chain of command over Joshua Godbey, but it was Godbey who was in charge of the charitable trust area, true?
There was a division at that time called Financial Litigation and Charitable Trusts, and that was under Josh Godbey.
Okay, and you, of course, are familiar with the role of the AG's office in charitable trusts.
I am generally familiar with that role, yes.
You told me it's highly unusual, I think you told Mr. DeGuerin, it's highly unusual for the AG's office to get involved with charitable trusts, right?
It's highly unusual. I don't think I used that term. I think I used the term that it was something that we did, but it was not, it was not a huge volume of work that we did, but that we did intervene in some number of cases every year.
Okay, then because it sounded like, and I thought it sounded to me like you were making the case that this was incredibly unusual for the AG's office to get involved in any litigation involving charities. That's not true at all, is it?
No.
Okay.
No, the AG's office from time to time would be involved in litigation involving a charity.
Because the AG's office gets complaints every year about charities, does it not?
Well, it gets complaints and it also gets notified of lawsuits.
I'm on a time clock, and if you could just answer my question, I'd really appreciate it. Can you do that for me? Just answer it, okay? Is it true that the AG's office gets many complaints every year about charities?
I'm having trouble answering that.
I'll help you. Eric, pull up 429, AG 429. Somebody prepared a PowerPoint about the AG's role with regard to charities. Do you see the first page?
Yeah, I was involved in preparing this.
Right. It says, protect the public interest in charity. See that?
I do.
Now, turn the next page, Eric. One of the questions Mr. DeGuerin asked you was how many charities or foundations there were in Texas. Remember that?
Yes.
Now we know what the numbers are, don't we? First bullet point.
Yes.
It's right there in black and white. As of December 2019,
yes,
over 102,000 charities and about 7,500 private foundations, right?
That's what it says, yes.
Okay. It even provides the gross assets. See that?
Yes.
Next page, Eric. Eric, is this straight? There we go. And if we wondered, if the jurors wondered how active the AG's office was, in fact, how active it was with regard to charities, it's right there in black and white, right? These are the number of complaints received in fiscal year 18, 19, and 2020, right?
Yes.
So now we know.
As I see it here, yes.
Yeah, now we know, right?
Hmm.
Right?
Well, now we know how many, yes.
Okay. So let's go. And you know, of course, that the Midi Foundation had a sordid history. True?
I know that they had, we had been involved with an investigation of some nature of the Midi Foundation, I believe, in the late 00s.
Yeah, I mean, let's all be clear. Not only had the AG's office been involved with the Midi Foundation, the AG's office had, in fact, sued the Midi Foundation. Isn't that right?
I'll take your word for it, but I don't.
You don't need to take my word. Exhibit 223, Eric. You know what an original petition is?
Yes.
That's a lawsuit, right?
It is.
That's a lawsuit where Greg Abbott was the Attorney General, right?
It appears to be, yes.
And Greg Abbott sued the Midi Foundation. Do you see that?
I do.
And have you ever looked at this lawsuit before and all of the allegations made by the AG's office against the Midi Foundation?
I cannot recall whether I looked at this specific petition or not.
Page 4, Eric. In case any of our jurors wanted to see the long and sordid history of the Midi Foundation, it's right there in black and white, prepared by the Office of the Attorney General. See that?
Well, I see the allegations here, yes.
Yeah, well, you wouldn't think that the AG's office would just make allegations with no proof, would you?
Well, I'm not suggesting that. I had no personal involvement in this. I have no personal knowledge.
Right. And you know, of course, that this lawsuit that Greg Abbott's office filed when he was the AG led to a settlement and a consent decree?
I believe all I know about it, if you want to know, is that I believe one or more officers or board members of the Midi Foundation were removed for some sort of violations.
Now, let's move forward in time to June of 2020. Eric, bring up AG 42. What's supposed to happen is that when a charity is involved in litigation, a notice is supposed to be sent to the AG's office so it can do its job. Is that right?
So that it can assess whether it should become involved.
Whether it's within the public's interest to intervene or get involved, right?
I don't know if there is a more specific analysis, but that would certainly be a consideration, yes.
One thing you know is that on at least 2 occasions, the Midi Foundation failed to send timely notice to the Office of Attorney General. You know that, don't you?
I don't.
You don't even know that?
No, I don't.
Okay. What we have here, AG Exhibit 42, is a notice letter sent from some of Nate Paul's entities regarding some what they claim to be changes in the litigation. You see that?
Is it possible to blow it up just a little bit?
Eric, bring up the body of the letter. Thank you.
Thank you. Okay, I'm sorry, if you could re-ask.
The point is, notice was sent by Nate Paul's organizations informing the AG's office of the litigation and also that at least from their point of view, there'd been some sort of change in the circumstance.
Okay, I didn't see the letter, but I assume this letter is from Nate Paul's organization.
Yes, sir.
Okay.
Okay.
I see that.
All right. And you know, of course, that the AG's office was provided with a very lengthy memo laying out not only the past problems with Midi Foundation, but also current problems with the Midi Foundation. True?
I did see that memo, yes.
This was a very lengthy and detailed memo, was it not?
It was a lengthy and detailed memo.
And if our jurors want to see what the justification was for the AG deciding to intervene into this Midi Foundation litigation, they could look at AG 33. Would you put it on the screen? You've seen this memo before, have you not?
Did you want me to answer? Was there a question before this, or do you?
No, this is the question. You've seen this memo before, have you not?
I have seen this memo before, yes.
This memo is, it goes on and on, page after page, does it not?
I don't know how many pages. It looks like there's 6 pages.
Well, it's got a lot of attachments too. Look over here. Sir.
Gotcha.
Okay.
Right.
All right. And this is something that you looked at before you signed off on intervention in the Midi Foundation case, right?
Likely.
Okay. And let's get to that. Eric, bring up AG Exhibit 151. You had told us about this bureaucratic procedure where this person signs and then it goes to the next person and then the next person up the chain of command, right?
Well, I wouldn't characterize it that way, but there is a procedure by which several people approve an intervention into a charitable lawsuit.
And that's what we're looking at here, true?
That is correct. Related to the Midi Foundation, yes.
Right. And we can see that Mary Henderson signed off?
Yes.
And that was the same Mary Henderson that previously had been part of a memo saying that we maybe shouldn't get involved 6 months prior?
Yes.
Okay. And then we see that one of your subordinates, Joshua Godby, signed off, right?
That is correct.
And then we see that you signed off, right?
Indeed. Yes, I did.
And then we see that your boss signed off, right?
Mr. Mateer, yes.
And each of you signed off on an official government document because you felt at the time that it was in the best interest to do so. Isn't that right?
Based on what I have been told at the time, I believe that there was a colorable reason to intervene, yes.
Let's make sure we understand what you just said to us all. You said colorable reason?
Yes.
That's lawyer words, right?
Well, I don't know. I think everybody understands that.
You felt like, just you, let's just focus on you because I've asked some of these other folks.
Yes.
You felt like intervention was justified based on what you knew. Isn't that right?
Based on my conversations with the Attorney General, I believed that it was important for us to intervene in the Midi Foundation litigation and that he had colorable reasons to do so that I had no reason to question at the time.
Let me make sure I get it so we can be clear. If you didn't think it was justified, you wouldn't have done it, right?
If I had believed at this time that the office would be acting against the Midi Foundation, I would never have signed off on the intervention.
Mr. McCarty, I don't mean to be short with you, but I only have a short amount of time. And I know you like to speak in paragraphs, but could you just answer my question directly? You believed at the time it was justified. That's why you signed off, right?
No.
You believe that the information you had justified you signing off at that point in time, right?
I would not have made that decision on my own.
Okay. And we see that there's 1, 2, 3, 4 different people that made that decision, don't we?
There were 4 people who signed off on this memo.
How long did it take you to decide to sign off? Can you tell us?
It's hard for me to say how long it took for me to sign off. In other words, from the time I first learned of this until I ultimately signed off, I don't remember how long.
Let's look. Exhibit 305, Eric. You see on here that on June 6th at 4:52, you see that email that you were sent from Josh Godby?
Yes.
And do you see at the top where you had signed off by 5:26?
Well,
38 minutes.
The difference between receiving the document and making the decision to sign off, it doesn't mean that clearly there were conversations prior to receiving it.
Not only did you sign off on the Midi intervention, you also signed off on a memo authorizing an investigation of the Midi Foundation, didn't you?
That's correct.
Let's look at that, Eric. AG Exhibit 155. And I think it's important, sir, as we're pulling that up, to think about what you were doing then versus what you decided to do once you lawyered up, okay? That's why I'm looking at this stuff back in time.
I'm sorry, if that's a question, I have a response, but it may not be a question.
Okay. AG 155, this is where you, along with four other individuals, approved an investigation of the Midi Foundation. Isn't that right?
Yes, we approve this.
Okay. Now, let's focus on Nate Paul a little bit. Nate Paul was a major pain in the rear end, was he not? Take the document down so our witness is not distracted.
I'm sorry, I'm just trying to, I'm sorry, could you repeat your question quickly?
Yes, sir.
Yeah.
Nate Paul was a major pain in the rear end, wasn't he?
I don't know that I would describe him that way.
Did you ever meet him?
I have met him, yes.
Was he aggressive?
I think he was somewhat aggressive at the time.
Condescending sometimes?
I think that's a fair characterization.
Demanding?
Well, clearly demanding.
Yeah. We look at AG 219. He began to accuse the AG's office literally within 30 to 40 days of wrongdoing with regard to the Midi Foundation, didn't he?
Yes, I think that's a fair characterization.
He claimed that the AG's office had a conflict of interest, right?
Josh Godby, I believe.
He claimed that the AG's office wasn't doing its job, right?
In so many words.
He claimed that the AG's office was biased in favor of the Midi Foundation, right?
I don't recall, but he could have.
Let's look, Eric. Go to the fourth page. Pull it up, Eric. Fourth page, second paragraph from the top. Just so we're clear. This is within 35, 40 days of the intervention, and he is saying that Josh Godby is grossly negligent, and also that has a lack of openness and clear bias. Do you see that language? It's the last sentence, second paragraph.
Yes, I see that.
So this Nate Paul, who supposedly was given the keys to the AG's office, is accusing the AG's office of being biased, grossly negligent, right?
Yes, he is.
He also was raising this issue that there was somebody who was married to the receiver in the Midi Foundation who worked at the AG's office, right?
There was some sort of familiar relationship that he was upset about. I don't remember the specifics.
He was very upset that no one had ever told him that an individual who worked in the AG's office was married to the receiver in the case, right? Did I get that right?
That sounds familiar. I don't remember the details, but that sounds familiar.
Did anybody ever disclose that to him? That, you know what, just FYI, we're intervening, we're not taking sides, but we do have somebody who's working in our office for one of the parties in the case. Or married to somebody working for one of the parties in the case?
The receiver?
Yes, sir.
Well, that wouldn't have been one of the parties, but to your question about whether Nate Paul was informed of that relationship, I'm not aware that he was.
By the AG's office?
Yeah, I'm not aware that he was.
And he sent email after email after email to Josh Godby that you saw where he made allegation after allegation after allegation against the AG's office. Isn't that right?
He made allegations and he made demands and he, sort of demeaned our professionalism.
He was just aggressive and mean-spirited and accusing you guys of all kinds of things, wasn't he?
He was certainly aggressive. I don't know about mean-spirited, but he certainly made accusations too.
I mean, when somebody calls you grossly negligent and clearly biased, that's not very nice, is it?
Well, I'm a lawyer, so I'm used to that.
That happens to you a lot?
Well, not to me personally.
Okay. Let's look, just so we can close this loop. Eric, 165, please. He claimed, or his lawyer claimed, directly to you that the Office of the Attorney General had a a significant conflict of interest.
Can I see where you're looking?
Yeah, Eric, bring up the first and second paragraphs of Michael Wynn's letter or email to Darren McCarty in September 2020. He's accusing the AG's office of a conflict of interest, isn't he?
He is, yes. Yeah, I mean, yes. He's not accusing us, he's stating it, yes.
He's saying that the OAG's office employs an individual who's married to the receiver, right?
I see that.
Yeah. And he's raising all kinds of cane about that too, isn't he?
Well, he's certainly stating it, yes.
Did you know he ultimately threatened a lawsuit against the office for this very reason?
I remember that we received a communication, I believe, after I had reported to the FBI that was putting us on notice of claims against the office, as I recall.
You were telling us that you had conversations with Sheena Paul.
I did.
Sheena Paul was Nate Paul's sister.
And lawyer.
And also his lawyer.
That's correct.
But you also had conversations with the lawyers from Midi Foundation too, didn't you?
I did.
Yeah, so when you suggest, you weren't trying to suggest, I'm sure, that you were only talking to Nate Paul's lawyers. You were talking to the lawyers for the Midi Foundation too, weren't you?
I was.
Okay. You never were told by Ken Paxton, take a side, were you?
I was told by Ken Paxton to expedite the termination of the litigation if possible.
Listen to my question so we can all go home. You were never told by Ken Paxton, pick a side or pick Nate Paul's side, were you?
He never used those words with me.
And do you remember when the news broke or the news was about to break in the Texas Tribune, being in a meeting and you were getting a call from the Tribune the Tribune reporter, and they wanted you to make a comment about the Midi Foundation intervention?
I believe that I received an email.
Yeah, you received an email, and the allegation against you was that you had threatened the Midi Foundation?
I do recall that, yes.
They claim that you had told them there will be trouble if the Midi Foundation didn't settle, right?
Yes.
That's what they were going to say in the newspaper, right?
Yes.
And you knew that was absolutely false, didn't you?
I believe that to be false, yes.
I mean, the newspaper was getting ready to report that you, Darren McCarty, had been making threats against the Midi Foundation on behalf of Nate Paul, right?
No.
You had been making threats against the Midi Foundation if they didn't settle the case.
I believe that was, I believe that was what they intended to report, something of that nature.
Totally false.
I never threatened the Midi Foundation.
That was totally false, right?
That I made a threat?
Yeah.
Yeah, that was false.
But they were going to run with that if you didn't respond. They told you that, didn't they?
They did.
Now, let's make sure we're clear about this. If you didn't respond, the Texas Tribune was going to write a story where they claimed that you threatened the Midi Foundation with trouble if they did not settle the case. That's what they were going to report, weren't they?
Well, that's what they were telling me at the time, as I recall. I know there's an email that has the words in black and white, but it was something of that nature.
And they kept after you for you to comment, didn't they?
Well, I don't think they kept after me. I think they just sent it once.
Yeah, but that's upset you pretty good, didn't it?
Yes, it bothered me.
Yeah, you were animated about that, weren't you?
I was bothered without question.
And you wanted to make it clear that you never said that. Never said that, right?
That I never threatened the Midi Foundation.
Because you never did you?
I did not threaten the Midi Foundation.
Let me ask you finally, were you, let's look at AG 1020, the last bullet point. Just want to know, we've been trying to figure out who was all involved in this. Bring that up, that last bullet point. AG 1020, were you part of the group after y'all went to the FBI that were also planning on cooking up bar complaints against your boss, Ken Paxton? Were you part of that group?
I don't have any recollection of that.
That would be really wrong to be cooking things up because you felt like you had been somehow mistreated, right?
I never considered retaliating against Ken Paxton.
Yeah, think about that. Cooking something up, that sounds like we're just going to make this foolishness up so we can try to protect ourselves, right?
I was not participant in that conversation, have no idea of the context.
You would never.
I have no personal knowledge.
You would never even say that, would you? You would never say, let's cook up an FBI complaint, let's cook up a bar complaint, let's cook up a lot of foolishness because I think we're about to be fired. You'd never do that, would you? Would you do that?
Would I make a false complaint? No.
Okay. Your Honor, thank you very much. Pass the witness.
Redirect, Mr. DeGarrett.
Very briefly, Mr. Busby asked you, and I think the answer was that there was a colorable reason to intervene. A colorable reason to intervene. What is the real reason you approved the intervention?
Because Attorney General Paxton, who was the elected official, thought it was very important to intervene, and his reasons for that intervention were, one, that the Midi Foundation had past problems that the office had been involved with and sort of, colored the Midi Foundation's trustworthiness or something like that. And secondly, that the Midi Foundation was wasting money in a lawsuit that it shouldn't waste.
And that's what Ken Paxton told you, right?
That is correct.
But you found out that wasn't true, didn't you?
Yes, I found no evidence that the Midi Foundation was being improperly managed or run, and I saw no reason to believe that the Midi Foundation was somehow improvidently pursuing this lawsuit.
So in the end, do you believe Ken Paxton was telling you to act in the best interest of the Midi Foundation or the public interest in the Midi Foundation? Yes or no?
No.
What?
No, I do not.
Would you bring up Article 1, please? Specifically, Paxton caused employees of his office to intervene in a lawsuit brought by the Roy F. and Joanne Cole Midi Foundation against several corporate entities controlled by Nate Paul. Paxton harmed the Midi Foundation in an effort to benefit Paul. Is that true?
I believe that to be true, yes.
What?
I believe that to be true, yes.
No further questions.
Recross?
All right.
Tell us how the Midi Foundation was harmed.
I believe the Midi Foundation was harmed in these ways. I believe, number one, the Midi Foundation was threatened with an investigation by our office. I believe the Midi Foundation...
Wait a minute, let's take them one by one.
Sure.
They were threatened. How does that harm them? That didn't harm them. You're the one that signed off on the investigation, didn't you?
I object to Mr. Busby cutting off the witness when he was responding to the question.
I'd like to take them one by one, Your Honor.
I don't care whether he'd like to take it one by one. He was responding to the question.
I'll sustain. You can take it one by one, sir.
They were threatened with an investigation. We intervened in a lawsuit that complicated the Midi Foundation's litigation. I have no doubt incurred fees. It delayed the Midi Foundation's lawsuit by some amount of time, and potentially pressured them improperly related to their litigation with the Midi Foundation. And ultimately, and most importantly for me, I guess sort of the straw that broke the camel's back was that our office, under the color of, well, I shouldn't say the color of our office, under the authority of our office, we had used the criminal justice system to prejudice the Midi Foundation's interest in the lawsuit.
Wait a minute, sir. We're talking about Article 1. We're not talking about Kamek. We're not talking about a subpoena to a bank. I'm just trying to figure out in Article 1, okay, how did an intervention, you think they may have spent up more on fees, that's what you say, maybe, right?
Well, I believe that it undoubtedly did. They had to respond to our motions, and we were involved in the foundation lawsuit, and that was a complicating factor.
Maybe. You don't know that. Let's be clear, sir. We're in a court. You don't know that, do you?
Well, I think I do know that.
Okay. Well, tell me what their fees were with or without the intervention.
I didn't give a number, and I don't have a number.
Okay, so you can't provide any testimony, any evidence whatsoever of how the fees were more because of a 3-month intervention. Is that right?
I just said they were more. I didn't say how much more.
Yeah, they could have been less for all you know.
I can't agree with that.
You don't know is the point.
I think I do know.
And so, what was the other thing you said? They were threatened with an investigation?
They were threatened with an investigation.
They weren't threatened, sir. You signed off on a memo authorizing an investigation, remember?
I do.
I object to Mr. Busby arguing with the witness, Your Honor.
Overruled.
You personally signed off on a memo authorizing an investigation, didn't you?
Well,
objection,
yes.
Non-responsive.
Okay.
Sustained.
You personally.
Yes. Sorry.
What did you just say to the court?
I said yes. I signed off on a memo. I thought that was responsive to your question.
No, you started your answer with well, and you were going into another paragraph. I'm just asking you very specific questions. You personally signed off and authorized an investigation of the Midi Foundation, didn't you?
I did.
Along with your boss, correct?
Yes.
Along with your subordinate, correct?
Yes.
Along with his subordinate, correct?
I don't think so.
There was one other person below Josh Godby in the chain of command. She signed off as well. Mary Henderson, remember that name?
I do.
Okay. 4 different people from the AG's office signed off on a memo to investigate the Midi Foundation. Isn't that right?
That's correct.
Okay. And we know that the problems with the Midi Foundation weren't just back in Greg Abbott's tenure at the office. They were more recent, weren't they?
I believe there was something in 2019.
What was that in 2019?
I don't
Do you remember?
recall. I don't remember, no.
Do you not remember? The CEO, what was the name? The CEO having to be replaced because of misconduct?
I believe this is outside the scope of the redirect, Your Honor, and I object.
It's actually not, Your Honor. We talked right about this in the cross.
Overruled.
Thank you. Do you not remember that?
I remember that there was something in 2019 concerning a member of the board or the foundation, but I don't remember
Eric,
specifics.
Bring up AG 33. Go to the second page real fast.
Your Honor, objection again. This is clearly outside the scope of what my redirect was. I covered 2 very brief areas, nothing about any 2019 investigation.
Again, Your Honor, he came back up here and tried to get despite the documents in the case, elicited from this witness something that's 180 degrees different than the documents. And so I'm entitled to show that his testimony doesn't match the historical record. And that's what I'm trying to do, hopefully in 5 minutes.
Overruled.
All right, Eric, bring up the paragraph 1, financial status of Midi Foundation. What we see here is the justification after Greg Abbott had already had intervention with the AG's office. This is more recent information. Do you see that?
This is the memo that Nate Paul's organization sent to us. Is that what this is?
That's what it is. That's what you reviewed before you signed off on the intervention.
I'm not trying to be argumentative at all. I'm just trying to understand what document I'm looking at.
This is something that you would have been, everybody in this courtroom, you would have seen this document before anybody. You understand that, right? You saw this document back in June of 2020, right?
That sounds right, yes.
Okay. And it lays out in detail all of the financial issues with regard to the Midi Foundation, including its negative cash flow of $440,000, right?
I see what it says here.
It talks about forms not being filed in a timely fashion. Do you see that?
I see that it says that.
It talks about the assets of the Midi Foundation is about $15 million. Do you see that at the bottom bullet point?
I see that it says that.
And one of the concerns could have been from the AG's office, why is a foundation, in the grand scheme of things, not a very large foundation, why is it engaged and investing into land deals? That could have been one of the questions raised, right?
It wasn't. It was not one of the questions raised.
We've heard the testimony. And let's go to the next page. And it continues with the legal fees that have been incurred and questions about how much the receiver's being paid and how much the lawyers are being paid and what the fee arrangements are. Remember all that?
I certainly remember that Nate Paul's organization made these statements and these allegations, yes.
And so if the jurors want to see, despite your testimony, despite what you say now, if they want to see in the documents the reason and justification for the intervention, they need only look right here. Isn't that right?
Utterly incorrect.
Mm-hmm. Did you make it a practice as a lawyer or at the AG's office to sign a document that says one thing, but actually you had hidden reasons? Because that's what you're saying. I mean, let's be clear what you're saying. You're saying, hey, ladies and gentlemen, I signed something to authorize an intervention, but I really didn't mean it. I had other reasons for it. That's what you're telling us all, isn't it?
Absolutely not.
I pass the witness, Your Honor.
No further questions. We have a housekeeping matter that we'd like to approach about.
Okay. Can we excuse the witness?
Yes.
You may be excused. Both parties come up. You said you had a housekeeping matter?
So we have been listening to testimony from Darren McCarty, who was the former Deputy Attorney General for civil litigation in Paxton's office. He is also one of the 8 whistleblowers who reported their boss to the FBI, and we heard him talking about his decision to do that and what led him to do that, and it is largely based on what happened with the Midi Foundation. The Midi Foundation was involved in a lawsuit with Nate Paul regarding the apparent purchase of some properties with Nate Paul's companies, and the Attorney General's office intervened in that lawsuit. You're hearing McCarty say really on Nate Paul's behalf to benefit Nate Paul rather than to benefit the Midi Foundation. And the House managers say that this really runs counter to what the Attorney General's office is supposed to do when it comes to intervening in lawsuits with charitable organizations. That in fact, that Ken Paxton failed to act as a public protector of charitable organizations, which is what is required by the law, and that he had his office to intervene in that lawsuit to the benefit of Nate Paul. And so one of the things that I thought was particularly interesting about what we saw here, we're going to pause to listen to Dan Patrick speak for a moment. When he starts talking, I'm going to stop talking, just so you know, so we can hear what exactly he's saying. But you can see there, they're trying to take care of a housekeeping matter between the prosecution and the defense. But what we have in Article 1, and one of the things that I thought was interesting, is that we saw Dick DeGuerin sort of take a tactic that we've seen Tony Buzbee and his team do, which is where he actually pulled up the article. And Buzbee did this first. He's done this with 2 other witnesses, and he started to do it with McCarty, where he pulled up Article 1 on the screen for McCarty to look at and had him, he was actually reading what is alleged and whether or not it was true. And Buzbee sort of abandoned this tactic with McCarty because it was not going in the direction that it had gone with Ryan Vassar and Brandon Kamek, the 2 younger attorneys who have testified. They, in this questioning, were saying, well, no, that's not exactly what happened. Well, no, that's not what Paxton did. And you had McCarty sort of taking a much different spin on this, saying, well, yes, that is what happened. And so you saw Buzbee abandon that practice before he really got through with going through the line by line of Article 1. And then we saw Dick DeGuerin sort of steal that tactic in his redirect after Buzbee's cross-examination. He had Article 1 pulled back on the screen and asked him about it. And you had him say, yes, these things did in fact happen. And so that's something that the jurors will certainly have to reconcile. We saw Buzbee come back in his questioning and ask, well, how was the Midi Foundation harmed in this instead of the AG's office? We're seeing Dan Paxton sort of rounding up the senators and pointing at them, telling them to round up and to get on out. We're good to go. We're going to make some notes there. And McCarty answered Buzbee saying, well, they had to, they had us intervening, which complicated things, as well as having to spend more money to respond to our request. And now you're seeing Lieutenant Governor Dan Patrick stand up and walk away, indicating that they are done for the day. He doesn't have any final words to say after an eventful day in the Senate chamber in this trial. We heard from 4 witnesses today. I want to note that the prosecution had a little bit more than 9 hours going into the trial today, but there are the witnesses that we heard from today alone. Brandon Kamek, who was hired by Paxton to be a special prosecutor to look into Nate Paul's claims. And his hiring is the subject of Article 5, that Ken Paxton just went against all the policies and procedures and laws that dictate how the Attorney General's office hires prosecutors in Kamek's hiring. We then heard from Joe Brown, who is an attorney and the former district attorney for Grayson County in Texas. He was also a U.S. attorney, and he was also up for that position that Brandon Kamek eventually got. And he talked about the red flags that were raised for him when he heard Paxton saying what exactly it was that he wanted him to investigate. We heard from Kendall Garrison, the president and CEO of Amplify Credit Union, which had plans to put 3 of Nate Paul's properties into foreclosure, to foreclose on those 3 properties, saying that Nate Paul and his company owed them $11.5 million and that they were not making payments in 2020. And so the plan was to foreclose those properties, but they stopped and halted their plans to foreclose those properties after they received this opinion from the Attorney General's office that said foreclosure sales could not happen during the COVID pandemic pursuant to an order that Governor Greg Abbott issued. That opinion in and of itself is subject to some of the articles of impeachment because it is said that Ken Paxton had his staff, and certainly we heard the top aides in the AG's office say they wrote that opinion one way, a way that would allow those foreclosure sales, and you had Paxton come back and tell them, no, I want you to reverse it. I do not want these sales to happen. And they made that happen. They're calling it the midnight opinion because this was all happening very quickly and over the weekend. In fact, Garrison testifying that he got that opinion on a Sunday, which was most unusual. And we've heard the former, prosecutors in Paxton's office say it's unusual because it normally takes them weeks, if not months, to prepare opinions. And this one had to be done over the weekend. And then finally hearing from Darren McCarty, again, former deputy AG for civil litigation for Paxton and one of the whistleblowers. So the time clock is certainly running out on the 24 hours that the prosecution has to present its case. We started this morning at 10 a.m. At that time, they had 9 hours left. We've now gone, until a little bit after 7. Obviously, the defense taking up some of that time, a lunch break and breaks taking up some of that time. But will be interesting to see who the prosecution calls tomorrow as they're preparing to wrap up their case. Dan Patrick saying that this case is expected to go to, or rather, let me take a step back. Dan Patrick saying earlier this week that both sides are expected to run out of their time, run out of their 24 hours for presenting witnesses and cross-examining witnesses by Thursday, and the case could then shortly thereafter go to the jury. We know that after those 24 hours expire, each side gets 1 hour for rebuttal evidence, and then each side gets 1 hour for closing arguments. So certainly will be interesting to see A, how much time is left, and B, who is called to the witness stand on tomorrow. The trial is going to resume at 9 a.m. tomorrow morning. And of course, we hope that you will join Tony Plohetski and myself right here on KVUE Plus as we continue to bring you gavel to gavel coverage of the impeachment trial of suspended Texas Attorney General Ken Paxton, along with analysis and guests. We'll see you back here tomorrow morning at 9 a.m. Thanks so much for watching tonight.